You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are excited to have this session because the guest who is going to join us is going to join us for the very first time. So, friends, stay tuned and stay connected with us. Also, watch this webinar till the end and don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. Also, we are available on LinkedIn, Facebook, X, and on Instagram too. So do follow us and like, share, and subscribe to our channel. And before moving ahead, let me go through with this very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. Once again, friends, welcome back everyone to Immigration Talk Show, and it's me, your host, Sam. Talking about today's topic is again a very interesting one and a very important one. How will marriage based green cards be different in 2025? So, getting a green card through marriage sounds easy, right? Just fall in love, say, yes, I do, snap a few cute photos, and sign few forms. That's all. But you know what? In 2025, it's not just about romance. It's about paperwork, updated rules, and most importantly, proving that your marriage is real, loving, and yes, a real card, green card worthiness. So if you are also looking for marriage based green cards, then this session is for you. And the best thing about this session is the guest who is going to join us is highly experienced and one of the finest immigration attorney. Joining me in a bit, none other than immigration attorney Mark Santamaria, who is a dedicated immigration lawyer, AI consultant, and also founder of Santa Maria Law Firm that is based in San Francisco. He has over 12 years of experience and helped hundreds of clients with marriage based green cards, work visas, asylum, and even more. So I think without any further ado, let me welcome him. Hi, Mark. So happy to have you and really our honor to have a show with you. Thank you so much for joining us.
Oh, Sam, it's my absolute pleasure. Thank you so much for having me. I'm happy to be here.
Same here. And our viewers are also excited to have a show with you as you are our new face on Immigration Talk Show. So it's really lovely to have you. And I hope that you're doing great today and really excited for the session as we all are.
Yes, I'm looking forward to it. And day after Father's Day, it's a special day, and
Yeah.
and I'm just happy to be here that I can share my experience with you all.
Absolutely, that's lovely. And I think, Mark, before diving into the questions, as I have so many questions, and some of our viewers have already joined us. So, hi, Ricky, and thank you so much for your question. Stay connected, soon we are going to take it. So, I think, Mark, as you have joined us for the very first time, if you can let us know something about you, like what inspired you to become an immigration attorney, any incident or anything that if you want our viewers to know about you, please go ahead.
I appreciate the question. And when I was postgrad after my undergrad degree,
Mhm.
I was considering immigration, and then I studied abroad in the Philippines, which is where my parents are from. And I had an interview with a U.S. consulate officer. And so what I remember seeing that day will forever be with me because when I went to the U.S. consulate
Mhm.
to interview the officer, there was a line for American citizens, which I'm very blessed and acknowledge. I'm very spoiled to have this position. by birth, and then I went through that line very quickly. But then I saw in this 90 to 95 degree Fahrenheit day, people lining up for the consulate, and some under tents. And in the Philippines, there's about 7,000 plus islands, and so it's not like they could just take the neighborhood bus there. So so they had to camp out there in that heat, and I felt so guilty, and I feel like that was one of those clear moments about 20 years ago that I can still clearly see and feel the heat. I could feel the heat of going to the office, and then the cool air conditioner inside the consulate. They had to brave the heat. I mean, yeah, many of them are used to the heat, but then still, it's not pleasant to wait that long. And so that's one. There are so many other reinforcing incidents in my life that really inspired me to serve immigrants, and emphasis on serve. I feel like this is a service business, and being able to serve people is what my faith is based on, and that's one of the reasons why I wanted to do work that serves people. And yeah, we have an organization, we have a founding attorney, we have legal assistants and whatever. But then at the end of the day, we're serving other people, and I like that. I didn't want to get into corporate law because it's just an entity. You know, here we're helping actual people that some of us become friends with, and that's, it's always a treat to see some we help from the beginning become citizens, and we become lifelong friends after that. So yeah, that's why. Yeah.
Wow, that's wonderful, and that's really motivating. It feels so good, Mark, that there are such a good people, who really want others also to grow and to have a pretty life. I mean, nobody wants to, stay in a long queue, that too in such a summer heat. They all want to have a good life, a comfortable life under AC, and you are really inspiring people and helping them. So it feels wonderful. And friends, if you also want to have your love story in terms of marriage based green cards, stress free and without any problem, then I'll suggest that go ahead and reach out to attorney Mark Santa Mario. You just have to visit the link that will be visible on the screen, and you'll get the contact details of her. Go ahead, reach out to her and ask any question or any query that you are having in your mind. And with that, also don't forget to subscribe to our channel at Immigration Talk Show, our handle. Okay, let me go ahead with my very first question, Mark, that I want to bring up in front of you. That USCIS has updated, some green card forms this year. So how can couples make sure that they are using the right ones when applying in 2025?
That's a very interesting question, because first we have to know the stakes involved. So if you submit a form that's outdated, it can be flat out denied. Not even an RFE will be sent. It's just a denial, and so it's a reasonable request, in my opinion, to just to use the latest one. But just note that for the viewers out there, USCIS has updated its forms, specifically the 485 and the I-130, this past spring. And so you have to check carefully. And it says there on the bottom of the form where when it's expired or not. And so you can also check on uscis.gov for the latest form, because sometimes what people do is they just go online and then they happen to find the form. But it's better to go to the source, uscis.gov, and then just get the updated form there. Then be very mindful of any any announcements that they have about the changing of the expiration date or the changing form of validity, because it can happen anytime. And so, like for example, this past updates to these forms, they kind of happened all of a sudden. And so people have to be aware that it can happen. And if I were you, I would just carefully look at the dates and have a goal in terms of, okay, it's going to take a few months for me to submit this case, and so right before I send it, I'm going to double check if the form is still updated and still accurate and not expired. And so before you all send it out, please double check uscis.gov and see if it's still the updated form, because it does take a while to fill out the forms. And then right before you send it, you can double check it. And so, yes, so check the USCIS website regularly. Review the instructions also, because with the forms, they not only have the date, but they also have instructions on how to fill out the forms. And it might be in relation to some sort of date requirement. So be aware of that. And obviously consult with an immigration attorney, double check with an attorney if it's the latest form.
All right, that's great. Thank you so much, Mark, for explaining things. And I'm sure our viewers are, keeping a note of all these very important pointers. And it's a very important, and most of the time our viewers overlook these are very important pointers. So I hope, friends, that you are getting benefited from this session, and participate as much as possible. Ask any question. We are here for another hour. So I think that will be great. And let me go ahead with another question, Mark, that is for you. That is USCIS taking longer or faster to process marriage green cards this year?
Yeah, and the short answer is yes. And the feeling is real too. So for example, when I'm in USCIS offices, the wait time is longer, and so I also heard from other colleagues that some USCIS officers left their jobs, and so naturally, the processing time will be extended. And so knowing this, it's very important to consider that in terms of expectations, because if you are expecting to get a result of your application because, oh, you have a friend that told you, oh, it took me 5 months, I got the response, I got my green card in 5 months. That's your friend who probably did it last year. So just be aware that, okay, we're in different times now. We acknowledge that, but we strategize. Okay, so knowing that it's going to take longer than usual, okay, how can we get this application in faster, as fastly, but as detail-oriented as possible? So you really have to balance it out. And that's why obviously working with an attorney may help. But yes, we acknowledge that there are delays, but we try to pay attention to detail when filling out these forms and send it up. And then you control what you can control. And sometimes we say, control the controllables. So you can control how fast you put together your application. You can't control how long it's going to take. And that's fine. Although other visas have premium processing, ironically, marriage does not. Fine. After a while, you can get your work permit. You can get your travel permit. And so you look at that as a halfway goal, and then you have your green card interview later. So yes, it takes longer, but strategize. And if you do that with an attorney, it can help you put together your case faster.
That's right. And that's wonderfully explained. So thank you so much, Mark, for your detailed explanation and putting things in a very simple form. So I think let me go ahead with my next question. And we have been hearing, Mark, that the rules for the medical exam have been changed. So if you can explain what's different and what it means for people who are applying for a marriage-based green card this year.
Right. So this is interesting. So it is actually kind of a reasonable request too, but basically it's saying that, in a nutshell, the form has to be valid, but now in more detail. so USCIS has changed their validity period for the form I-693, which is for green card applicants. They have to submit this form, for those of you that don't know, and signed by a civil surgeon. And it has to be after November 1st, 2023. Okay, so the form is now only valid while the associated application is pending. So in other words, yeah, if your application is withdrawn or denied, the exam is no longer valid for future applications, whereas it would have been in the past. But
Okay.
that's makes sense to me in terms of, okay, at least it could be worse, right? So um, just because the people who withdraw their cases are very, very few. And so just make sure you are aware of the date of the form and the medical exam to match the requirements of the validity period. That's the key. But in terms of, okay, if you withdraw your case, yes, you will have to submit a new form, 693, which is fine. You just have to do what you have to do, and and just be aware of it. This is a new policy. It was implemented June 11th, if I remember correctly, 2025. And so this is something to be up to date with. And so talk with your attorney and check if you have the correct form, updated form, and so that you're all on the same page of its of validity.
That's right. Absolutely. And I think that's explained wonderfully. So let me go ahead with my next question. And thank you so much, Mark, for taking up that one. Now, I think before diving into how the conditional green cards being handled, if you can let us know what is the meaning of conditional green card, then that will be great.
Sure. So let's think about what it's called, the conditional green card. So you have your green card, but it's conditioned. So and so because the background is there's a lot of marriage fraud, especially from Asian countries, and me being the child of Filipino immigrants, Indians, also Chinese. So there's a lot of fraud, especially from those countries. And so the officers are trained to look out for those kinds of issues.
Okay.
And so, and another check is the conditional green card. And these are issued to applicants whose marriage to a US citizen was less than 2 years at the time of approval. So kind of like for newlyweds, you know. So, but after that, they can request to remove the conditions and have their 10-year green card. So there's a form called Form I-751, and so the applicants have to file that within 90 days before the condition expires. So now to your question about, okay, so how has it changed, if at all, in 2025? So for these, at least, fortunately, it doesn't seem like there has been a big change in the processing times. But you know, we're in June 2025, and anything can happen with processing times. But in
That's
terms
right.
of our experience, yeah, unfortunately. But in terms of our experience, we're okay with processing times. Just it's more important that people consider that yes, USCIS continues to scrutinize these kinds of cases very closely, and so when you do submit your 751 application, in other words, the waiver of conditions application, you should, like you did the first time, work as hard or even more on putting together evidence of your quote unquote bona fide marriage, which is a fancy lawyer way of saying just a real
Yeah.
marriage. And so submit the same kinds of evidence, tax returns, photos together, social media together, receipts, and finances are key. So things like that are very important. And I was just in some green card interviews based on marriage recently, and the number one thing that the officers asked about were financial accounts together. So please note that if and when you have your interview, you will likely be asked about those kinds of similar kind of joint accounts. So, for example, tax returns and savings accounts, checking accounts, credit cards, um, lease together. They really want to see those things. The pictures are nice, the cards are nice, but any kind of joint accounts really does seem to persuade them. So if and you think that people are aware of that, but then we get even our current clients to this day still think like, oh, okay, it's okay if I file separately.
Yeah.
It not really. You may want to consider filing jointly. You know, what kind of red flags does this raise when you have your 751 pending? Like you still don't have your um, taxes jointly, filed. So maybe you got away with it the first time at your adjustment of status application, but then out of a year or two later, you still haven't filed taxes jointly. So think
Yeah.
about that. What would any reasonable person think if in a USCIS officer's position if he still haven't filed jointly? So think
Yeah.
about those things as you put together your 751 form.
All right. That's great. Thank you so much, Mark, for putting up, these very great insights. And I'm sure our viewers are keeping a note of it and, explaining things in a very simple manner. It's really a great thing, and you're doing a great job. So I think we are really enjoying this session and so much to learn from you. Your expertise are really great. So friends, stay tuned and stay connected. We are just going for a short, quick break. So don't go anywhere. We'll be joining in a minute. Till then, if you have any question till now, because we have covered half part of our today's topic, go ahead, post them on the comment section, and don't go anywhere. Keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and welcome back to Immigration Talk Show. It's me, your host, Sam, and today we are having a great discussion with none other than immigration attorney Mark Santa Maria on the topic how will marriage based green cards be different in 2025? So, thank you, Mark, for being here, and I hope you're enjoying this session. And with your permission, can we move ahead with our next questions?
Please.
Okay, that's great. And let me go ahead with this very important question. And that is it true, Mark, that when I-130 and I-485 are filed together, then waiting time depends on the slower of the two? Also, how should couples strategize their filing to minimize the delays?
Uh, Not necessarily. So, um, yeah, the main thing you can do is to check processing time is to check a USCIS.gov's processing time tab, and then you have to because it depends on the region you're in because they have different offices, and the offices have different processing times. So when you click the form that you're entering, and when you do that, it'll show you a processing time. It's an approximate processing time. So for example, like I'm based in San Francisco, and yeah, it's taken about a year. It's going to be longer, that's for sure. But somebody in uh, central Kansas might be a bit faster, than ours because there's just more applications in our area. So that's something you can do. Just check online to see the processing time there. But it shouldn't, and that should give you a good approximate time. And they sometimes they say it's going to take X amount of months or whatever year, but then the reality is it's about a little bit faster than it actually is, which is a good thing. And generally, that's the way it goes. They kind of hedge their bets. So if it says a year and 2 months, maybe you'll get your news in a year. So that's usually what happens, and that's a good thing. So hopefully that happens for you too.
Absolutely. We hope for everybody that happens. And I think let me go ahead with my next question mark. And this is that has the scrutiny increased for international marriages or long distance relationships? Now, Mark, here's a one case study that I would like to, make you understand so that it will be easier for our viewers to get the idea with the example. So what happened that there was a girl named Lisa who was actually a US citizen, and she got married to Raj who was an Indian citizen, and they had like a long distance dating, and it has been a year for them. And at his 2025 green card interview, what happened, the officers, they questioned every detail from daily routines to their texting habits and everything. And despite photos and records, his visa still got denied under 221G for insufficient evidences, and it took like months and more documents to finally get approval. So after proving so many things and giving so many documents, they got the approval. As we compare to other case like that was having a short distance relationship, the couples, those who were living together, those living together in the US often faced few hurdles, but they shared some lease, joint bills, and everyday photos, that made it easier for them to prove a real relationship. So is it true that distance matters if we talk about long distance, short distance in the eyes of USCIS? How does the process goes?
The short answer is yes, but there are ways to help your case. So,
Okay.
so the the officers will know the facts. The
Mhm.
officer will ask you, why are you not living together? Why are you in this long distance relationship? And you have to answer truthfully. But before that, what can you do to strengthen your case? Because ultimately, they're going to ask you those kinds of questions like, okay, if you really, really love this person and you got into this marriage for real, why are you on opposite sides of the world?
Yeah.
That's what they're thinking. But how do we show them, okay, it's real? All right. So we've had several clients with this kind of situation, and every case is a bit different. But usually, what we say to such clients is, okay, it's kind of funny, but can you visit your spouse in your country, in his or her country, go on a vacation together, take some pictures,
Yeah.
enjoy each other's time as presents. And secondly, and probably more importantly, is okay, as I mentioned earlier about the finances, we understand that it's hard to create joint accounts,
Mhm.
especially if you're not in the same country physically.
Yeah.
So you have to find ways to get around that. Okay, how about a will and a trust to show that okay, you're fully committed to each other, you're carefully family and financial planning with each other,
Yeah.
and talk with a CFA or somebody who can come up with some ideas of joint accounts that you can create while one spouse is abroad. And so it shows to the officers like, okay, wow, okay, they're really trying to make this work. And so, yes, it's a hurdle, but then it's not impossible. Like we've had clients where it worked out for them.
Oh.
And actually there were minimal times when they were actually physically together, but
Okay.
we figured it out. So okay, maybe they only saw each other once, but that one time they took a lot of pictures. They bought each other gifts, and also during that time, they
Mhm.
had the spouse sign certain documents so that they can create an account together, or so use that time wisely when you are on that one trip to see your loved one, your spouse, and see what you can do and get done while you're physically together. So yes, it does draw a little more scrutiny, but then it's not impossible. There are ways to show that you are in a real relationship.
Wow, I think these tips will not only just get their marriage green cards approved, but also it will make their relationship stronger and better. Because these are the proofs, right? They are going to show some pictures, flight tickets, and together. So, okay,
Yeah,
that's
and if I may add to that,
sure.
um, I've had some clients, to your point, like it actually, this whole process can actually, ironically, bring people together.
Yeah.
I did this with my wife. She
Oh,
came here as a F1 student, yeah,
oh wow.
and she's right there with our son, uh, and so she was an F1 student, um, and we had to put together this case, and I was already an immigration lawyer at the time,
Hmm.
but it was fun to see pictures, and she even made some photo albums. She's the one who did it.
Oh,
But
wow.
she put together some photo albums that we still have to this day. We didn't throw them away, and so we printed them out, and they're still here at home. And if we didn't have the interview, we wouldn't have that photo album. We
Oh,
have actually four of them, small
wow.
four small photo albums of printed out pictures in a book binder, and we kept those, and we'll always remember that was actually the time we had our interview. And so actually did bring us closer in a way. So it's all perspective, right? So yes, it's a stressful time, but we acknowledge that. Okay, how can we make the best out of it,
Yeah.
right? And so and so if you all can do that, then okay, this might make it less stressful, even just a little bit, right? Yeah.
That's right. And that's beautiful, Mark. It feels so good that, when a real married, happy couples we see and we feel so happy, okay, that marriage can be so pretty, even in the USA in 2025. So I think that's pretty and that's wonderful. And I think, friends, you can also go ahead and ask more questions. So I think, Mark, let's take up some of the questions from our viewers because I don't want to wait longer. So Ricky is here. Hi, Ricky, and I hope you have subscribed to our channel. If you haven't, then please go ahead and subscribe to Immigration Talk Show right now. Okay, so Ricky has a very important question, Mark. That can premium processing increase chances of RFE for NIW I-140 petition approval? Also, in what cases should one seek G28 representation required?
Okay, so I'm biased as an attorney, and so for those of you that don't know Ricky's question about what a G28 is, so a G28 is a form that attorneys fill out for clients in USCIS so that attorneys can represent applicants. So that's the G28. In what cases should one seek representation? I'm biased, of course, in all of them. I would say yes, there should be an attorney. But some people, and to that point, some people. Just last week, I was in a green card interview applicant's case. It was actually for an NIW, and I see Ricky, you have similar NIW questions, and so he was on it. He was focused. He was well prepared. One of the most prepared people I've ever met, and he had a binder full of tabs of all his case-related documents, very organized. And he put together his IDs in one folder with the tab. He put together his checklist, his NIW-related evidence, all in all in separate tabs, and he knew where to go. He practiced actually pulling them out for the interview, and so yeah, we told him to do this. We tell all our clients to do it, but uh, to make it look that nice and to be as organized, he's one of the top performers for our clients, and so he did it, and he had such a good interview. He answered each question very articulately, and the officer was very reasonable and friendly.
Mhm.
And he would have, let's say he got a very confrontational one, he would have been able to fully respond as well because We prepared him for the worst. So it was a very smooth interview, but we a week and a half prior to that started doing mock interviews with him, um, two or three, and we gave him very tough questions. Okay, why does your work serve the national interest? Give us details.
Yeah.
And at the first time, he said, "Yeah, it helps because I something like I help in my field," but it's very general. And so I said to him, "Okay, that's nice, but what can we do to make it more specific? And how can
Mhm.
you answer the question more directly?"
Yeah.
Okay, and then we practiced again, and then he answered that again. And then at the interview, he answered it just as we practiced. It was beautiful to see. And so that's best case scenario. And he said himself, like, yeah, yeah, I could have done this, but just knowing that you were there was very comforting because he was nervous. He said, yeah, I was nervous the whole time,
Mhm.
but just you physically being there, like it actually helped me. And so those are some things to consider because, like the boxer said, Mike Tyson, uh, we all have a plan until the first punch. I'm rephrasing it, but you know
Mhm.
what I mean. We all have a plan until you enter the ring, right? So you want to be there with as many resources as possible, right? So that's one thing. And then to your other question about premium processing, does it increase the chances of RFEs? And no, RFEs are just um, almost uh, something you should assume you'll get. So it's don't feel bad, you know. So um, you should plan ahead actually for that, um, because as I mentioned, I'm an immigration attorney and we got an RFE. So it happens and it's okay. It's just part of the process. We tell clients that all the time.
Yeah.
Yeah, I got an RFE too, and I'm an immigration attorney, and and so yeah, you'll probably get an RFE. Fine, you just deal with it.
That's right. And I think that's really honest and of you, Mark, that you're putting up these pointers because most of the time we try to sugarcoat things, but you are bringing up these things and making them feel that it's pretty normal. It's not such a big blunder that they feel as if what a big mistake had happened. So I think a great thing and great points you have been explaining. So friends, as Mark has said that don't be so burdened, and if you're preparing for the best then also be ready for the worst too, and that's how you are going to be, I would say, like keep going and stay motivated. Nothing is going to happen, and sooner or later, I think, of course, if you are passionate and dedicated, then you'll get your dream come true. So I think, Mark, you're explaining things wonderfully, and so many viewers have joined us. So I think this session is really going great way, and a great engagement we have got. So with that, friends, stay connected, stay tuned, and we'll be coming back just after a short and a quick break. So see you just in a minute. Until then, keep watching everybody Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
All right, so hi everyone, and welcome back to Immigration Talk Show. It's me, Sam, your host, and I have a very special guest joining me today, none other than immigration attorney Mark Santamaria. And he has 12 years of experience. And till now, friends, we have gone through so many questions. In case if you want to get in directly connected with this attorney, then you can directly visit this link that is on the screen, and you'll get the contact details of Mark, and surely he's going to help you out. Okay, let me go ahead with Bhavik Patel. So, hi Bhavik, and thank you so much for your question. I hope you have subscribed to our channel. If you haven't, then do it right now. Okay, Bhavik is asking, my spouse and I are planning to travel internationally while our green card application is pending. So, what are the specific requirements for obtaining advance parole, and how can we ensure that our travel plans does not create any problem with our application?
Okay. Yeah, good question, and especially in light of what's going on um, nationally with travel issues. So if I were you, yes, I would be a little concerned too. So that's a very legitimate question. So yes, and by the way, I just came back from Asia about 2, 3 weeks ago, and you can feel it. You can feel it at the airport at SFO. You could feel the anxiety. Yes, I went through the citizen line, but then I intentionally wanted to see the green card line too, and for foreigners, and so I was really observing and
Mhm.
how is it different traveling internationally versus last year, because we travel internationally sometimes, and we
Yeah.
traveled last year and we traveled this year. So
Mhm.
what I saw in the and felt was anxiety. So Mavik, I fully respect your question. So yes, so there is a form I-131 for advanced parole,
Mhm.
and when you do fill that out, you have to give reason and for your travels, because let's think about this. The background is you're applying for your green card, which is an immigrant visa. So and so you want to stay here permanently, and so if you keep traveling outside, which some of our clients have issues with because they have businesses, they have families, etc. And so they actually really have to, or think they have to, stay abroad for a long period of time. But obviously, that conflicts with the intent of a immigrant visa. So intent is key in immigration, and so when you have these conflicting intents, that will raise a red flag. Now, so when you fill out the form, you with that in the background, you say, okay, I'm only going to be gone for a month, and I'm going to XYZ country, let's say India, for example, to visit family,
Mhm.
and so one thing that usually is worth noting is it's a family event. So let's say that your uncle is getting married, your cousin's gonna have a marriage ceremony, and or unfortunately someone has passed away in your family, and so you need to be there for them. And so when you actually back it up with evidence, that does help get your I-131 approved advance parole. And so with everything, as a lawyer, you back it up with evidence. And so what we usually do is we provide supporting evidence, such as even a wedding invitation.
Mhm.
So things like that that show that it's a real event and you really want to go. It's for someone you love, and yeah, we're going together. So then that shows that yeah, you're traveling together, and since you're abroad, take pictures out there. Um, so yeah, so kill two birds with one stone is my point. So fill out the I-131, and then
Mhm.
while you're abroad, take pictures of you're traveling, so that when you apply for your 751, the removal of conditions, you'll have extra evidence to submit at that time. So you can use that kind of evidence for multiple purposes. So think about those things as you apply for advanced parole.
Absolutely, and that's very well explained and very well put up, Mark. And talking about pictures also, I think nowadays it's becoming trend. Wherever you are going, you always have some snaps or just sharing Instagram stories or putting a WhatsApp status. So I think it's becoming trend, right? They are making vlogs also, and pre-wedding shoots are also there. So I think this is really going to be a fun activity and also necessary one as well. So, really great, and these points are wonderfully explained. So, Sakshi is here, and hi, Sakshi. Thank you so much for being here and participating. Okay, Sakshi is asking that I have a prior immigration violation on my record. How will this affect my eligibility for a marriage based green card? Anything specific should be done in such situation? Yes, Mark.
Okay. So I have to start off with the lawyer response of it depends. But here's what I can say in terms of this kind of question. It's not the end of the world. Usually isn't. We've had many clients with such violations in the past, and sometimes what happens is they worked under the table or have a speeding ticket. Fine. So, but first, this is where you kind of should have an attorney. I know you want to save money. Some people want to save money, but at this point, if you do have a violation, you should definitely consider at least talking with an attorney, because it really does depend. I wish I could give you a straight up answer, but it depends if it's a crime based on domestic violence. It depends if it's a crime based on marijuana. If it depends if it's just a simple crime of whatever it is. It really depends, because worst case scenario, it's a crime that makes you inadmissible. If it's something like that, then yes, you have to highly consider talking with an attorney, because it could bar you from applying for any immigration benefit. However, if it's something maybe working under the table and then you marry a citizen, that should be waived. So it really depends. Talk with an attorney, and
Mhm.
before you submit anything, make sure you did your research. Okay, because the USCIS will have everything. You will be surprised about how much they know about you, and for them, it's a click of a button. And so, don't assume that you can hide anything. And so, I would rather you fill out the forms and just volunteer that information on the back of the forms, because on the 485, for example, it asks, have you ever committed a crime or been charged with a crime? So they make it very broad, so there's no way around having any negative interaction with the authorities. So you just say yes, and then say what happened, and then explain that on the form and at your interview. And if it's a violation that can be waived, you should be fine. So, but again, please consider talking with an attorney.
Absolutely. And Sakshi, I think you should go ahead with expert guidance and the guest who is sitting in front of me, who could be better than that. So go ahead, directly visit this link, and you'll get in touch with attorney Mark Santa Maria. I can understand that these violation cases might sound a little confidential. So go ahead, reach out to her. You'll get the email ID of, reach out to him, sorry. And you can also get the email ID of him as well. And there you can share your details, your documents, or anything, whatever queries you're having. And he would love to help you out. Okay, so I think thank you, Sakshi, for being here. And yeah, let me go ahead with Ganesh comment. So Ganesh is asking that I have a non-traditional marital history, significant age gap, and cultural differences. So we are concerned that USCIS may scrutinize our application more closely due to our unusual circumstances. So the question is that what are the key factors that USCIS will consider when evaluating our application? Are there any specific forms or statements that we need to submit to address our non-traditional marital history? Yes, Mark.
Very interesting um, question. And so, yeah, again, we've been doing these kinds of cases for more than a decade, or about a decade, and so you think about all the kinds of cases we've had over the years, and so
Yeah.
love. I'm based in San Francisco. Love is in different forms. Okay, so so that is a factor to consider. Yes, there are some factors that if there's a age gap is a very important thing to address. So yeah, you can't change anything about your age gap, but what can you do? You can strengthen your case and say the
Mm-hmm.
truth. So when they ask, okay, well, likely you have, or people that in your situation have had prior marriages,
Yeah.
and just say, you know, I'm going through another marriage, and hopefully this will be it. Kind of joke around a little bit and be lighthearted, and so maybe you'll get the officer to smile a little bit. And you know, it's as a married man, it's not easy. It's not easy because there are
Yeah.
things that come up, and it's hard to understand these cultural differences because yes, I'm Asian, my wife is Asian too, but we're from totally different countries. And so when the officer asked us questions, the officer happened to be Filipino American, and so he asked us questions about like, okay, so this is a long time ago, so I don't remember exactly, but something about our separate cultures.
Mm-hmm.
Not because he didn't believe us, because I think he wanted to pass us. It's just he was just trying to kill time. But he asked us like some random question about um, my wife's culture, and then we kind of joked about it, and it worked out. But I knew a little bit about her culture because I love her culture. I love her culture's food, you know. So you can show pictures of you guys eating out at the different kinds of cultural restaurants.
Yeah.
You know, how what do you do to celebrate each other's cultures?
Mm-hmm.
Um, you know, things like that. So, um, same thing like I said earlier, document everything. Okay, you have cultural differences, but you have one bank account. Think about that. Okay, so think about what is irrefutable. Like you actually share a bank account. Okay, so you file jointly. You have a lot of pictures of your travels together.
Mm-hmm.
You know, you think about that. You have the burden, but then yeah, just keep adding to your list of evidence. Okay, and then let them decide.
All right. That's that's so sweet, Mark, that you are also sharing your experience, and by setting an example, also our viewers can relate to it. That yes, if you have also went through it, then it's not just that you haven't experienced those situations and you're randomly giving advice. So, friends, I think it's great. You have an example sitting over here and who is living his dreams. So, I think that's wonderful. And also go ahead and get in touch with attorney Mark Santa Maria just by visiting this link, and you'll get the contact details of him. Okay, Rudra is here, Mark, and Rudra is saying that he is sharing his experience. Hi, I had an interview on 4th February 2025. After the interview, officer put my case under administrative processing. Now, embassy sent me a letter saying I need to upload some documents on CEAS site and drop off passport when login to my CEAS profile. Okay, and there's a continuation to it, but there is no option for upload documents. Then what should I do? I emailed to NBC, but I did not receive any response. Also, the asking passport drop off while you are in under AP. Is this a good sign or not?
I totally get it, Rudra. It's so confusing because yeah, they ask you to upload documents, but there's no place to upload it. So it's like, yeah, okay, here you go, but can you accept it? That's something I have to actually I have to guide you through of like where to click and things like that. So that's something. Feel free to reach out to me and my office, and we'll try to show you where to go. But it's possible.
All right. That's wonderful. I think Rudra, you need some guidance to it and some, little deep analysis on it. So, and Rudra, I hope you have subscribed to our channel. If you haven't, then please do it right now. We would love to have more sessions with attorney Mark Santa Mario, and I think that will be great. So, I think let me go ahead, Mark, with some another questions that I have for you. And we have been talking about so many things right now. So, any update on public charge rule, affidavits, or financial requirements in 2025?
Uh, okay, these are also good questions. So, public charge rule keeps changing, and so I have to be careful on what I say. But so as for now, it's related to the 485, and so you can check that in terms of public charge. So when it comes to um, the public charge rule, you have to really pay attention to what's going on, because the 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 policies changed frequently over the past several years, with Democrats and Republicans in office, and so it's going to change. You can assume that. Right now, it is what it is the status quo. So it's no change lately. But then, in terms of the affidavits of support, not necessarily either. No real updates, and that's in relation to the financial requirements. So, for example, you have to submit your past year of tax returns, for adjustment of status case, and it's a plus if you also submit the past, include in the 3 years, including the most recent year. So 3 years total, past three. That's of the financial documents. And so in terms of requirements, yeah, tax returns, and in some cases, in many cases actually, they'll want employment verification letter from the sponsor or petitioner. So those are some financial requirements that you should be aware of.
All right, that's right. And I think it's almost time, Mark, and we didn't even realize like it's been 1 hour. So I think let me go ahead with one last question, and after that, I think we can move ahead with our wrapping up. So, how can newlyweds avoid delays or rejection during this process? Any tips, any strategies for newlyweds? Please go ahead.
Well, that's a good question, and so we've had newlyweds, and we've had cases where they've been married for a decade and finally got around to it. And so, for those newlywed cases, it's still possible to avoid delays or rejections. But if so, you're obviously asking this question because you want to get this done as soon as possible. But at my suggestion is make sure it's you have a quality case. So yeah, maybe it'll take an extra week to put together to open up a joint bank account. I would rather wait that 1 week to open up a joint bank account, because if you don't give enough evidence, then yeah, you will likely get an RFE, some sort of delay, and so I would just consider doing those things and plan ahead. So assume that it's not going to happen overnight where you can open up a bank account. Assume that an estate planning attorney or family law attorney is going to take at least a few weeks to just get a call from that other attorney. So assume all those things. So knowing those things, do those first, right? Save yourself some time and some headaches. And so prioritize the things that you cannot really control. Like as I said earlier, control the controllables. So you can control picking up a call to your family law attorney to write your will and trust. You can control that. You can't control his or her schedule. So yeah, just do what you can to control what you can control, and that will likely increase your chances of avoiding delays.
Okay, that's great. And I think that's all for today, Mark. And I think that was really great having all the questions. And I'm sure our viewers are so happy and satisfied with the insights that you have provided them. And it was a great engagement, great feedback from our viewers. So I think this was your first time on Immigration Talk Show. So please go ahead and let us know how was your experience, how did you feel, and when should we look forward to our next session?
Well, Sam, I really appreciate this opportunity, and it's a lot of fun. I love advocating for immigrants. As I said earlier, I love serving, and
Hmm.
so that's what I feel like I'm called to do. And
Okay.
I really appreciate this opportunity that I am given to show that I'm of service to people, and we are of service. So thank you for this wonderful opportunity. It was fun.
Same here. And I think, Mark, we are getting lots of engagement not only on YouTube but also on LinkedIn as well. We can see a lot of comments here. So I think that's really great. And thank you so much, guys, for joining us. It is really appreciating. It is really motivating. I hope you all are liking, sharing, and subscribing to our channel. Our handle is at Immigration Talk Show. And if you want more sessions or any other topic that you would like to cover us, on our next upcoming show, then also put them on the comment section, and we will make sure that we are going to fulfill your demands, your needs again. And with that, Mark, it was really wonderful, our honor to have a show with you. I am really feeling so happy that you are here. You have put in a lot of efforts, so many great insights on the table. So wonderful. Have a great day. And once again, thank you so much for being here. It was really great to have you.
Thank you, Sam, and thank you, Immigration Talk Show. And it's my pleasure and privilege. All the best, everyone.
Thank you so much, Mark. Have a great day. Okay, so with that, friends, I hope you like this session, and we have covered so many questions on a very interesting topic about marriage based green cards. In case if you are having any more doubts or any other queries regarding the topic, then please go ahead, put them on the comment section. And even after the live stream ends, we are going to come back to those questions and will provide the great answers to those. And in case if you want to get in touch with attorney Mark Santa Maria, then please go ahead, visit this link and get in touch with her. So thank you so much, guys, for being here. I'm sure this session has been helpful for couples, newlyweds, and for those guys also who are looking to have, their marriage-based green cards. So thank you so much, everyone, for joining us. And don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. It's me, Sam, and looking forward to another great session that will be live at 4 p.m. EDT. So join us there. Until then, keep motivating, keep yourself informed, and also keep watching Immigration Talk Show. Thanks, everyone.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and a warm welcome to each one of you here on Immigration Talk Show. Thank you so much for joining, and this is your time to share this link with also your friends and folks out there who could benefit most from our content. So ask them to join because we have a very interesting, discussion lined up with our guest for today for sure. And before we start off with everything, let me tell you that our handle is at Immigration Talk Show. So share now, subscribe now. And this important disclaimer before we start. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, welcome once again. I'm Nipasa, and I'm going to be your host for this session that's lined up. And our guest for today is going to be none other than Jake Tuimau Luga, who is a seasoned immigration attorney with extensive experience helping, Fortune 500 companies, small businesses, investors, and families, who have been exploring the complexities of U.S. immigration system. And he specializes in both business and family immigration and holds a Juris Doctorate from BYU's J. Reuben Clark Law School, where he was recognized for his outstanding work with migrant communities. So, absolutely, friends, without further ado, please help me welcome Attorney Jacob from, well, US Amy Visa. Hi, Jake. How are you doing today?
Hey, Nipasa, good. Good morning. Nice to see you. Hi, Felipe, too. Nice to see everybody.
I'm excited for this session that's lined up. And, Jacob, I'm sure it has been super busy for you. So tell us what has been happening since we last met.
Yeah, it has been a couple of months, huh? I feel like probably like a lot of you, it's pretty jarring to follow immigration news on Twitter or X. With the Trump administration or officials, and so many government leaders posting their thoughts or announcements on social media rather than through traditional channels. We live in interesting times, if nothing else.
Yes, indeed. Very interesting. Every day is an interesting day because we have, different updates, especially if you talk about US immigration. And I hope folks out there have been following us. And if not, this is your chance to subscribe now and stay updated because we come up with everything US immigration. So our handle is at Immigration Talk Show. Check us out not just here on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Join us to stay connected and also ring that bell so that whenever we have discussions like these, you're notified. And today's discussion is going to be very interesting one indeed. We're going to be talking about why is USCIS taking so long, the latest processing delays and how you can stay ahead. So Jacob is going to help us answer most of the questions we have. And you too, friends, you can ask your questions. Feel free to comment wherever you're watching. And another best thing is, you can also dial in, call us on this number, which you can see on the screen. And the number is 425-436-6335. And when they ask for the access code, just dial 988-888. And I think, Jacob, without further ado, I'm just going to dive right into our questions. So I have this first question for you. How are Trump era changes reintroduced in 2025? And, like heightened national security or screening, and cancellation of humanitarian parole as well, which we recently heard. You know, it's slowing down both family and employment based immigration. If you could tell us more about it, please.
Absolutely. I think it's no surprise anyone who's followed the news or the American politics scene. Immigration was probably the forefront issue for the 2024 election. And I think that the Trump administration has shown in its actions that they are evaluating all immigration processes, both legal traditional means and through illegal immigration, as ways, frankly, to deter both. I think we've received a lot of mixed messages from the administration with regards to legal immigration. I think it's no surprise that the administration was targeting crime and trying to prevent what they perceived as unlawful entries into the U.S. But I think there is a battle within the Trump administration between those who also want to limit legal immigration as well. And I think, like you've pointed out, Nipasa, there has been a lot of announcements or actions taken to, at the very least, slow down all immigration processes. I think this is across the board, both with USCIS here domestically and with the Department of State abroad, where, I mean, literally before this morning, F1 visa appointments were not even available for weeks or almost a month. So we're basically checking these sorts of updates every single day to see what's going to be next.
Right, Jacob. Thank you so much, for giving us a peek into what is happening. And yes, these updates have been going on, and we have a lot of confusion, questions, and it's only, very how to say obvious that people have a lot of questions for us to answer as well. So I'm happy that we have some viewers who have joined us already, so I'll quickly say hello to them. Ricky, thank you so much for joining us, and also Philippe, thank you for joining us on LinkedIn. He says good morning, Jake, and hello, I am from Nepal, he says. So it's lovely that you have joined us. This is Netra from Nepal on LinkedIn. Lovely to see you. Thank you so much for joining us. I hope that you're going to enjoy this whole session that's lined up. And feel free to comment if you have any questions, especially with regard to the topic of discussion for today. And Jacob, now my next question to you is, USCIS has now expanded also the biometric requirements to additional categories, including the H-1B and the I-539 applicants. So
Right.
how much is this new step contributing to longer processing timelines?
It's a really good question. I actually think the rollout of this was not streamlined properly. If you look at the announcements for this biometrics announcement, they said that if you had an I-94, which for those who are not familiar, you get an I-94 if you enter the US with a temporary visa or another type of entry document. You're given this document online or in your passport, most commonly online, which tells you how long you're allowed to legally remain in the US. And the announcement said if you have received this record, you are not required to file the updated biometrics request. And the way you do that is through something called the G325R. You do it online. But for example, I had a national interest waiver applicant, a couple of them, who received RFEs for their cases. Nothing about the merits of their actual NIW case, but solely requesting that they provide this biometrics data, even with their I-94s, where they were on an H-1B or an E-2 visas, which give you I-94s, but they were still given these biometrics requests. So I think it's, I think in principle, it's a good idea if you're trying to vet travelers through the U.S. I can understand the intent behind it. I think the execution could certainly be done better. So is it contributing to longer processing times? Yeah, no doubt.
Yes, definitely is. And we can see that almost in most of the categories, I think, right, Jacob? So,
Yeah. Yep. That would never have happened for a petition, like for a change of status. it would make sense for like derivative applicants where they need to do biometrics. That has been done in the past. But for a strict petition where you're not even asking for a status change for you to have to provide biometrics, that's never really been done.
Right, right. Thank you so much, Jacob, for taking that up. And I do have more questions. And Jadav has also joined us. Jadav, thank you so much for commenting with your question. We are going to take it up a little later in the show, so stay with us, all folks out there watching us right now. So, also, Jacob, I have more questions. And if you could tell us, because with reports of tighter scrutiny and more frequent RFEs, across applications in USCIS, um, is USCIS becoming more risk averse in its adjudications?
Absolutely, yes. The rate of increase in RFEs, I think it was more than 20% of non-immigrant visa applications overall receive requests for evidence. This is based on anecdotal reported data, but this is up from 3% from the Biden administration for around the same time last year. So undoubtedly, when you start to see more requests for evidence across the board, you can tell that USCIS is trying to more heavily scrutinize applications. I think we've also seen this too with regards to green card processes, where in the last 4 or 5 years, really since COVID, we were not getting very many adjustment of status interviews at all. So for those who don't know, adjustment of status is where you change your status from temporary to permanent residence in the US rather than get your green card or your visa through the consulate. And so last few years, a lot of people, I would say 95+% of our clients were just getting these in the mail, and you never had to talk to an officer. Right now, we are kind of flooded with a lot of these interview appointment notices, even for EB1 and EB2, EB3 green card applicants, through employments, not just the marriage-based ones. So, yep, there is definitely higher scrutiny.
Well, thank you so much, Jacob, for taking that up as well. And very interesting, I feel, this whole conversation we're having. And there's so much more to ask. And Philippe Caesar says hi to me too. So, hello to you too, Philippe. Thank you so much for joining us. And, well, we are going to take up your questions. Stay with us, and please feel free to share this content with your friends and family out there who could benefit most from this conversation and discussion today. So we'll just go for a quick short break right now. And do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Today we are speaking with none other than attorney Jacob Tuimaluga, and we are talking about why is USCIS taking so long, latest processing delays, and how you can stay ahead. Don't go anywhere. This is Nipasa on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. And I'm Napasa, your host on today's discussion. We got none other than attorney Jacob with us today from US IMI Visa. And it's been superb having him because we are already, getting most of our questions answered. And we are talking today about why is USCIS taking so long, the latest processing delays and how you can stay ahead. So if you too are facing processing delays, maybe you have questions with regard to your visa status, feel free to comment or maybe join us on call. Our number is 425-436-6335 and the access code is 988-888. So Jacob, I have more questions for you and I'm just going to go right into it.
Let's do
So,
it.
which USCIS forms are currently facing the longest delays, if you could tell us? And for example, why are I-130s for green card holders now exceeding 36 months, while I-129 for fiance visas are moving comparatively faster?
Yeah, I'd say for the most common forms, the ones that I've seen that the processing time is just lengthened to crazy levels, is probably the 601 waivers. Those are basically if you've otherwise violated your status, or if you have unlawful presence and you need to ask for forgiveness through a qualifying relative. Before COVID, I remember those taking around 6 months or so for them to process. And now there are several of them, like these types of ones are taking more than like 2.5 years for them to process. So basically something that's, I would say, an unacceptable processing time. I think the one that's probably the worst is also the I-751. So this is to remove the conditions of your green card to get the permanent one. I think the fact that, I mean, it's a very quick, easy form. The fact that that takes more than 2 years to process is crazy. With regards to the I-130s compared to the I-129Fs, on a personal level, I really hate that these take that long. I feel like the need for family unification is very important. So I think the idea that, I could be sponsoring my wife, my kids, or my fiance through the I-129F, and I need to wait 3 years for their petition to get processed before I've even gotten to the consulate is ridiculous. I think that's extremely inefficient, and I don't think that helps Americans, who are trying to help their family. So yeah, those are a lot of those delays. There are certain actions, I'm sure we're going to talk about those, that you can take to try and speed these up. If I was being honest, I would say a lot of these actions were more effective in years past than they are right now. If it's any consolation, though, I will say last few years there has been, I would say, a back and forth between whether a fiance visa or a spousal visa was faster. And there are definitely some advantages where you would choose one over the other. Right now, my experience just with my own clients, the fiance visas are definitely processing more quickly than the spousal visas are, though.
Right. And like you said, very, very, very true that, families need to be reunified sooner than later. I think it's very important for families to stay together.
Yeah.
So let's see what happens. And if I may ask, Jacob, all these years of experience on immigration, law, is this, I mean, are these delays, have you seen these sort of delays earlier or more delays anytime earlier?
Um, no, I was trying to think if there was a time that I had. I would say COVID was pretty slow for sure. There expressed reduced capacity there. Um, I think one factor is there are more people applying now, and there have been in the last few years than there were ever before. So I can understand in a limited capacity why there are delays. But I also think with the advent of technologies and AI and modernization, it really shouldn't take that long for a lot of these types of basically procedural, respectfully, secretarial work for decisions like this to be made. A lot of these types of applications, it's not even possible to file them online. You have to print these off and mail these in, and somebody literally combs through your paper in order to make a decision. I'm like, it's 2025. We should be able to modernize a lot of these systems to just make them more efficient. But alas, we have what we have.
So true, so true. That's what, even I had in my mind, because it is modern times. Most things are digitized where everything is online, and
Right.
it's more like saving time and faster, right? Where messages or documents rather do not take so long to get through. But I agree. You still need manual labor behind all of that, so it should take some time. And I think people are traveling now more than ever before, so
Yep.
that too adds up, I guess. So
Yeah, no,
quickly, though, I'll say hello to Seema. Thank you so much for joining us, Seema. We are going to take up your questions. Stay with us. But Jacob, I have another question before we proceed with our questions from our audience. Despite border backlogs, the N400 naturalization applications are being processed faster than in, recent years. Why is that? And can this trend continue?
I've definitely seen a marked increase in the speed of processing citizenship applications. Probably in the last year, maybe 2 years or more. I've had several cases. I practice here in Utah, as where we're based out of, and I've had almost all of my citizenship cases were processed within like 2 to 3 months, sometimes even faster than that. I think a lot of people suspect that this is because of two reasons. One, the fees that they earn from citizenship applications are pretty high in comparison to the actual work of what the officers need to do. Those applications are pretty quick to review. It's pretty easy to determine whether somebody's qualified or not. So that's nice. The second reason, I suspect, is that allowing people to apply for citizenship also helps for voting purposes. And there's a big incentive for that to be done as soon as possible as well.
All right. Thank you so much for taking that up, Jacob. And we should address some of our questions from our audience. They've been waiting since we began this discussion. So let's take up Ricky.
Yeah.
Can you give some idea on the typical processing time that you are seeing for NIW based I-140 petition? My NIW based I-140 petition is pending for last 7 months. So do you suggest filing premium processing at this stage, or should I wait for 1 more month? Also, can premium processing increase chances for RFE for NIW I-140 approval? If so, by how much will the chances of RFE increase?
This is a great question, Ricky. Yeah, if you're at 7 months of waiting right now, if this was 2, 3 years ago, I would tell you it's going to be any day now. Right now, it's probably closer to 14, 15 months for them to adjudicate initial submissions. Personally, I think I've shared this in previous videos together. I'm not the biggest fan of premium processing. I think that one, it's very expensive for what it is. You're paying almost 3,000 USD. And for an NIW, it's 45 business days for them to make a decision. I mean, that's basically 3 months that they're going to take to process your application. The other reason why I'm not the biggest fan of premium processing, well, two reasons. One of them is it does, based on our firm's own data, increase your chances of receiving a request for evidence. By what percentage is up for debate, I would say it's significant enough for it to not be worth it, in my opinion, in a lot of cases. Now, if you have a very strong case, or if you have urgent reasons why you could benefit from premium processing, let's say you have H-1B, your spouse has an H-4, you don't have an approved I-140, and you want her to have an EAD, might be worth it for you to do premium processing. Or if you are also super rich and you have a lot of money and $3,000 is not that much to you, go for it. Why not? Otherwise, I like for USCIS to really take the time to review your evidence without the time-sensitive pressure of having to make a decision or give you your money back. Because I can tell you, they don't want to give you your money back. So you are likely to get an RFE if your case is not very strong and you file for premium processing.
Yes, for sure. And Ricky also has a follow-up. If NIW I-140 petition filed by the employer is pending, can I file another NIW I-140 in parallel myself while the other one's still pending? Will this create any issues?
Great question. Nope, no issues at all. You can file as many separate immigrant visa petitions that you want, as long as there's not any, let's say, conflicting claims or information. So, for example, I had clients in the past who had submitted certain visa applications previously before moving forward with one with me or with my firm, but submitted different experiences or different claims regarding the dates that they worked in certain places. That would be problematic. But assuming all else being equal, you're submitting the same truthful facts, go for it.
All right. Well, thank you so much, Jacob, for taking that up for Ricky. And folks out there, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Ricky, I hope you got your answer. Don't forget to also ring that bell icon and share this with your friends and family out there who can join us and benefit most from this content. And best thing is that they can also join in to ask their questions, and you can also dial in, by the way. The number is 425-436-6335, and the access code is 988-888. Join us. So now let's go with Philippe. Oh, Philippe already taken. Netra, really, I wish you could join us on call, but nevertheless, if you have any questions, let us know. And Jadav, Jadav is asking, I've been waiting for my application to be processed for months now. Can you help me understand what factors are contributing to these delays? Is there anything I can do to speed up the process?
Yeah, sorry, Jonathan, for the wait that you've been experiencing. It would depend on the type of case that you have as well. Historically, there are basically three steps that I would try and take to move an application forward. Depending on case type, there might be more, but these are some of the actions I would do. Number one is to file an e-request with USCIS. Basically, if you Google e-request USCIS, you'll be taken to a page that allows you to submit a request if your case is outside of normal processing times. I'm going to be very transparent with you. Most of the time, this step is completely useless. It usually doesn't lead to any good action. But you will receive a service item ID confirming that you have made this request. And this is something that could help you in the future, at least to show you have been trying to get the agency to take action. Number two, you can contact USCIS directly via their Ask Emma option, or to call them and ask to speak with them, and to request expedited processing depending on your case type if you have an urgent reason to justify it. Some of these would be if you have urgent humanitarian, medical reasons, or other significant hardship that should be considered. Okay, so I've seen this type of request done for advanced parole, for travel, and for employment documents. Usually, I haven't seen this for petitions. Historically, the other thing we would use is something called the Ombudsman's Office. That was defunded through the Trump administration, so that office no longer exists. The last couple of options that you could do would be to seek congressional assistance. So if you live here in the States, you have a congressional representative through the House of Representatives, and you have a Senate member as well through the U.S. Senate. In either case, I'm very certain that your representative or senator has a page on their website that says help with a federal agency, and you could submit this request to ask for their office to help you. In times past, I've had this work where, here in Utah, I had a previous senator help to bring somebody home who was stuck in a foreign country and who's been waiting a long time for a case. So I have seen it work in the past. If I was being honest, there have been mixed results in the last year or so. The last thing I'm going to say, sorry, this is kind of long-winded. If all else fails and you have attempted, all of these steps to try and compel USCIS or the Department of State or whomever to make a decision on your case, and they have still not, and you have suffered some form of irreparable harm, or there's some other urgent reason why they need to make a decision, you can, in some cases, bring your case to federal court and ask for a judge to compel USCIS to make a decision. And this is through something called a writ of mandamus. This, in my opinion, would be the last option you would do if you have an urgent need. So, for example, I've had clients in the past where they filed petitions and had waited years for immigration to make a decision, way outside the it was a marriage-based case that took like 9 years for them to make a decision on I-130. That's ridiculous. So by filing this claim, you're essentially saying that USCIS has, for lack of a better term, neglected their duty, and that they need to have the courts to compel them to make a decision. And then by doing so, USCIS will make a decision on your case. So hope that helps.
Very helpful. Thank you for the detailed explanation for Jadav, Jacob. And folks, don't forget to subscribe to our channel. Our handle is @Immigration Talk Show. I hope you're enjoying this whole discussion we're having today. And it's really lovely that Attorney Jacob is so patiently taking up each of our questions and answering them. So don't go anywhere, because we are definitely going to take up more questions. I can already see Netra's comment with a question. I'm going to take up this question right after this short break. So don't go anywhere. Stay tuned here on Immigration Talk Show. This is Napasa with Attorney Jacob.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm Napasa, your host, and today we're having an awesome discussion with Attorney Jacob from US IMI Visa, and we have been speaking about why is USCIS taking so long, latest processing delays, and how you can stay ahead. And it's lovely that Attorney Jacob has been taking up each of our questions and answering them patiently. And before the break, I told you that we are going to take up Netra's comment. I believe Netra is from Nepal. So thank you so much for joining us here on Immigration Talk Show. If you haven't as yet subscribed, subscribe now. Our handle is at Immigration Talk Show. This goes out to everyone watching us, by the way. And Netra is asking, we are four in family and master in management and science. Children are under 20 years. Tell me the best and cheap way to PRUSA.
Hi, Nedjari. This is a great question. I'm going to use the lame lawyer answer and say it depends. I would say if you don't have like in a perfect world, if you have an American company to sponsor you, to bring you to the US to work in some capacity related to management and science, your background, that would be the best and cheapest way because one, it statistically has the highest chance of approval. And two, it's the cheapest way because you're not the one paying for it. So that is also a great benefit. Now, assuming neither of those apply in your case, you're going to have to look at the self-petition options. And the immigrant visa ways for you to do that would be through the EB-1A, the EB-2 national interest waiver, or the EB-5. I'm going to go ahead and rule out the EB-5 for you because it is not only not the cheapest way, it is the most expensive way. So you would probably not want to consider that one. EB-1A is a self-petition for those with extraordinary abilities in their field, usually considered for those who are in the top 1% to 2% of their profession. Statistically difficult, not impossible for it to be approved. I would say in your case, based on what you've said with your educational background, you have a master's degree. Assuming it's the equivalent of a master's in the US, you would be qualified for the EB-2 classification. And if you can show that you have future work in the US that is of national importance and substantial merit and that you're qualified to do this work, you'd probably want to look at the EB-2 via the national interest waiver. Now, to be transparent with you, if speed is your concern, this may not be your number one option. In years past, this was much faster of a process for it to go through. But right now, if you were applying from Nepal, I would say you're going to be waiting at least 2.5 years for this to process if everything goes well. So if you are interested in immigrating to the US and working here beforehand, you probably want to look at a non-immigrant visa for employment or investment first before doing the national interest waiver.
All right. Thank you so much, Attorney Jacob, for taking that up for Netra, all the way from Nepal. I hope that was helpful. And I would say please feel free to contact Attorney Jacob. You know, the link is going to be displayed on the screen. Click this link and you will get the contact details to have a one-on-one consultation even with Attorney Jacob Tuimau Luka from US IMI Visa. So it's lovely having you. And we do have more questions. So let's quickly take them up. This next one is from sorry, Harsi. I'm just going to say Harsi. It's asking, my priority date is 21st June 2006, document qualified 30th December 2024. F4 category, India. When when to expect interview?
This is a really good question. I'm going to check the bulletin right now for the F4 category. Give you my estimate there. Yeah, so you're before, I mean, you're obviously your priority date is already current there. You're interviewing in India. Let me look and see what was the last time that like the estimated processing time that we had um, for consular processing there. So in a couple of countries that we work with, we've seen some pretty significant delays even after being documentarily qualified. I would say in most cases, usually ends up being somewhere between 2 and 6 months. Now, there's a couple of countries, I would say Nigeria, Chile, are the two that most clearly come to mind, where even after being documentarily qualified, I've still had guys who've waited a year for them to have an immigrant visa interview. So I'm hoping in your case that it does not take that long, hopefully only a few months, but it would be difficult to say right now.
Well, thank you so much, Jacob, for taking that up. And Harseem, I really hope that was helpful. And please feel free to also contact Attorney Jacob. And the link you can see on the screen, click it, and you will have his contact details. Thank you so much, Jacob. Now let's take up this one from Philip S. Thanks, Jake, for your flexibility in helping us with our legal issues. July 10, my NIW petition is going to be 1 year since I submitted. I'm going to take your advice and just wait, he says.
I know, Phil. He's a good guy. I appreciate that. Yeah. I'm wishing you the best of luck, my friend.
All the best, Philip, from my end as well. And now let's take up Seema's comment. Seema's asking, has a question. I'm seeing conflicting information online about USCIS processing times, and it's really confusing. How can I get accurate, up to date info about my application's status, and what are the best ways to track it?
Very good question. I would agree with you on this. So, the most common resource that people use is the case processing times estimate from USCIS that they make publicly available. In my opinion, these are not reliable at all, and I think it's intentionally that way. In my experience, the relevance of these posted processing times is so that way USCIS has a defense for if you try and sue them under a mandamus action, they can say, hey, it's still within processing times. Our processing times are 36 months. Sorry, you need to wait until then. Even though in practice, they're approving most cases far quicker than that. They have that in there as an insurance policy. That's my opinion. Now, I would say the best way to track it is through personal experiences and reported data from users who are actually in it. And there are several websites that I like to reference for this. There is one called Track It online. I think there's 2 T's on there that I would look at, where people share anecdotal, like their personal data, as a way to give a more true estimate of the estimated processing times of cases. I also like to use even social media reports from people who are filing themselves. I will say on a personal, yeah, there we go. Thanks for sharing that. Yep. So it's www.trackit with 2 T's at the end.com. This is one that I have seen a lot of people use. I like that there is, compiled data here to track this with real people who are applying. But yeah, if you didn't want to pay or use this, I think there are some of these that are paid services. I don't know if this one was specifically, but if you didn't want to, I would also just check with social media, and I would ask, lawyers or those who work in the system to just give an estimate based on their personal trends. It may differ from your case, but at least to know what the estimates are.
Approximately. Thank
Yeah.
you so much, Jacob. Yeah, that was very helpful. And folks, do check out that website. And thank you, Seema, for participating with your question. Folks out there, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And feel free to also share this with your friends and family so that they can also subscribe. Ring the bell icon so that whenever we have discussions like these, y'all can join us and ask your questions. And yes, thank you so much, everyone. Now let's take up. Well, Hari Sim is here with the continuation. He wanted to also update you that I also get 60 days mail from NVC, sir. He says.
Oh, sweet. Okay. Then, yeah, I would keep in contact with them via email as well. If they're already giving you the 60 days out from your appointment or from when to expect correspondence from them, I would definitely stay in touch with them because you're probably very close to the actual appointments. And the next step, they will ask you to go and get the medical examination before your immigrant visa interview. So you're almost there.
That's nice. Harsim, all the best, and I think it's your time now. So get
Mhm.
it done. All the best. And please don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Now let's take up this comment from Nirav. If I'm waiting for a decision on green card and the delay is affecting my life plans, is there any way to get expedited processing? How do I know if I'm eligible for that?
Yeah, sorry, Nuram, it's not fun. Um, it's going to depend on your individual case circumstances. The only one who can ultimately determine to expedite your case is USCIS. Particularly, I'm assuming here that your petition's already approved and you're either waiting for your immigrant visa abroad or your adjustment of status here in the States. In either case, I would, that's kind of a lame answer, I would talk to an attorney then just to see what your facts are. If you didn't want to do that, you, again, don't have to. You could contact USCIS, whether through their online accounts or to call them, ask to speak to a representative through an InfoPass appointment, and explain the reasons why you need expedited processing. I'll be honest, I've seen a lot of these requests denied where they don't consider them to be justifiable reasons, but sometimes they will grant these. If you can explain the reasons why you would need to have this process expedited. I would say in most cases, you're more likely to get your work permit or travel permit expedited than your actual green card, unless you have, again, a pretty justifiable reason. For example, if you were working for the US government in some capacity or in some important, let's say, tangentially related to a government interest, or you had some urgent medical need or other humanitarian reason, those are the reasons that I would say are most likely to be approved for expedited processing.
All right. All right. Thank you so much, Neera, for commenting. And thank you, Attorney Jacob, for taking this up. Folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And if you need a one on one consultation with Attorney Jacob, Tuimawa Luga, do not forget to also visit this link, which is displayed on the screen. And yes, please feel free to share this content with your friends and family so that they can join us in this conversation. Comment if they have questions, because today we are discussing on this topic: why is USCIS taking so long? Latest processing delays and how you can stay ahead. You don't want to miss out this opportunity because, yes, this is very, very beneficial content and content you don't want to miss out on. For now, though, we'll just go for a quick break, and folks, don't go anywhere. Stay tuned on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Hello, everyone, and welcome back on Immigration Talk Show. I'm Nipasa, your host, and today we are having a wonderful conversation with none other than Attorney Jacob to Mawaluga from USCIS Visa. So it's been wonderful having you, Jake. Thank you so much for doing the session with us and for patiently taking up all of our questions today. We are discussing on why is US taking so long, the latest processing delays, and how you can stay ahead, and we have been taking up comments from our audience. It's really lovely to have all of your support and your questions. So let me just quickly pick them up since we do have more questions from Harisim and Philip who have joined us back with follow ups. So, Harisim, sir, can you also tell which document qualified are getting interview in F4 category?
If I forgive me if I don't understand your question, I'm assuming you're referring to siblings of U.S. citizens. Can you tell which document qualified are getting interview? Yeah, basically everybody who's applying for an immigrant visa, who's over age 14. So if it's you and your spouse and children, and you're waiting for your interview, if your kids are over a certain age, they will need to be there in person for that. So that's what I would be prepared for. I hope I understood your question.
Thank you for taking that up. And now Philip is asking, my work was terminated because of my expired work permit. Can I request an expedited request?
It's a good question. I think it would depend. If your work permit was through OPT, the occupational practical training, because you have an F1 visa, the expedited request, I'm assuming if you mean on your NIW, it would not be helpful for you to do, because having the approved I-140 would still not allow you to get a work permit in and of itself without having a current priority date or another visa type for you to do. Now, if you had H-1B, or if you have, let's say you're married and you have a H-4 work permit, then it would make sense for you to do an I-140, like the expedited request for NIW, because getting that would allow you to apply for a new one. Otherwise, though, there's just not really a benefit in doing that. I'd say the only other reason you'd want to do that is if you have an employer who says that they'll sponsor you for a work visa, or a temporary visa if you have an approved I-140. Otherwise, I still don't think it'd be that helpful.
Right. Well, thank you so much, Johnny Jacob, for taking this up. And Philip, I hope you've gotten your answer, and I hope everyone watching us is resonating with what we are discussing today. Please do not forget to subscribe. Our handle is at Immigration Talk Show. And we do have more questions, actually, Jacob. From I had many questions from my end, but it looks like I'm not going to get a chance because there are so many lovely viewers out there with so many questions for you. So let's take these up. These are from our Facebook groups. So I would request control to please, display them on the screen, and we will take them up.
Okay, let's do it.
All right. So meanwhile, I think we can all right. So we have these questions. This is from an anonymous participant asking, has anyone been stopped by ICE? What do you show them if stopped? My lawyer said the pending case letter where they approved it and shows we have to be here, but will they respect that?
Very good question. Has anyone been stopped by ICE? Yeah, but I would say quite a few people. A lot of people have been stopped by ICE, Immigration and Customs Enforcement, nationally in the States. If you are stopped, you do have, if you're physically in the US, you have the constitutional right to remain silent. If you choose to invoke that right, you should be aware that you will eventually be required to provide proof of lawful status here in the US. Otherwise, you will be placed in removal proceedings. What you should show them is proof of lawful status here in the United States, or other proof that you are allowed to remain here. So for example, and the most clear example of this would be if you have a green card or a U.S. passport, right? If you're a resident or citizen, obviously you're entitled to be here. If not, you should have an I-94, which you can get by using your passport and Googling I-94 record online, and you can find what your I-94 date is. On that record, it will tell you how long you're allowed to legally remain here. Let's say you don't have that though. If you're physically in the US and you filed for a change of status legally here, you are allowed to remain here legally for the duration of that process, as long as that process is still pending and the time you requested to extend is still ongoing. For example, if you entered as a tourist and you were here in America for, let's say, 3 months, and then you wanted to be a student and you filed for this change of status, you would want to present to ICE something called the I-797C Notice of Action, which shows that your I-539 for the change of status is still pending. For the long story short, you just need to show them some documents to show you're allowed to be here. If you're unsure what this is, please feel free to contact me or an attorney, somebody who knows what they're talking about, and they can tell you what you should bring or have on hand.
Well, thank you so much, Jacob, for taking that up. We do have more questions. Let's take up this next one quickly. This is also from an anonymous participant asking, my case status until yesterday was saying next step is an interview, and today it says your application is pending. What does this mean?
Very good question. I have seen uncommon case statuses online for USCIS lately. Normally, the next step as an interview would apply for a family-based, most commonly for a family-based adjustment of status case. Your spouse, child, etc., is sponsoring you to change your status from temporary to permanent resident here in the States. If it does change from that to your application is pending, to be honest, it suggests that they're likely reprocessing part of your application or reviewing it. I've had some instances where they approved the I-130, the family-based petition, and then reopened it because there was a new piece of evidence that the officer needed to consider. Now, that doesn't mean that's for sure what has happened. It may also mean that they are just not going to give you an interview, which would be nice in 2025. I would just continue to check your case status online every day until you see a new update on there. I hope it's a good one. Good vibes.
Thank you, David. So now we have more questions. This is another one asking, on submitting my DS-160, I got the following message. An unexpected error has occurred while processing your previous request. The error has been reported to the site administrator. No further action is required. To retrieve your DS-160 application, please enter your application ID. Has anyone encountered something like this? If so, how did it get resolved?
Okay, I can definitely comment on this. This is anything but an unexpected error. If anything, this is very expected. This happens all the time with a DS-160 website. I kid you not. I think this is the worst website I have ever seen. That is supposed to be a functionally used by people on a daily basis. Regardless of browser, you are likely to see this. So my advice on this, my guidance on this would be to save every page that you do on the DS-160 and be prepared that you will get this message, if not once, multiple times, every time you do this. If you're having, I will say a lot of times I've experienced this on Chrome, and then I'll switch to Safari. I use a MacBook and it will work. Oftentimes I have to wait until the next day for it to work. And sometimes this may continue 4 days. I would try with Mozilla, I try with Chrome, I try with Safari, I try with Internet Explorer, and wait for time. Those are basically the only things that you can do, unfortunately.
Okay, that's interesting. And well, thank you for taking this up. I think this is a frequently asked question then. Yeah. This next one is from Carlos asking, I just talked to a DHS immigration officer and he stated that EB1, EB2, EB3. Adjusting of status I-485. Interviews are back. No more green card approvals without interviews. Do you know if someone already went to one? Thank you.
Yep, I've been to many just in the past 6 months. I would say even from before President Trump came into office, this was starting to become a more common uh, practice. Is definitely happening more so now, and this is for across the board, the self petitions and the employer sponsored ones. I would just be prepared to bring all the documents that are listed on the interview notice. I have several ones that are upcoming too. Got an EB3 interview this next week too. And I'm going to have my client bring all the documents listed on the interview notice and be prepared to discuss the employment and the information listed on the labor certification and on the I-140. I remember being in these interviews even when President Trump was in office last time, because prior to that, it was still not common. It was not common before that for these employment-based interviews to be ongoing, to occur before that. So yes, they're happening now. You just need to be prepared to answer their questions pertaining to your employment.
Right. Thank you so much, Jacob, for taking that up as well. And well, we do have more questions. I wonder if you have more time with us, Jacob.
Now, let me finish the questions on here. I can do it.
All right. So this is from JP asking, my PD is 28th August 2023. What happens when it gets current and how long you guys think? Sorry, it's getting cut off. Control, if you
Yeah.
can zoom out a bit. Uh, Less will it be? How how long you think more or less will it be?
It's a great question. I tried to have everybody file within the month that your priority date is available to file the adjustment of status, assuming JP that you are here in the States. You do not want to let it go into the next month because you don't know. Well, you can check the next month's bulletin, right? But oftentimes the retrogression can happen where you'll lose the ability. I know many Indian applicants who suffer the retrogression who were unable to take advantage of adjustment of status during 2020 and 2021 because they did not file the adjustment of status on time. So there's the saying, a bird in the hand. I can't remember the rest of it, but you want to take it when it's available. So you want to make sure you file the I-485, even if you don't have all the evidence that you need. I would make sure you file the bare minimum to get accepted. The medical exam, the 485, the fees, etc. Even if you get an RFE, make sure you get it in.
There you go. Thank you so much for taking this up. And folks, don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. I hope you're resonating with this conversation we're having and with all these answers that Attorney Jacob is so patiently taking up and answering. So this one is from Tatiana asking, hi everyone. I'm currently with my B1 visa and applying to F1. My visa expires in July 28th. My question is, what happens if past July 28th, my request of status change has not been answered yet? Can I stay legally while waiting or should leave the country?
Great question. Tatiana, you should know if you leave the country and you file a change of status, it will be considered abandoned. It will not be approved if you leave the country, for sure. You are legally allowed to remain in the United States while your F1 change of status is pending, as long as you filed the change of status before July 28th. Even if you filed it and it arrived with USCIS on July 27th, you are allowed to remain here while that process is. Specifically for the F1, because you would have requested that your F1 status be valid for the duration of status. That's D/S on this form. As long as your I-20 is valid, even if it takes 6 months for your F1 change of status to be approved, the F1 change of status will still be approved, and it will be predated back to the time that you had filed for the change of status, assuming you asked for the F1 to start on July 28th. The risk here is that if it's not approved, you need to make sure that you depart after the I-539 is denied. A lot of times for my clients, I have them file a B1 extension as well, just in case the change of status application is not approved.
All right. Thank you so much for taking that up for Tatiana. Now, this next one is: did anyone cross borders to get F1 stamp from his home country, US Embassy, after applying for change of status inside the US? In my case, I applied for I-539. I want to travel home by end of this year, but I am really afraid to lose my status and not be able to return back again. I really want to hear your experiences about that, and which country did you get your stamped F1 from?
Yeah, this is a complicated answer, to be honest. So, for those who do not know, filing a change of status in the US does not govern for the Department of State. So, in theory, you can have an F1. Let's say you enter as a tourist and you apply to change your status from tourist to student here in the US. You'll get a green piece of paper saying, congratulations, you now have F1 status here. If you take that document and fly to Mexico for vacation and try to fly back with that green piece of paper as your visa, they are not going to let you back to the country because it's not a travel document. It's not a visa. It is not without its own risk for you to leave the US with a change of status and to pursue a visa abroad. I would say in this case, in your case with the F1 stamping, it's going to depend on a number of factors whether it's worth the risk for you. So I've had some clients in the past who came here as tourists many years ago. Like I had one client who came in like 2013 and filed for a change of status to F1. And he had been on F1 for 10 years before going back to his home country in South America for a visa. He had no property and he had no family, no spouse, kids, parents, nobody that lived back in his home country. When he went back to that country, he was unable to get the F1 visa stamped there because they did not believe that he could establish ties to his home country. This is really country and fact specific. Now, alternatively, let's say that you own a house there in your home country, you have property and money and savings and a business and kids, whatever. The more context you can show there and the more frequent your visits back home, the better in your case. Again, any case specific things, I would talk to a lawyer about this, but it's really going to be case specific.
All right. Well, thank you so much, Jacob, for taking that up. And I think we are going to take up these last two questions. Or, folks, maybe if you want or have any questions, quickly comment now. This is your chance. And we are going to leave soon. So, this next question we have is on YouTube, Inner Drive. Thank you so much for joining us. Don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And also feel free to share this with your friends and folks so that they can also join us in these conversations and benefit most from our content. So Inner is asking, last year H1B I-797B approved and active, but has consular 221G and it's in refused status. Employer need to submit more documents. Can any other employer file a cap exempt H1B for me based on approved I-797?
If you were H1B, if you were fiscal year 2024, so you had it approved October 1st, 2024, or fiscal year 2025, and you were approved October 1st, 2024, yeah, have another employer file the cap exempt H1B for you. You could also do that based on that approved I-797.
Thank you, Jacob, for taking that up. And this next one is from a ranger. I have a pretty forward case, no arrest, no removal overstay, but back in status, DPS. How much do you charge for AOS? Thank you.
Nice. Yeah, genuine transparently, I would say here in Utah where we practice, I would say most firms, including ours, it would be somewhere between $3,000 and $4,000, counting the AOS appearance with USCIS as well. I think if you were price shopping, you could find a more affordable option than that. But if you were looking for support and for someone to attend the interview with you or respond to any requests for evidence, super happy to do that. You did mention you have a straightforward case. If you have TPS, you have lawful entry, you have no arrests or other inadmissibilities, you probably have you got a good straightforward case. I don't think you'd have too much trouble at all. You should definitely do the adjustment of status.
Thank you so much, Jacob, for taking that up. And folks, please feel free to contact Attorney Jacob from USCIS Visa, and you can do so by checking out this link which is displayed on the screen. And also, Jacob, today I mean, so much to ask, so much to speak about, but I think we will have to keep some of our questions for another session. We have been discussing on, why USCIS is taking so long, the latest processing delays. But also, if before we go, you could quickly just give our audience out there, viewers out there, a few tips on how you can, or they can stay ahead rather. So that would be great.
Yeah. Immigration is an ever evolving field, probably more so now than ever. Feel free to follow us online, follow other accounts, follow this channel for updates on this. I would just remain informed. If you do have delays or you're worried about case processing, I would say, take heart. Yeah, there might be some setbacks. Yes, there might be some processing delays, but there's usually more available. There's usually more things that you can do than you think. Sometimes you just have to be creative, or might just have to do a little bit more work than you realize in order to reach your desired goal. But I would just, where there's a will, there's a way. If you have any other questions or anything else, please feel free to reach out.
Thank you so much, Attorney Jacob. It was really lovely having you. And Ranger is having a big question out there. And I think you should definitely contact Attorney Jacob, and you can do so by checking out this link. Contact him, and yes, have your consultation with him. I'm sure he's going to be most helpful. It was really lovely having you today, Jacob, with us.
Appreciate you, my friend. Always good to see you. Thank you.
Thank you so much. I wish we could continue, but let's leave some of our questions for our next episode. And folks, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. I hope you loved it just like I did. And thank you everyone for joining us. Also, if you want to contact me or you have any questions which I can, send them across to Attorney Jacob, also you can write to me or call me on my number. This is also my WhatsApp number. My number is 408-335-6444, and my email address is nipa@staffingme.com. But yes, don't forget to subscribe, share, and like our content. Our handle is at Immigration Talk Show. Check us out on LinkedIn, not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Thank you once again, and stay tuned on Immigration Talk Show because there's a lot more coming, all on U.S. immigration. Bye for now. Thank you, Jacob.
Thank you.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Hello, everyone, and welcome to Immigration Talk Show. I'm Nipasa, your host for today, and I'm super excited because we are going to have our guest join us pretty shortly, so stay with us. But before we start off with today's episode, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use at your own risk. And once again, friends, thank you so much for joining us here on Immigration Talk Show. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And check us out. We are on YouTube, LinkedIn, Facebook, X, and on Instagram. So stay connected with us and do not forget to ring that bell so that whenever we have discussions like these, you're notified. And another important thing is like and share our content because we have so much information that most of your friends and folks can also benefit. So share now, ask them to join in because we are going to be joined by a very renowned, managing attorney at EEG Immigration Law Group, which is led by none other than attorney Erin Green. So I think, yes, without further ado, please help me welcome him back to Immigration Talk Show. How are you doing, Erin, today?
Hey, good. How are you? Good to see you.
I'm doing good too. It's always good to see you and lovely to have you. I'm sure folks have not seen enough of you in our channel, so we'd love to know you better. Tell us more about what's going on. You have a pretty busy schedule.
Just about my work. Yeah, I'm just living and breathing H-1Bs and L-1s, you name it, all the fun stuff. Um, just constantly working, solving problems, strategizing. It's never ending. But it's good to be here with you and talk about some of these issues.
Same here, Erin. And folks out there, do not forget to check out attorney Erin Green. You can visit this link, which you can see on the screen, and get to know more about him or how to get in touch with him. So today, our topic of discussion is another very interesting one. H1B picks are down and what's behind it, and should you be worried about it? So I'm sure, folks who are in this H1B cap time and before the fiscal year, pretty worried because there have been less picks because of so many reasons, whether you talk about fee hikes or so many other things we're going to talk about in today's webinar. So I am pretty ready and I can see, we already have viewers joined us. So welcome viewers here on Immigration Talk Show. Ricky says hello. So hello to you too, Ricky. Good to see you once again. And he has a question. We are going to take it up a little later in the show. But before these questions, Erin, I also have a couple of questions and I'm going to just dive right in. So if you can break down, how the new beneficiary centric system changed the dynamics of this year's lottery, H1B lottery. Was it fairer, you think?
Oh, yes, I think it was much fairer. Did away with a lot of the job shopping and fraud. They went to more of a deduplication. They supposedly, so instead of taking all the registrations, and even if there were doubles, you could get selected 2, 3, 4 times. They announced that they were going to duplicate by beneficiary. I think that means that when a beneficiary was chosen a second time, they wouldn't put the second one in. Instead, they would choose another random person. Is what I understand. that means. So this led to yes, definitely less applications and less people being chosen. Um, I believe the statistics were 7,800 multiple entries versus over 47,000 last year. So that's a big change. This is duplicates, so this would be a person being selected twice. Certainly has had a big impact there.
Right. And lovely to have you, friends out there. This is attorney Erin Green, who is an immigration attorney and an H-1B expert. So if you are, one struggling with your H-1B this year, or have so many questions because you're planning to get into the lottery very soon, feel free to join in to ask your questions. All you have to do is comment wherever you're watching, or dial this number, which you can see on the screen above. And the number is 425-436-6335. And when we ask for the access code, dial in 988-888. So, Erin, also, given the big drop in multiple registrations, which according to the statistics, it shows over 80%, what are the biggest takeaways for companies and applicants alike?
Well, the biggest takeaway is that we're not wasting all these H-1B lottery slots on people getting selected 2, 3, 4 times by different companies. A lot of that, probably most of that, was the job shopping. If people don't know what job shopping is, it was these companies that would form maybe non-affiliated companies, but still had similar like a friendship group, let's say, that could own different companies. And then let's say they took 100 employees, they could, if they had 10, 15 companies, they could apply 100 times per company. Think about how unfair that is to just one person who's trying to get an H-1B cap slot. So by doing the lottery this way and some of the changes, yes, including increasing the fee, it appears that we can see the statistics. There were much less multiple applicants picked, and in addition, less numbers. And I don't think that has to do with the economy, but I think it has most to do with cracking down on the job shoppers.
That's true. That's true. And it's really nice. I feel like it's much fairer this year. Whether you talk about, I think transparency is also another good thing that's happening recently, as we see, because firstly, there are no duplicates. Nobody can register more than once, or no matter how many companies are registering, but you'll be counted just as one. So all of that is, I think, pretty fair to everyone. It's like an equal chance for everybody in the lottery, right?
Yeah, I mean, I can tell you, our firm, we got almost just about 50% this year, which is very rare of our lottery, of our H-1Bs. In the past, we were, at 40 or 35. I think the overall percentage this year was at 30. I don't know if I have that. 35% approximately that were selected thus far, which is okay. It's over a third. It would be nice if the actual rate was like at 50%. That would be really a much better chance, obviously. But yes, it did feel like a better lottery this year so far. So we're looking good.
All right. So, do you expect to have another lottery soon? I mean, the second lottery or a third, maybe?
Well, it's hard to say. So what they do is they see after. So the end of the filing period is at the end of June, as you know, at the end of this month, and then they will see if there's any withdrawals or just those cap cases that weren't filed, and then they traditionally will hold a second lottery. We really don't know. It's hard to predict what that's going to look like. When obviously our clients and employees that call us all the time and say, "Well, I didn't make it. What's my chances for the second lottery?" We tell them not to get your hopes up because it's usually not a very big number. Last year was okay. It was a little bit better than the year before, but we really don't know what kind of numbers there will be for a secondary lottery.
Okay, so let's not keep our hopes up, folks out there, but definitely keep asking your questions. Hello, Sunita. Thank you so much for joining us. We are going to take up your questions a little later in this show, so stay with us. And also, Erin, we were talking about duplicate filing. So, How has USCIS's crackdown on fraud and duplicate filings, impacted these legitimate applicants and their chances? What do you say?
Well, as I said, well, now the legitimate, well, you can see the percentages are going up, and the legitimate filers have a better chance. If you can get rid of all they don't call it fraud. It really is fraud, but what they're doing technically was, just groups of people filing for mass filings. When you do that, it normally, you say fraud, and I agree, because in many of those cases they don't have the jobs available. They're going backwards. They're trying to get numbers and then trying to pop these people into jobs that they can find after that. So yes, it was fraud, and now hopefully, well, it looks like it's much better for those who are just normal, regular cap lottery, applicants getting their number selected.
So is it true, like, there's a lot of scrutiny going, as in, like, people who have been registered for a special occupation, do they really check if there's a job like that or a vacancy like that for each and every case?
Well, the problem is they can't check when you're doing the lottery. So yes, after you file the application, that's when you have to submit all the relevant data and all about the job and everything. But yeah, I mean, years ago we used to the lottery worked where you would submit the application up front, and so there was a lot of work and a lot of fees, a lot of attorney's fees. Now there's a little bit less, but yeah, I predicted that when they switched over to the online method, that this exact trend of job shoppers would have it easier. Now this year, also by raising the price to $200, which is huge. It was $10 last year, and now each applicant was $200. So if you are job shopping and you have hundreds and hundreds, that's a huge cost that they're taking on and a big deterrent. So hopefully that has helped as well. And again, just the way that they intook the multiple beneficiaries also. So both of those combined should have been a deterrent to job shoppers, at least in the outcome, and even in maybe some that were applying. And so you can see the overall numbers were down this year as well.
Right, Erin, and thank you so much for taking that up as well, and for giving us a clearer picture on what is going around. So, friends, feel free to join us, and do not forget to subscribe. Our handle is at Immigration Talk Show. We have with us attorney Erin Green, who is an immigration attorney and, of course, an H-1B expert. So, to get to know more about him, visit this link which is on the screen, and keep commenting. So, Erin, what kind of red flags is USCIS looking for now, especially when reviewing H-1B filings, especially post-lottery?
Okay, well, yes. So we are seeing trends now because we've obviously filed a lot of H-1B lottery cases. We did receive an RFE, which I haven't seen in many years, which was a level 1 wage. We used to see those RFEs about level 1 wages years ago. Now I received one, which was interesting, questioning if it's a level 1 role. That had died down for a while, so that might be coming back. Also, we're seeing, let's see, what else do we have with our RFEs? They're questioning again. It seems they're questioning the job, the educational category. So sometimes, like if you file for an IT person, you might say the job requires a bachelor's in computer engineering, electrical engineering. Sometimes they'll put mechanical engineering, information science, data science, etc. You put a bunch there because large companies have the same role being played by employees with a variety of backgrounds, which do qualify for the role. We have seen a couple of those recently. They were not cap cases, but other cases where they questioned the degree requirement, which it's very ticky-tacky now for USCIS to start doing that in today's age where most of these degrees are acceptable and very relatable for IT roles, software engineering, etc. I think it's very ticky-tacky on their part. they're supposed to be looking again at third party. We haven't gotten any yet, but third party work sites. So for people who are working at third party sites, they used to heavily attack those. I remember that was about 6 to 10 years ago. Then it died down, and they announced that third party sites were not going to be scrutinized that hard. They might be coming back with that as well. So if you're going to be working at a third party site, you really want to document your application up front. Obviously, you need an itinerary, but we like to include SOWs, MSAs of the work contracts with the third party. And now they claim they're going to be looking into the third party itself, which is interesting because they're not the employer. So other than the statement of work and the MSA, I don't maybe some other documents relating to the particular job. I don't understand what they're going to look for in the third party client site, but we'll see if we get RFEs like that. Haven't received any yet.
All right. So, would you like to tell us, especially with H-1B cases that your law firm has been dealing with, or we will get to that very, very soon. Actually, it's time for a short break. So, folks out there, don't go anywhere because today we are speaking with attorney Erin Green, who is an immigration attorney and also an H-1B expert. Get to know more about him by visiting this link, which you can see on the screen. And don't go anywhere. Stay tuned on Immigration Talk Show. It's me, Napasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa. And today we have our guest with us, attorney Erin Green, who is from Dallas Fort Worth Metroplex area. And, well, he is an immigration attorney and an H-1B expert. So go check out EEG Immigration Law Firm and definitely join us for this conversation today because we are speaking about H-1B picks are down and what's behind it and should you be worried about it. So if you have your questions, especially with regard to H-1B, please feel free to join us. Comment wherever you're watching us. We are live right now on YouTube and also on X, Facebook, and LinkedIn. Also, friends, do check us out in all of these platforms. Stay connected with us and you can call us to ask your questions. The number is 425-436-6335 and the access code is 988-888. So it's lovely, Erin, to have you. And I was just before the break, I was going to ask you about your firm, EEG Immigration Law Firm. Tell us about what has been happening, H-1B cases or anything interesting that you want to share with us.
Well, other than those RFEs, which I just shared, which are some of the new trends we're seeing in RFEs related to H-1Bs, everything else is pretty running, as normal. Wait times are, similar. Maybe without premium, we're looking at anywhere from 2 to 6 months approximately to get H-1Bs back. As you know, the premium gives you a first response within 15 business days. They changed that from calendar days, so they're giving themselves more time for the same amount of money, which is kind of a ripoff. But yeah, other than that, everything's running pretty smoothly. Hopefully, we'll see how much we did. We are experiencing a few RFEs now that we haven't seen in the past couple of years. So hopefully, the RFE numbers won't get too bad, but we will see how that goes.
All right. Thank you so much, Erin, for sharing how's it going there with EEG Law Firm. So, friends, if you have your questions, I can see Girish has also joined us. Mansi has joined us. We are going to take up your questions. Please stay with us. In a short while, we are going to address your questions. So, Erin, with a 35 selection rate and cleaner data this year, what are the real odds of a second lottery? I already asked. But how do you feel, the differences? Because though there have been less registrations, but the picks are, I think, still all right, right?
Yeah, I mean, there was over what 300,000. What was it, 370 this year? So it's pretty strong indication of the economy and the jobs that are needed. Um, yeah, I don't see any problems.
Okay, and if a second lottery happens by any chance, what are the timelines and what should, unpicked applicants do now to stay prepared, if you have any tips?
There's nothing they can do except wait. And if they normally will do a second lottery, I think usually towards the end of July, so next month, if they do it. But again, as I said previously, I wouldn't get your hopes up because there are not very many slots given in the second lottery traditionally.
Okay, okay. But I think that's good. Thank you so much for your response. And folks out there, do not get disheartened, but wait. Let's just hope that things open up for some of you somehow. Anyway, let's take up some of our questions from our viewers who have joined us. I think we should not keep them waiting too long. So let's take up Ricky. If one is on H1B, should one persuade the employer to try the O1 route if it has any benefits?
Yeah, I mean, the O1 is certainly provides a way to get a work visa. The problem with the O1 is you have to be an expert in your field, and that's very hard to prove, much harder to prove now than it was 15, 20 years ago. Um, to go into the O1 category would take a while, but there's basically criteria of 10 different groups, and you need to prove 3 of those very well. So for example, if you've done a lot of one of them is like refereeing for like journals. If you can show that you've been invited to referee or to look at others' papers, but you can't just have done it like once or twice. You need to really have a good number of those. For example, articles that you've written with IT, which is the number one H1B, but in O1 you're looking at a lot of journals, whether it's IT, medical, whatever the field is. You really want to have a lot of Google citations. So sometimes folks are very brilliant, but they don't have they haven't been cited, maybe only 50 or 100 times. They do look at that. So those are like the weaker cases. If their work has been cited, let's say 500 to 1,500 times, then you're looking at a stronger case. The only way to really know if you have an O1 case is for an attorney to look at your resume, full resume, which includes all presentations, all your journals, all your work, everywhere you've spoken, conferences, things like that. If you have, the best thing to do is to put that in a very comprehensive resume, and someone like me can look at that and see if you have a legitimate O1 case or at least a solid chance of getting approved. But those
All
are
right.
not for everybody. Those are just the highest, considered experts in your field, and you have to really show that you're either nationally or internationally known as an expert in that field, whatever your expertise is.
Like exceptionally good. So thank you, Erin, for taking that up. And Ricky, we are going to take up more of your questions, but now we'll quickly take up Girisha's question. So if H1B applicant has prior visa overstays of 5 months, departed USA, does USCIS flag it now with Christine Wem's guidelines, or it can be addressed in DS 160 for consulate interview? If filed new H1B petition with new employer from outside the USA.
So I don't know that Christy Nome has implemented any new guidelines. I'm not sure what they're talking about there. That might be just fear mongering, because they do fear mongering of Trump. Everything that's Trump, they like to fear monger. But to answer your question, yeah, if you had an overstay and you have a new H1B and you're doing the DS 160 and you're going to have your interview, yes, please, you must disclose it on the DS 160. It'll ask a question, you answer it truthfully, explain what happened, the dates, and yes, if it comes up, then you gotta discuss it at the interview. Do not try to hide and overstay. That's the worst thing you could do, because then there's going to be fraud and you're going to be barred for years from the United States.
All right. All the best, Girish. And thank you so much, Erin, for taking that up. So let's take up Sunita's now. Sunita's asking, I've been following the H1B numbers closely and I'm concerned about the impact on my chances. Are there specific reasons why fewer people are getting picked? Is it because of a change in the lottery process or something else?
Okay, fewer people are not getting picked. The same amount of people are getting picked. The same amount of people have a better chance this year of getting picked than last year. So I don't know where it's who's saying fewer people are getting picked. It was 60,000 and 20,000, total of approximately 80,000. They select over 100,000 for those who, will withdraw, et cetera, or fraud. So it's exactly the same number of people getting picked, no less.
Okay. All right. Thank you, Sunita, for asking a question. And thank you, Erin, for taking that up. Now we got Mansi asking, doesn't the fact that an H1B visa is employer sponsored create a power imbalance, potentially leading to exploitation? Specifically, if an H1B visa holder feels pressured to accept lower pay or unfavorable working conditions that a US citizen in a similar situation would not tolerate. Can it be argued that they are being taken advantage of?
No. So first of all, as far as the salary goes, the employer offers a salary to the employee. The employee can accept the salary or not accept the salary or negotiate for a higher salary. U.S. employers have to treat H-1B employees exactly the same as they do American employees. So all the benefits that their American employees get have to be offered to the H-1B employee. So there can be no mistreatment of an H-1B employee in that sense. As far as salary goes, salary is always a negotiation between the employer and the employee, whether you're an American employee or an H-1B employee. That negotiation happens back and forth. With the H-1B, there is a labor condition application which protects the H-1B employee from the salary being offered as being too lower than the standard for that area. So that is already in place to help them. But, I've seen H-1Bs with very salaries much higher than the prevailing wage on the labor condition application in many times. It all depends on the company and, how they pay and what their guidelines are for their roles. But again, there's no difference between a company hiring an H-1B and hiring an American in terms of how they're going to treat that employee.
Okay. All right. Thank you so much, Erin, for taking that up for Mansi.
Mm-hmm.
We have more questions from Ricky, so let's take this one. My H1B is up for renewal next year. I haven't gone outside the US for the first time H1B stamping till now. For the first H1B stamping, it says. So, will I have to go for stamping before H1B renewal, or can renewal be done while I am in the USA?
Well, traditionally, you can't renew your visa while you're in the USA. I think he's talking. So keep in mind, you don't need to get an H-1B visa unless you're leaving the U.S. Some people, we have clients that have been in the U.S. for 10, 15 years and never left, and they just keep extending their H-1B and getting new approval notices. You really technically do not have to leave. But most people do need to travel, whether it's to go home and see their family or whatever. They just business trips, vacations. They want to get that H-1B visa. That is done outside the U.S. at a consulate. You do fill out your DS-160 online. You make an appointment. You go to the interview. You bring your approval notice and some other documents, and then you get the visa. There was a pilot program they announced a couple years ago where they're going to maybe start trying to do that from within the U.S., where you don't have to necessarily leave to get that H-1B visa. That certainly would be nice and save everybody a lot of travel time, especially if you're from India or China, which is a long way to go. But I don't think that's in practice. I think they did some samples with that, but I'm not sure where that program is right now. But yeah, if they do change that and allow some mass, some people from getting in great numbers from getting visas in the U.S., I think that will be very greatly utilized. I don't trust USCIS to implement anything smoothly, so it's good that they're doing a sample run here. So we'll see how that goes.
All right. Thank you so much, Erin, for taking that up for Ricky. And Ricky, keep commenting. I can see more questions, but we will take them up after another short break. It's time for another break. So, friends, today we have with us none other than attorney Erin Green, who is from EEG Immigration Law Firm. And, folks, uh, it is led by attorney Erin Green himself. So, he's an immigration attorney and an H-1B expert. So, please feel free to keep commenting with your questions with regard to H1B so that we can address them in this show. And don't go anywhere. I'm your host, Napasa, on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Nafasa, and today we have with us attorney Erin Green, who is an immigration attorney and an H-1B expert, and we have been speaking about H-1B picks are down and what's behind it, and should you be worried? And you should definitely go check out EEG Immigration Law Firm. Focuses solely on corporate immigration and is led by none other than attorney Erin Green himself. So visit this link, which you can see on the screen, and get to know more about him. So, yes, I think our topic is like H1B picks are down, but in the real picture, it not really is very down, right? So
No,
that
when you
is
say picks, you're saying that the number of applications are a little bit down. But not to be don't confuse people by saying, oh, there's less H1B cap lottery slots this year. There's exactly the same amount as there is every year.
exactly the same amount.
That's a little bit misleading.
I think that is what I wanted to clear up so that people don't get confused, because I think it was Mansi or Sunita asking something similar like that. But yeah, lovely to have you, for so patiently taking up each of our questions, Erin. And we have more questions from Ricky, so we'll just take
Ricky's
them
got
up.
a lot. No, Ricky's busy. Ricky's keeping us busy. Okay.
Yes.
Let's go, Ricky.
Can you give some idea on the typical processing time that you are seeing for I-140 petition, he's asking?
I-140s?
Yes.
Well, it depends. If it's like EB1 multinational manager without premium, those are taking a long time. We're looking at like 8 to 13 months before you get a first response. If you're talking about I-140, EB2 or EB3, I would say between 5 to 10 months, let's say, somewhere in there. They're a little bit more over the map, but for some reason, the EB1 multinational managers have slowed down tremendously over the past couple of years with their wait times. You can now do premium in that category, so that's good. But again, the premium is almost $3,000 the USCIS takes. It's a big expense for companies to spend that. A lot of them do because they have a lot of money, but it's still and also, if you really don't need it, so let's say you have an Indian born and the perm's been approved and now you file the I-140 and they have a lot of time on their H-1B clock because you've done it early. Do you really need the premium? I know people like to know, is my I-140 approved or not? But in a lot of cases, you can just do regular processing and save the company the money. I know that wasn't the question, but yeah, those are the approximate timeframes for those.
Yes, you already took up his next question, so there you go.
Oh,
It's already on screen. Yeah.
the
So he
next
was
question.
also asking, yeah, it was related to premium processing. So he's also asking if he goes for premium processing, how much will the chances of an RFE increase? For a pending NIW I-140 petition.
Yeah, it's hard to say. Some people think that if you do premium, you have a better chance of getting a quick RFE. Just because and I guess I have seen this. I can't really prove it, but I have seen trends where you do file in premium, and these adjudicators have so many cases that they just send you these boilerplate RFEs. I don't know if that's. I mean, that would be pretty mean if that's the practice to do that, and impractical to give people who are paying you $3,000 more of a chance of an RFE. I can't see that in practice, but I mean, yes, we do see sometimes that it's just like you send these premium cases in on an I-140, and then towards the 15th or 45th day or 30th day, whatever the premium time is, you get that RFE like that. It's hard to say. I wouldn't discourage anyone from doing premium if they need it. Again, if you don't really need it, then there's no reason to spend the money. Again, premium can be useful. We have a lot of H-1Bs, for example, who are close to their 6 years of H-1B time, and they just got their perm approved, and they need to get that I-140 approval so that they can get extra H-1B time. There's an example where you would need it, so you're going to have to do it anyway.
All right. Well, thank you so much for taking them up, and thank you, Ricky, for so actively participating. I hope you're happy with all of our answers, and don't forget to subscribe to our channel and also share and like our content with your friends and family out there so they can also join in to ask their questions. And subscribe to our channel. Our handle is at Immigration Talk Show. So I do have more questions, Erin, so I'll jump into them. How has the jump in registration fees, from $10 to $215, influenced employer behavior or application volume, you think?
Yes, I did. We touched about that earlier. We talked about that earlier, but it was really shocking to me that they went from $10 to over $200 just to enter the lottery. As far as my clients go, we haven't seen any impact at all. But again, my clients can be big $1 million clients, $1 billion clients, even smaller clients. They can pay the lottery fee. I think the whole point of that was to deter these job shopping schemes that were going on. And so, yes, as I mentioned before, if you're filing, 500 lottery submissions for, 10 or 150 or 100 people, look at the cost that you're getting by filing so much. So, yes, for the job shoppers, that can be a deterrent. So I would suspect that played a part in the reason why there weren't as many applications this year, and certainly multiple duplicate applications for the same person.
Right. So, but this has, you think, affected the smaller businesses? The bigger companies have still been.
I don't know. I think if smaller businesses know that the H-1B process is going to cost them anywhere from, if they make the H-1B, you're looking just between attorney's fees and USCIS fees, you're looking at, it could be anywhere from $5,000 to $8,000. So if they're willing to make that investment anyway, then another, $190 isn't going to change anything. If they're a legitimate company and they have a real need for an H-1B, and they're already accepting the fact and the costs of the process.
All right. Well, thank you, Erin, for taking that up as well. So now moving on to my next question, are you seeing a trend where companies are getting more selective about who they sponsor for H-1Bs now?
That's a hard question to answer because it depends on the company. If you're talking about big companies with thousands and thousands of employees, they will usually have processes written in place in their HR, in their guidelines for employees, where they have a set regiment of who can and who cannot. If you're talking about smaller companies who don't really have rules set in place, where they go just on a case by case basis, nothing's changed. I would assume that for the bigger companies, for example, they might say, if you're working we will not sponsor your H-1B until you're working for us for a certain amount of time. I don't see how anything would change this year, though. But that's a hard question to answer. Depends on the company, I would say.
Thank you. Thank you, Erin, for taking that up as well. So I do have a few case studies. Let's take them up. So this first one is about a student, who's currently on STEM OPT, was not picked in fiscal year 2026 H1B lottery. So their OPT ends October this year, and they are exploring day one CPT options. What risks should they consider before enrolling in another program, just to stay in status?
Yes, we did have that situation happen a few times recently where, the student doesn't get picked, and then they want to enroll in a master's or a higher, degree level. And yes, they can get the CPT. Before they enroll, they need to talk to the foreign student advisor of that school and make sure that the program that they're enrolling in will give them CPT. Sometimes it is on day one, and sometimes some of the programs won't give it to you until you're there for 3 months or 6 months, etc. So the most important thing to do is to speak with the foreign student advisor of the school that you're interested in and understand what their rules are for your degree study that you're going to do. And obviously your employer is counting on that. So you want to make sure that that's set before you invest in the school or enroll, etc. But yes, that can be helpful in the short term. We have had cases where students did do that. They used the CPT, they continued to work with the employer. And then, for example, maybe the perm was now pending for a year and we could apply for a 1-year H-1B, or, during that studies, we got the I-140 approved where we didn't have it approved before. And now we can apply for the 3-year H-1B. So it can be valuable in some situations.
Okay. Thank you so much for taking that up as well, Erin. And
Yeah.
This next question also is another case study. I would like to address that as well. So, a US startup filed an H1B for its only foreign engineer but was not selected. The company is now wondering if moving operations abroad temporarily is a better option than waiting another year. And what legal and strategic considerations should they keep in mind?
The question is a little weird. Are you saying that the whole company is going to move because one person didn't get selected in the cap, or you're saying they want to move the person offshore for a year, which is, yes, this is another way. If the latter, this is another way of keeping someone employed. If an American company has a foreign affiliate, not everyone does, but they can employ the person, let's say, in their home country or even in another country where they have an affiliated country. If they can employ them there for a year, not only will first of all, they will be eligible for an L1 potentially if they're a manager, or if they can accumulate specialized knowledge in that year of employment abroad with the company, or they've been accumulating it. Then after a year, the company would be eligible to file an L1A or an L1B for that employee, which is an alternative to the H1B. Or they're keeping the employee, and yes, of course, they want to apply for the H1B cap, in the next year when it comes. So you'll have both of those options while keeping the employee.
Thank you so much, Erin, for taking that up as well. And we have more questions from our audience on Facebook group, so we are going to address them as well. But it's now time again for another short break. So, friends out there, don't go anywhere. We are speaking with attorney Erin Green from EEG Immigration Law Firm from Dallas, and we are speaking about H1B picks. What's behind it, and should you be worried today? So, don't go anywhere because attorney Erin Green is an immigration expert and an H1B expert. So keep commenting with your questions. We are going to address them after this short break. Don't go anywhere. It's Mina Pasa on Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we have with us none other than Attorney Aaron Green from Dallas, and it's been wonderful having him. He is from EEG Immigration Law Firm, who focus solely on corporate immigration and is led by Attorney Aaron Green himself. We have been speaking about H-1B picks and what's behind the counts and should you be worried about it today. So it's been wonderful that Tony Aaron Green has been taking up each of our questions so patiently, and it's lovely to see all you viewers also so actively participating, especially Ricky and Girish as well, who has another question, and we will take that up before we take up our Facebook questions. So Girish is asking one more follow-up question. USCIS will not issue RFE for prior visa overstays or out of status. That is the question or a statement.
Um,
So
yeah,
is yeah.
when you submit an H-1B, a part of the application is to show them that you are and have been in status. So, for example, every H-1B extension or change of employer, you want to submit pay statements from we like to ask for the previous, let's say, 5 months, just to be safe, to show them that you have been working as an H-1B while you're in the U.S. As far as the previous overstay goes, USCIS, maybe it depends on how deep they want to get into your travel history. It's possible they can look into that. Those questions are usually dealt with at the consular level when you're getting your visa. But RFEs never cease to surprise me. Sometimes we'll get some weird ones or some different ones. So it's possible they could ask anything depending on how far they want to look into your record, your travel history, and things like that.
All right. So thank you so much, Aaron, for taking that up. And Girish, thank you for your question. We will address a couple of questions from our Facebook. So control, if you can please display them. So this first one is my H-1B visa interview was conducted on January 15th, 2025, and I was issued a 221G with the status showing refused. The case was initially created on January 13th, 2025, and has been updated on January 22nd, February 11th, February 18th, when my employer submitted the response, February 28th, and lastly on March 3rd this year. It has now been almost 84 days with no further updates since the last status change. What do I do next? And please guide me.
Well, in most cases, you can, or the employer or the attorney, or even yourself, can send an email to that consulate with the case number. You can go online and find the consulate, and sometimes they'll have instructions of how to use. Some of them have tools where you can basically make an inquiry online, or even the vendor will have that as well, meaning the vendor group who's transporting the passport back to you sometimes. But yeah, try to reach them by email is the best, and explain, give them all the information, put your, the day of your interview, your name, your birthday, passport number. If it's an attorney, he'll do that for you. if it's yourself, yeah, you can just ask them and then say, give them a little bit of the background. Don't make the email too lengthy or too drawn out. Just say specifically what the issue is and tell them how long you've been waiting. And hopefully someone will get back to you with an answer, whether it's on an email or in their internal processes where you can make inquiries.
I'm sure that'll be very helpful. Thank you so much, Attorney Aaron, for taking that up. Now, our next one, let's take it up. Control, if you can display, please. All right, I think there is an issue or something. Okay. So this is from Ashraf. Hi everyone. I'm currently pursuing my MBA in US, expected to graduate by December 2026. I plan to apply for the H-1B lottery in March 2026 while still on F1 status. Could anyone with experience in this process kindly advise me on eligibility to apply for H-1B before graduation, how to manage study and work timelines if selected, and steps I should take now to prepare? Any reliable consultant or organization that can guide me and help or recommendations would be greatly appreciated. Thank you.
Okay, well, you're an F1. The first thing you need to do is have an employer who's going to sponsor you for an H-1B. That's step one. Without that, there are no other steps. So assuming there is an employer that you're working for or will work for, and they're interested in applying for the H-1B for you, you mentioned that you're pursuing your MBA. So yes, technically, if you have an undergrad, you will have a 4-year degree. If it's a relevant degree, then an H-1B could be applied if the degree requires a bachelor's in that subject area. If it requires an MBA and you don't have an MBA by the time you're filing the application, then they're going to reject the H-1B application because you don't have the degree unless you have, the requisite undergrad degree plus years of experience. So be careful for that. We had situations when I worked at Infosys where we had some folks who they didn't have the degree yet. So they were doing their bachelor's, but they didn't have yet the degree. So we couldn't file the H-1B for them so from the date of filing, you should have the 4-year degree. So then you'd have to delay it until the degree was actually received. And I've seen RFEs where they get nitpicky, where sometimes you have earned the degree, but you haven't got the diploma yet, so you can't submit that. I've seen some RFEs on that years ago. But bottom line, yeah, you should have the degree, at least whatever the degree is required. And again, for H-1B, it's a 4-year undergraduate degree is required. The role must require that or its equivalent.
Well, thank you. And Ashraf, I hope that was very helpful. Don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram. And folks out there, thank you for joining us. Keep commenting. So now we have our next one. This is from an anonymous participant asking, I'm seeking assistance from anyone with experience in this matter. I'm currently in the process of changing my J1 visa to H1B status within the US without returning to my home country. I recently got married and my home country may be on a travel ban list. My question is, if I obtain the H1B visa, will the ban impact my wife's ability to secure an H4 visa, considering I do not plan to travel back home? And can the ban affect her H4 visa status if I have an active H1B?
That's a good question. So you're saying you're going to get your H-1B in the U.S., you're going to change status, but the wife is abroad. She would normally be entitled to just simply going to the consulate in her home country and getting the H-4 based on your approval notice. So the question becomes, what about all these new bans if they're not processing people from that country? That's a very good question. I guess we would have to see what country it is and what the ban is, if there is a ban, or what it says. In some cases, it may be possible to obtain H4 in a different country. We had a client recently in the Congo, but the consulate was shut down, so we had to send them to Angola to get an L2 visa, and the wait time there was a year. So you can imagine all the headaches and problems in some countries. But yeah, that's a good question. It would be hard for me to answer that without more information and specifics of the country and what the ban is and what it says and how it's being, processed in that sense.
But I suggest, anonymous participant, if you're watching this, do check out this link and, get the details for attorney Aaron Green. You can, consult with him and probably get more answers after you give him more details. So now this next question, if we can have on the screen, please. Well, that's pretty long. If Aaron, you can also read so that,
Okay.
those.
Yeah, I'll read it.
Sure. So, hi, I recently got married and my husband is in the US on H-1B visa. I'm working in US based multinational IT company. My company is planning to transfer me on H-1B or L-1B visa in late 2026. Before that, I am thinking of visiting my husband in US for a couple of months in late 2025 or early 2026. Our query is, which is the best visa option, B2 or H4 for me in this situation, considering approval or rejection, possibly, or other aspects, if any. I'll take leave for a month in my company and resume work once back to India. In case of B2 visa, should I update my passport with spouse name and then apply for a visitor visa, or is it advisable not to disclose marriage right now and apply for a visitor visa with my current passport? Presenting me as solo traveler while taking PTO from work. What kind of question can I expect during B2 and H4 visa interviews? Is there any risk in applying for a visitor visa, which is considered straightforward and safer option to get visa quickly? I'm planning for a short visit, so looking for solutions during this year till the time my company transfers me on work visa.
Yeah, okay. So here in this situation, it appears that the husband is in the U.S., the wife is abroad. I would apply for the H4 visa based on the husband's approval notice and the marriage certificate that she would have. That would be a lot better than trying to get a B visa where you have to show ties to your home country. And then when you have a husband in the US, that is going to raise a lot of red flags as to your immigrant intent, because not many people get married and live in two different countries, although it does happen. So yes, number one, I'd go for the H4, and it's pretty straightforward. The marriage certificate and the fact that he has been approved for an H1B would give you the right to get an H4 pretty quickly. That would be the smoothest way to go. They usually don't ask much on H4 interviews, but in this situation, they will see that you're married to someone living in the States while you're living, at least right now, abroad. They might ask about the dynamics of the relationship, but I mean, probably not. You just can explain everything to them about the situation. You have your job here, he's working there, but you want to go visit him. And yeah, the H4 would be for that. Technically, an H4 should be living and working and living and accompanying the H1B in the US. That's the reason for the visa. But in this case, even if you're going to go in and out for trips, I think it would be okay as well. So I would go for the H4 here.
Oh, there you go. Thank you so much, Aaron. For that was huge, but very clear question. So, and also a response from you, Aaron. So thank you so much. And I think with that we have covered most of our questions, especially from our audience who are watching us. Lovely viewers, I would say, with great questions. So do not forget to subscribe and please like and share, with your friends and folks who can also benefit from this content. And Aaron, before we go, we spoke about our topic of discussion for sure. But if you can leave our audience with, a couple of tips as well, maybe it'll be great. since anything with regard to corporate immigration or people with H1B, and who are worried about their status, what can they do? Just leave us with some tips.
Well, if you're an H-1B, you're pretty much in a good position in the United States. Um, as you know, H-1Bs can change employers. They are very, just like an American worker would be. They can be recruited and they can seek jobs. I've seen H-1Bs who've worked for 10 different companies in 15 years in the United States. Um, it can be a little bit frustrating because of the backlogs. Like if you're Indian born, for example, and you go through everything and you get an approved I-140, but still you're not going to have a priority date for years. You got to keep extending the H-1B. That can be a little bit frustrating, but on the other hand, you're still able to live and work just as you would if you had a green card. So there's really no downfall other than the fact that you don't have your green card yet. As far as any, the fear mongering that goes on because there's a new president and people say they're going to affect the H-1B. I've heard that left and right. A lot of unscrupulous immigration lawyers will try to scare clients into thinking that somehow the H-1B program is going to be harmed or reduced, or it's going to be harder. We might see RFEs uptick a little bit here. We'll see, in the sense that they want to verify things. But other than that, there aren't really many changes just because there's a new administration now. We've seen this administration before. We're seeing it again. They're very pro-business. In fact, I would say they're pro-H-1B as well. It would be nice if Congress could act and, help with the H-1B process, maybe the backlogs or more numbers, but that's a long shot because they're never going to come together and agree on some legislature in that respect. But to your average H-1B out there, yeah, I wouldn't worry about anything. There is a little bit of a downtick in the IT sector these days. There have been some reports that there are less numbers. A lot of these jobs are in IT admin, a little bit in engineering, and some people say because of the increase in AI that there's less IT jobs available. I still think there's plenty of IT jobs in our country that we can't fill even now. But yes, for those who are studying, make sure that you're studying relevant degree fields like computer engineering, IT, even anything in AI would be great. That's the future. One of the reasons why the United States needs so many H-1B IT jobs is because our students, American students, in many cases are taking just ridiculous degrees in liberal arts or just things that are just not philosophy, things that are just not useful or practical, especially as our world evolves into internet and computers and IT and how we've been going. So that's something to keep in mind. But yeah, for your normal H-1B out there, nothing to worry about. Just, keep going. Don't have any fear. And the H-1B program is working as it has been, as it always has been.
Thank you so much, Tony Erin. It was lovely having you. Such a pleasure and an honor that you took up all of our questions and you made time out of your busy schedule to be a part of our session here on Immigration Talk Show. So lovely.
Thank you for having me. It's always great to talk to you. Thank you
Thank
so
you.
much.
I hope you can join us again soon. I will keep in touch with you for
Looking
that.
forward to it.
Thank you once again.
Okay. All right. Thanks. Have a good day.
So, folks out there, check out attorney Erin Green from Dallas and absolutely check out EEG Immigration Law Firm, who's focused solely on corporate immigration and is led by attorney Erin Green himself. And also, if you have more questions or any suggestions or topics that you want us to cover, please feel free to get in touch with me as well. Or if you have any questions, maybe address them and I could take them up on our shows. My phone number where you can get in touch with me, call me, or WhatsApp me is 408-335-6444. And also, I have an email address. My email is nipa@staffingly.com. So check us out. And do not forget to subscribe to our channel. Our handle is @Immigration Talk Show. Ring that bell so that whenever we have discussions like these, you are notified. You can join us. You can participate by dialing in, by commenting, and check us out on YouTube, LinkedIn, Facebook, X, and on Instagram. Stay connected with us. And lovely viewers, it was awesome having you with your questions as well. Keep commenting. We will try to address them even after the stream has ended. So thank you and stay tuned on Immigration Talk Show because we have so much more content that you do not want to miss out on. It's Nipasa saying bye for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello and welcome everyone to Immigration Talk Show. I'm Napasa and I'm going to be your host for this session that is lined up. And I'm super excited today. I'm really thrilled because we are going to have this guest join us for the first time here on our channel, and it's going to be none other than Mikhail Arsentiev, one of the top immigration attorneys based in Los Angeles, United States. And he's widely respected for his work in US immigration law and is also known for his innovative contributions through the Skylex mobile app, which we are going to talk more about, by the way. And this app, which also helps streamline legal communication for clients and attorneys. So I think, of course, we will welcome our guest for today. But before that, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And now, without further ado, please help me welcome our guest for the first time here on Immigration Talk Show, none other than Mikhail Arsentiev. Hi, Mikhail. Good to have you. Welcome to Immigration Talk Show.
Ani Pasat, yeah, thanks for having me. I'm thrilled to be on the show, and thank you for the kind introduction.
Really, thank you so much. I mean, what I said is really so less. We would love to know more about you from you.
Oh yeah, definitely. So I'm an immigration lawyer, and I've been practicing immigration law all my life ever since I graduated from law school in Washington D.C. And then, and as you said, I like innovation. This is really my passion because my mom is an engineer and my father is a lawyer. So I like combining the two together. And we created a mobile application that you said that it streamlines legal communication, but it really solves one problem. is getting a lawyer and asking a question and getting an answer. Getting an answer from a lawyer, that's number one. You download the app, you ask a client, you ask an immigration question, and you get a response, and then you can get a call. You can send documents and really take care of your situation, regardless of where you are, in the world, or in the detention center, or somewhere in the U.S. So that's how it is. Yeah.
It's really amazing, really amazing. And in fact, I just had a look sometime back on the app, and it really looks very interesting. Folks out there, don't forget to check it out. Here you go. You can see on the screen. It's called Skylix, and if you are yourself, yes, definitely go check it out. And maybe Mikhail, if you want to tell a little more about this or how
Yeah.
to
So
navigate.
definitely, yeah. Skylex. Sky is a sky, and it lex is law in Latin. So it's like law connected through the cloud, through the sky, via the internet. And you download the app, and we have a chat bot that I created that can answer legal questions. And also, we have the 24/7 immigration support line. That's when people can ask questions, and then we just get them answers, and then you can reach a lawyer right away. Because number one problem in the immigration law, because the immigration is law generally is outdated. You still need to send emails and do office phone calls when you look for a lawyer. And then in the app, we have several lawyers and immigration consultants responding to clients' inquiries and really helping them with their questions and relieving stress, because immigration is stressful and people are very anxious about their processes, especially now when with everything that is going on.
So true, especially now than ever before. So, friends, please check this out, and really very innovative. What can I say? Truly a pleasure and an honor to have the founder of Skylix mobile app here with us today, Mikhail Arsentiev, who
Yeah,
is also
thank
an
you,
attorney,
Nicole.
by the way. Yes. And today, our topic of discussion is crossing the line. What happens when your visa expires or asylum is denied? So, folks, please feel free to join us. Best thing is you can also be a part of this webinar, this conversation, and that you can do by commenting wherever you're watching. We are live right now on YouTube, on X, on Facebook, and on LinkedIn as well. So check us out. We are at Immigration Talk Show on YouTube, and you can check us out on YouTube, LinkedIn, Facebook, X, and also on Instagram. So stay connected with us. And you can also dial in, by the way. This is our dial in number. You can see it on top of the screen. The number is 425-436-6335. And the access code when they ask for it is 988-888. So dial in, call us, and ask your questions. And Mikhail, are you ready for our questions?
Yeah, absolutely. I love answering questions, and this is the best way to spend our afternoon. I had a live event on Saturday, and it was a Saturday night in Los Angeles. And Saturday night, who wants to study and learn about immigration? But a lot of people do, because that's when they think about it and they're anxious. And so I love having live events as well. So definitely, immigration is my passion, and yeah, let's look at it. Yeah.
Really, really a pleasure to have you, and good to know, really. So I think, without further ado, I'll quickly say hello to Rudra, Kritika, and also Ricky. Thank you so much for joining us here on Immigration Talk Show. We are going to take up your questions. Stay with us for a bit. And quickly, though, my first question to you, Mikhail, is if you could tell us, what are the legal consequences if someone's asylum claim is denied and they have no backup relief application?
Yeah, well, if someone's asylum claim is denied, so we talk about two different asylums. We have an administrative asylum, and we have an asylum in court. So if someone entered on a visa and then applied for asylum and waiting for a USCIS Immigration Services interview, excuse me, then you can just your case is going to get referred to the court. And then you have another bite of the apple and present the case before the immigration judge. But basically, if then the asylum claim is denied by the immigration judge, then there is only one form of relief, which is you need to file an appeal.
All right. Thank you so much for taking that up. And how can one, file for an appeal? If you could just briefly tell us that as well.
Yeah, well, so an appeal is pretty interesting because it's very different from like a civil or criminal appeal. Because once you file an appeal, you have to, or well, I mean, lawyers mostly do that. It's very complicated to do it on your own. You can apply for a tourist visa by yourself, maybe even file a 589 form, right, the asylum application. But filing an appeal is very complex. Basically, we need to look for ways to find something in the judge's decision that we can question, right? That we can cast some doubt at, and it could be anything based on the legal concept. So it's very legal, and then we filed that appeal with the Board of Immigration Appeal. They're located outside of DC, in Falls Church, Virginia. But then something interesting is really happening because you wait forever. You wait for a very long time for that appeal. It takes about 3 to 4 years. However, recently it's gotten a little faster. Then the appellate judge is not scheduling a new hearing. You don't need to go anywhere else. It's all on paper. And then the judge is basically reviewing the decision, and he's reviewing our claims. And then he essentially sends a message back to the main judge saying, with his or her opinion. So in other words, he's not overturning the case, or he sends his like recommendations on a certain part of that decision, and saying, okay, judge, reconsider your opinion based with my recommendation, if that makes sense. So it's a little different from other appellate appeals that are being considered by other in other areas of law.
Very interesting it is. Thank you so much, for the detailed explanation, Mikhail. And I think, yes, we have more questions, so we will take them up. Now, my next question is, if someone facing deportation still requests protection under humanitarian programs like asylum or the TPS, the temporary protected status, can they do that?
Yeah, they can certainly do that. It depends also when that person is facing that deportation, because there are two places basically where we can be. It's either just out on the streets, like in the U.S., or in a detention center. Detention center is because mostly when someone faces deportation, the ICE picks that person up and puts in a detention center. And when it's not in a detention center, when it's not detained, then it's a little easier, because then we file the proof of a TPS, for example, or another form of relief, and then we basically first request like a pause on the deportation proceedings, and then we request to terminate the proceedings if there is, or put in or administratively close the proceedings. That's another thing. So these are all different like legal ways to close the case. However, always the judge has to make a decision, and if we have such relief as a TPS, it certainly works. If someone is in a detention center, it's a little more difficult, because we have to work with ICE, and then the ICE officer needs to release that person, not necessarily the judge. And that would work. TPS is a really temporary protected status. While TPS is essentially like enacted, then it can stall the deportation, but it will never give a green card to that person. It's a temporary protected status, so it's a temporary solution. If someone gets out of the detention center or out of the deportation status based on the TPS, it doesn't mean it's permanent. We still need to find a long-term solution for that person to obtain a valid status and a green card in the U.S.
All right. Well, thank you so much, Mikhail, for taking this up as well. And we heard about the humanitarian parole coming to an end. And now, what about TPS? Do you think this is going to survive as it is?
Yes, definitely. So I, you see, in order to understand the nature of the TPS and like the government fighting with each other, right? The courts and the administration and the Department of State, they, they fight and then see who is more important, right? So to speak, uh, who can do what within the government. But TPS is a temporary protected status. It's like a privilege. To by the United States government to certain countries, like a way to help the citizens of those countries that are in the US now. And who is an expert on the conditions, on the country conditions around the world? This is the Department of State. The Department of State gives a list or like knows what's going on around the world and enacts a TPS status, a TPS for certain countries. So the judges are not experts on what is happening with in all the countries in the world or in particular countries, and only the Department of State can do it, and the president. So it's an executive branch of power. This is my understanding of it that the courts can stall TPS, but then as we ultimately saw in the Supreme Court decision, they said that this is for the executive branch of the government. In other words, president and the Department of State were right, and they can enact and take away TPS statuses as they wish because it's a privilege. It's not a right. So with that, if there are severe country conditions, then TPS will be enacted. It's for the Department of State to decide who to give it to and from whom to take it away.
Absolutely. Such a clear explanation. Thank you so much for that, Mikhail. And I'm sure, yes, sure. You wanted to add something.
Well, it may be unfair, right, Nipasa? We may not like it, but I try to be impartial and only talk about the law. The U.S. government and the Department of State decides what to do. Yes, we might not like it, but if we talk about Nepal, right, their TPS was ended like last Friday, but the earthquake happened in 2015. So for 10 years, people who were affected, right, who Nepali citizens who were in the U.S., they had 10 years and they had a valid status and employment authorization. So
Yes.
if you look at some other countries that don't get anything, anyway, it's not for me to talk about fairness, was it fair or
True.
unfair, but from legal perspective, the U.S. government gave it. For 10 years, they extended it, and then they took it away. So they have the total right to do that.
Yes, absolutely. And it's only clearer. Thank you so much for that great example as well. And folks out there, I'm sure you're loving this conversation today we're having with attorney Mikhail Arsentiev from Los Angeles, USA. And friends, if you want to have a one-on-one consultation and maybe get help with your status as well, visit this link and get to check out attorney Mikhail Arsentiev. For now, though, we'll go for a quick break and we'll be back. Don't go anywhere here on Immigration Talk Show. It's me, Napasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Welcome back, everyone, on Immigration Talk Show. I'm Napasa, and today we have our guest, attorney Mikhail Arsentiev, who's one of the top immigration attorneys based in Los Angeles, United States. And he's also the founder of Skylex mobile app. You should definitely check it out. And the conversation is amazing. So thank you so much, Mikhail. I hope you're enjoying yourself.
Yeah, thank you, Nipasa, and thank you that you keep mentioning the app, because this is the only way to quickly ask for immigration help. People can download the app, keep it in their phone. It's totally free. And if something happens, if they get stopped at the airport, or if they have, get picked up by the ICE agent, God forbid, or anything else, they can quickly ask a question right inside the app. We also have an immigration chatbot that we developed based on everything that I've written and have said ever, and then we put it inside the chatbot, and it answers questions based on that. So yeah.
Thank you, really. And folks, don't also forget to subscribe to our channel. Our handle is at Immigration Talk Show. And yes, what you should do is also share this content with your friends and folks, because they're going to benefit from all this information that we've got to share today. So share now and subscribe now. My next question to you, Mikhail, is, how does expedited removal affect people who have recently arrived in the US but are now seeking asylum?
Well, Nipasa, this is a very difficult question, and has been many very important changes to that process just last week. Okay, and I posted several videos about it, and then the the top one question in comments I got, like, why other lawyers don't talk about it, and then just because they don't know yet. But basically, it's like really interesting. So in short, we have this CBP-1 application that the Biden administration used to let people in to apply for asylum. When I first heard about that app, I was quite shocked, because essentially it's an app that the government uh, created to help people, again, legally speaking, to break the US law, to cross the border illegally, and to get to the court system, right? So, and then at that time, people were saying, well, I have an app, and then it's like an invitation for me. And I was like, well, then you get a notice to appear before an immigration judge, and you have to see ICE, and then they can like, it doesn't sound like a good invitation, right? Like it's not that welcoming. And then many clients and people who just heard about that and used that, they didn't understand the nature of it, because CBP-1, you just get an invitation, you get a date to appear at a border, and then all of a sudden you're in the US. So it's great, right? So the Trump administration is questioning the legality of that, right? Because, and then again, it may be fair, maybe unfair. Let's not get into that. We just talk about the pure law. So he has a valid claim that how can one help make crossing the border, which is like essentially a federal, well, it may not be a crime, it's a misdemeanor, but in any way, it's a problem, right? It's crossing the border illegally without proper documentation. So that CBP-1 application was used, and at that time there was no it's really quite complex, but when they used it, the people were just allowed into the country with that, like without proper vetting. And again, we heard about a lot about from Trump during his especially before the elections, that he kept saying, oh, we don't know who actually used it, we don't know, the people were not properly vetted. And that's exactly what happened, because people used the CBP-1, they were allowed to enter, and then they were in the US. So now the administration is questioning it, and the new DHS, Department of Homeland Security leadership, saying we need to vet the people that entered, and many of them were giving an I-860 notice of expedited removal, and now they claim that they received it. So I just had a conversation with the client yesterday. She got a notice of dismissal. So I mean, honestly, it will take us an hour or 2 hours to cover that topic. But the gist of it is that the current administration is questioning the legality of the previous actions, and it uses legal tools to put people into the expedited removal process. And how can we understand the expedited removal process in simple terms? It's a way to vet people to get the fear interview. What is a fear interview? Is when you get called for an interview and a professional USCIS asylum officer is validating the legality or the the credibility of the asylum claims that someone has. So that's in short, that's what it is. But it's very dangerous. Many people can get affected of it, and it's very, very scary.
Definitely is now, especially now than ever before. If you talk about U.S. immigration, it has definitely been sounding scary lately, and has been making people anxious at the same time due to so many other reasons. So
Yeah. So essentially, you applied for someone applied for asylum, right? And then you get an expedited removal notice saying, "Well, we withdraw we close your asylum case, and we want you to appear for an interview with an ICE officer or with an asylum officer, where we're gonna do where we're going to do whatever. Like in other words, we don't know what's gonna happen to that person, and so when we have this ICE appointment, they can get sent to a detention center right away. Like, many of our clients are asking, should I sell my car? Should I pick up my stuff? And then we don't know, right? Because but legally speaking, again, ICE has an authority over the asylum seekers. At any point, they can do anything with their presence in the US. In other words, at any moment, they can put people in a detention center, absolutely legally. And there is nothing we can do about it. Many clients asked me, okay, can you go to the interview with me? Of course, I'm a lawyer, I can go with you. But even the candidate for the New York governor, what do you call it? Like someone who will be running for the New York mayor of New York got arrested in the immigration court. So he tried to prevent ICE people from arresting an illegal alien or like an immigrant, right? And he got arrested. So what am I gonna do if I go with you to an ICE appointment? Am I gonna fight the ICE officers? Of course not. Am I gonna present legal arguments to them? Yes, but who cares? They will still take people to the detention centers, and they will be right. I hate to say that, but they will be right because they have a legal way to take people to the detention centers as long as their asylum claim has not been approved. Before it's approved, it's in a pending status. So the ICE has absolute jurisdictions over those people presence. I mean, they cannot beat them up, right, or take their property away from them, but they can put them in the detention centers, and then the judge will decide what to do with them next.
Well, thank you so much for the detailed explanation. And when you spoke about it, just came to me that yesterday we had a viewer asking for those who have got deported, what is happening to their belongings, like their cars or their homes or things that were there in the homes. What is happening to those things?
Well, first, private property is like the basis of a capitalist society. So, regardless of the person's status, it belongs to that person. So it's just a matter. The government, I mean, it's unthinkable that it can do something with the property. Although there are talks about it now, right? However, it's just a logistical matter. You just want to have a friend or a neighbor or someone, pick it up and do something. I guess for like some valuable assets, like a car, perhaps. I guess again, it's hard for me to say that, but I would recommend have like a power of attorney to your execute a power of attorney to your friend or a neighbor or trusted person to sell your belongings in case you get deported. In other words, so someone can sell your assets.
Right. Well, thank you so much, Mikhail, for taking that up and for the detailed explanation. And I think, we should not keep our viewers waiting because they have a lot to say and ask. So Ricky says hello. Hi, Ricky. Welcome back to the show as well here on Immigration Talk Show. We are going to take up your questions. And I think we'll just, we have questions which are not related to the topic of discussion. Would you still like to take them up, Mikhail?
Oh, absolutely. Yeah, sure.
So let's take this one then from Rudra. Hi, I am a VAWA approved applicant. I had an interview on 4th February after my waivers approved. I have been in AP since the interview. I recently got a letter from embassy saying it should submit some documents on CEAC site. But when I log into my profile, there is no option for documents button. In the beginning, also, I had mail all documents to NBC via mail. So what should I do now? Should I contact to embassy for that, or I cannot able to submit documents online and ask for alternative way? Also, they have asked me to drop off my passport. Is that a good sign?
Mm-hmm. Well, yeah, it's a very complicated case. So, and a question. Uh, uh, if there is no button to submit, then she probably needs to send it by mail. But overall, it's hard. You know, the case has been going on for a long time. By the way, for those who don't know what WAVA is, it's a Violence Against Women Act. It's one of the unusual ways to stay in the U.S. and it's a very difficult one because it means some violence. You have to prove that some violence have been committed against you. So Rudra, if you want to, yeah, you can send me a message and send me some screenshots. I'll take a look, but it's not a simple yes or no answer on what to do. And filing an adjustment of status application may be one option as well.
Thank you so much. Yes, Rudra. And folks out there, if you want to contact attorney Mikhail Arsentiev from Skylex Law, do not forget to check out this link, which you can see on the screen. And let's take up Girish's comment now. But I think we will go for a short break. And Girish and Ricky, do not go anywhere. We are going to pick your comments right after being back from the short break here on Immigration Talk Show. We have attorney Mikhail Arsentiev, and today's discussion is a very interesting one. We are discussing on crossing the line, what happens when your visa expires or asylum is denied. So don't go anywhere. It's Nipasa on
Yep.
Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm Nipasa, and today we are having a wonderful conversation with none other than attorney Mikhail Arsentiev, one of the top immigration attorneys based on Los Angeles, United States. And he is from Skylex Law and a creator of Skylex app. So it's been great. And before the break, I have been telling you that we are going to pick up comments from Ricky and Girish as well. So, Mikhail, it's lovely having you. Really good conversation today and so much to speak about. So, I hope you're enjoying as well.
For having me, and let's get to some questions. We need to get more. Keep them coming, guys.
Yes, Ricky is asking, for those on H1B, is there a way to print I-94 separately, apart from it being mentioned on the H1B notice? Also, in what cases should one seek G28 representation required?
Also, what should G20? Oh, okay. So, when you file for a reparole, then your I-94 gets updated online. Last time I checked, there was no way to get I-94 separately from the approval notice. So, but I have never seen a different way to print it out. So just scan it. Some employers, by the way, don't give it away. So that happens. But yeah, there is. I don't know any other way to have the I-94 other than having it in the approval notice, and it's never really been an issue for us or any of our clients. The H1, the I-94 that you access online is probably the old one. The old one that is, that the initial one that you used to enter. So yeah, and then in what cases should one seek G28 representation? Well, as an attorney, I file G28 and I sign it, and this is for me to represent my clients. So I get to see all the documentation that the government is sending. So you don't have to do that, and nor your employer. So G28 is required so I can communicate, speak on your behalf, submit documents on your behalf, so you can do your work. This is why I'm here. You do your work, I do my work, and then so the government doesn't bother you and doesn't send you documentation. You don't miss any deadlines because they're sending it to me to my address, they're sending it to my email, and then I can respond. Even if you don't respond, you went on vacation to Dubai, as we just heard, and I still can work and submit paperwork on your behalf. That's what. So the G28 is not required. It's a convenient way for me to represent you.
Interesting. Thank you so much for that very clear explanation, Mikhail. Lovely. And now this next question is from Girish asking, after 6 months of filing U visa petition, departed USA and returned to home country. What happened to U visa petition?
Oh, the U visa gets basically abandoned. It gets abandoned. That means it's nowhere. That's it. You left the country. This petition is no longer valid. So U visa is probably the longest pending petition in immigration ever. Even the asylum cases are taking less than the U visa. So it's abandoned because that means if you left the US, you no longer need the U visa, you no longer need that protection. So you might want to find a different way to apply and to enter the US. So the U visa gets abandoned.
Right. Thank you so much for that. And Girish, thank you for participating. Folks, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram. Stay connected with us. Now, this next one is from Sonia asking, I've been waiting for asylum approval for a long time, and now my visa is expiring. How can I stay in the US legally while my asylum case is still pending? And what options do I have to avoid being out of status?
Yeah, Sonia. So it's quite easy. It's an easy, simple question because when you applied for asylum, you got a receipt notice, 589 receipt notice. This is evidence of your valid status in the U.S. When you receive that acknowledgement of the USCIS saying we received your asylum application, from that moment you are legal in the United States regardless of your visa. So you are legal in the US after 5 months of your 589 pending, after 5 months of that date when your application was received, and that's normally in the top left corner of the document. You can file an employment authorization and get an employment authorization card and work for any employer in the US while being totally legal in the country.
All right. Thank you so much, Mikhail, for taking that up for Sonia. And we do have more questions. And it's actually like a case study, this next one I have. And it's about Emma, who's a 26-year-old student from El Salvador. And she entered the US on a tourist visa and remained after it expired. So she later faced threats back home and wants to apply for asylum. But it's been like 18 months. She arrived missing the typical 1 year filing deadline. And now the question is, in a case like Emma's, where someone fears returning home but missed the asylum deadline, are there any expectations that could still allow her to apply? And what should someone in this situation do immediately?
Well, yeah, again, for those who don't know, when you apply for asylum, there is a 1 year deadline to do that. Basically, you want to apply for asylum within 1 year, within 360 days from the date of entry. Not from the date when the status expires, but when you entered the US, within 1 year, the government wants you to apply for asylum. If you applied after that, you can still apply, okay? You can apply and your application will be accepted and you will be issued this receipt notice that we just discussed with Sonia. You will be able to get employment authorization. However, when you get to the interview stage, it will be the very first question, why you haven't applied within 1 year deadline. And you have to have a very good explanation on what happened and why you haven't applied within 1 year. So in Emma's example, you have a perfectly valid reason for not applying, that you were not going to, you had, basically we can argue that Emma has plans to leave the US and go back home. However, she received those threats and we need to document the threats. Where are they? How did she receive them? Because she's in the United States. The threats are from a different country. She somehow got them in some kind of a palpable, verbal, or a written way of communication. Maybe it's a WhatsApp text, or an email or a phone call. So document that and explain it. So it doesn't mean that the application will be denied solely based on the delay in filing, but the immigration officer will determine whether this reason is legitimate or not.
Right. Well, thank you so much, Mikhail. That was really very interesting and a detailed explanation. Really great. I do have another question. This is also another case study, and this one is about David, who's a 34-year-old man from Guatemala, and has been living in the U.S. for 3 years overstaying his visa. So one morning, ICE agents conducted a workplace raid at the construction site where he works and detained several undocumented workers, including him. So he has no criminal record and was never previously, contacted by immigration authorities either. So the question is for individuals like David who are caught in ICE raids and have overstayed their visas but have no criminal history, what are the possible legal avenues to stop deportation or seek relief?
Yeah, so a very good question, and this is now up on the news, right? This is something that is happening to people that with the ICE raids, and going back in history a little bit. Imagine the laws have always been there. The laws that allow ICE agents and the government to detain people and deport people who are not legal in the United States have always been there, but they have not been enforced. In other words, ICE were, for many reasons perhaps, but then they were not enforced. That the ICE agents were not really looking for people who overstayed their visas and who entered the country illegally to deport them. And it's happening now, and people are surprised. But every country does that, actually, right? We talked about Dubai just now. Try staying in Dubai for overstay the visa in Dubai. Forget about it. That person will get kicked out right away and probably will never be allowed to enter. It's very strict. Try do it in China or India. Oh, that's it's gonna be people are gonna get in big trouble. But in the United States, it hasn't been enforced much before, right? And then people just come in, they work, and then they just remained in the U.S. without any problem. So now, when someone gets picked up by ICE without criminal history, there is nothing in the law that says that if you don't have a criminal history, you can stay as long as you want, or any of that. So he was legally detained, right? In other words, there was no abuse of power of any sort. If person does not have a valid status, ICE can get this person into a detention center and put that person in the deportation proceedings. Now, going back to the actual question, now what to do? We seek relief, a regular relief that this person could have gotten if he wasn't picked up by ICE, which is family reunification mostly would work if he got married to a U.S. Citizen or a green card holder. Then it is possible to obtain, to get out of the detention, and asylum. Really, these are the only two major reliefs that are available to most people. And the TPS as an exception would work as well if that person is from Ukraine or from some of the other countries, such as like what is still some TPSs are still working. So yeah, basically those two types of reliefs.
Well, thank you so much, for taking this up, Mikhail, and very rightly put. I think very clearly explained. That's all I can say. And folks, I hope you're enjoying this conversation and you're able to take a lot from this webinar that we're having today with Attorney Mikhail Arsentiev from Skylex Law, and also the creator of Skylex app. And don't go anywhere, because we're going to speak more about the topic of discussion for today. And it's a very interesting one: crossing the line. What happens when your visa expires or asylum is denied? And we are going to take up more of your questions, so feel free to keep commenting. Or yes, you can also dial in. By the way, the number is 425-436-6335, and the access code is 988-888. Don't go anywhere. We'll be right back here on Immigration Talk Show. It's me, Napasa.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Welcome back, everyone, on Immigration Talk Show. I'm your host, Napasa, and today we have a very, very important guest, who has joined us for this first webinar here on Immigration Talk Show, none other than Attorney Mikhail Arsentiev, who is from Skylex Law and creator of Skylex app. And he's based out of Los Angeles, United States. So it's been awesome today, because we have been speaking about this topic of discussion: crossing the line. What happens when your visa expires or asylum is denied? We do have more questions to take up. And Mikhail, it's really awesome having you today.
Thank you, Nipasa, for having me. I'm enjoying this conversation very much.
And Girish is back, with a follow-up question. He's saying 5 months of out of status. If apply new H-1B or L-1 visa from outside USA, will those be approved by USCIS? If approved, stamping will not be issued in consulates.
Yeah, very good question, Girish. So again, I want to explain the background first and then answer the actual question, because if I just say yes or no, or this is what you do, you might not understand the full scope of the law and of the background. So it's the U.S. law has a certain punishment. I mean, any law has a punishment for certain wrongdoing, and in America, if you stay in the U.S. for less than a year out of status, less than a year, it doesn't basically it's not a big deal, and it doesn't trigger any bar. So in this case, you have overstayed for 5 months. It's not gonna affect you in any way. It will create a bias against you at the embassy, but for the H-1B or L-1 visa, that's normally not a big deal. So 5 months is not does not trigger any type of inadmissibility or in other words, it doesn't trigger a punishment that you cannot enter back. And the H-1B and L visas are generally there dual intent visas. That means you can have an immigration intent, and I don't think there will be any issues for the H-1B or L-1 visa. Now, for tourist visas, that certainly can create a big problem, but not for H-1B or L-1.
All right. Well, thank you for taking that up. And Girish, thank you for commenting again with your question. But Mikhail, we have questions from our Facebook groups as well, and we are going to take them up. So, Control, I request you to please display them on the screen. All right. This first one is, my husband and I recently attend our marriage-based interview with USCIS. The next day, our I-130 petition was approved. However, USCIS informed us that we need to withdraw his pending asylum case before they can proceed with his I-485, the green card application. Is it safe to withdraw the asylum case at this stage?
Yeah, very interesting and a technical question. So, for other viewers, basically, you applied for asylum and waited for asylum. During the course of waiting for an interview, she's a husband, right, got married to a U.S. citizen, and then they applied for a green card. In order to get a green card, an interview is required. So they went for an interview, and then they were told that they need to withdraw the pending asylum case before they can proceed. So if USCIS requires that, there is no other way, because they're not gonna issue a decision on your case. So I would recommend here going with the USCIS guidance and go ahead and withdraw. So if we would, however, I had some clients that withdraw it beforehand, but on their own, and that's an issue, because if you withdraw, you have no other basis to remain in the U.S., and then you basically get a notice to appear before an immigration judge. In other words, your case goes to the court system, which is not a nice place to be. So I think it's safe to withdraw here. And in any event, if something bad happens, marriage to a U.S. citizen can solve any problem. It's just a matter of time.
Thank you so much, Mikhail, for taking that up. And let's go on to our next question now. This is also from an anonymous participant and is asking, has anyone filed Form I-485, the adjustment of status through marriage, and Form I-130 while having a pending asylum case? Does this make the process slower? I would like to know the experience of those who have these three cases active simultaneously. Thanks.
Well, yeah, sure. I mean, what else to do? I-130 is definitely a must-have here, because if you get married, you want to file an I-130. It does not affect the other applications at all. 485 and asylum, that's these are actual requests for a green card, essentially, right? Both of them. I mean, it's a very common situation. What else can you do? While asylum is pending, you file 485 and then go with the USCIS guidance. Most of the time, they approve the case, actually, and then you get to withdraw the asylum claim after the 485. The 485 is approved.
All right. Thank you so much for taking that up as well, Mikhail. This next one is also from an anonymous participant asking, has anyone been stopped by ICE? What do you show them if stopped? My lawyer said the pending case letter where they approved it and shows we have to be here, but will they respect that?
Yeah. So, if stopped by ICE, what to show? So, having a letter from a lawyer that says the pending case uh, approved it. I wonder what it says. Where they approved it. I don't know what that is and what was approved, but a letter from a lawyer is good, but you don't have to have one. Uh, you can have your I-94 form if you're in a valid status. That would solve anything. And also, if you have a work permit, having a work permit, a valid work permit, is a good document. If your case is in the court system, then having a letter saying that you're waiting for the court, not a letter, but essentially like a judge's order, or at least a screenshot from the Department of Justice websites that shows your uh, A number, and it shows that your case is pending. In other words, it doesn't say deportation there. So that's what you can have. And as a bonus, I would recommend that everyone has a green card holder or a citizen friend who can help us and potentially become your sponsor and help us get you out of the detention center. And I recently posted a video where I recommend that people put these questions in, put these documents on the cloud somewhere, right? Google Drive or Dropbox, and send a link to their loved ones or to me. So I'm not going to open it, but if you get picked up by the detention, so that you can call our office, and then we have access to all your documents, and we can right away get working on your case, and downloading the app and putting it, sending it in the support would be the best option to utilize.
Thank you so much. And folks out there, if you want to contact Attorney Mikhail Arsentiev to help, with some guidance on your case or your status, please visit the link which is displayed on the screen. And now, this last question from our Facebook group, Mikhail, is my case status until yesterday was saying next step is an interview. And today it says your application is pending. What does this mean?
I don't know. I don't know what that means. It's strange. It's unusual. It means they took some action on the case, but we don't. I don't know what that means. Normally, it says your next step is an interview. It could mean that you will get an interview notice pretty soon, but it doesn't have to be that way. It may be a glitch in the system with the asylum cases. It's just anything can happen. So we don't know. Just wait and see. But I wouldn't expect. It depends on how many years you've been waiting for your asylum interview. If it has been more than 5 years, 8 years, 9 years, I would say that probably means you should get an interview notice pretty soon. But if it's less than that, it doesn't mean much. Yeah.
All right. Well, thank you so much, Mikhail, for taking them up. And we do have Shalu. I wish I could understand what you're saying. Well, Shalu, I think you will need to, maybe at least frame a sentence or a question and let us know what you're trying to say. But good to have you. Do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. This goes out to all viewers out there. Also, share our content, like our content, because there's so many folks out there. There are folks out there, your friends and family, who could benefit most. So, yes, Mikhail, it's been lovely. And I do have more questions. So, my next question is, if someone stays their visa due to delays in processing or job loss, what legal options do they still have?
If they experience a job loss,
Yes.
on what type of status? On H-1B
So
or
someone
something?
overstays their visa due to
Oh,
delays in processing or a job loss. So
oh,
if it's someone like that, what do they have to do next legally?
well, if yeah, mostly H-1B. So if we got let go of our job on an H-1B, we need to super quickly find an employer. who will file a petition to transfer that visa to a different employer. So, a practical advice, legally speaking, you just need to file a new petition. I would not recommend filing an asylum in that situation. That has very little chances of getting approved. And if it gets closer to like 6 months, I would recommend leaving the U.S. and applying for other jobs from outside the U.S. And the last option, perhaps, is going to student status. So to go to a language school or a university to study something, and then basically you go to and you change your status to an F1. You enter into a program, you study there, and you keep applying for different jobs, I guess, right? But there is no employment authorization at that point, so this person cannot work anymore. But in an F1 status, you are valid in the U.S. You are legal. You do not accrue unauthorized period of stay. In other words, you're not illegal. And then when you find a different job, just have the new H-1B filed and transfer from the F1 back to the H-1B. Yeah, we've done it many times before. It happens. Again, it just takes some money, because no school would issue an I-20 that is required for the F1 student status for free. They will not issue it for free. They will want money for that. But it is a workable solution. We've done it many times before.
All right. And folks, if you want to contact Attorney Mikhail Arsentiev, check out this link which is displayed on the screen. And Mikhail, I just would like to know how much more time you can be with us, so I know how many questions we can take.
Yeah, well, 5 or 10 minutes we can certainly do. Yeah.
That's perfect. All right. So my next question is, what should immigrants do if they receive, an NTA, a notice to appear, after their visa extension or green card is denied?
Well, a notice to appear. What is a notice to appear? That's a hello from an immigration judge. That means the judge wants to see you. And it doesn't have to be bad, but it's definitely not pleasant. That means you're in the deportation proceedings in the court system. And number one thing, one has to comply with the notice to appear. The notice to appear says the date and time and place where an immigrant must go, really. And that's what the person needs to do, just to go to that court and appear before the immigration judge. The best thing definitely would be to contact us and ask. We will enter the court system, because I can enter the court system and see all the case history, everything that the notice to appear has. Also, it has the charges that are claimed against you. Basically, it says you are accused of this, and that. So it already will state what's the reason and what the court wants to do with you. So, but we can see the procedural history in the court system, why it was done, because ICE are the ones who can initiate the removal proceedings against immigrants. So yeah, going to the court, contacting us, and figuring out, but definitely not missing the court hearing.
Definitely not. So thank you so much, Mikhail. And, again, I would like to say, folks, so you can check out Attorney Mikhail Arsentiev on this link, which you can see on the screen scrolling. And yeah, there it goes. Go check it out. And my next question is, can joining a protest or rally affect an immigrant's legal status, even, if they are peaceful and fully documented?
Well, this is the First Amendment, the freedom of speech, right? Probably the country where freedom exists, and people can openly express their political or other opinions. I think that joining a rally would not affect an immigrant legal status if they're peaceful and if they're fully documented. But if you get, but being next to the people who are burning way more cars and throwing rocks at the police is not a good place to be either. So yeah, like I mean, no one would want to be there, right? I went there just to see, and then, but I wasn't like in the middle. I just went downtown and wanted to see what's going on, and I shot a couple of videos there, but I was not participating, right? I just saw the people waving Mexican flags and saw the ice and the helicopters and everything. So it will not affect the status if you're not doing anything wrong, basically. And another thing is not just the anti-ICE protests, but the anti-Israel or pro-Palestine protests. This is another very important topic. So
Yes.
Just going to a peaceful protest is fine, but you see, with the Palestine, there is also some very slim, like a they have to be a balance between, like, anyway, it may be with the case of Palestine, it gets a little complicated, right? Because of all the violence that also happening recently. So it shouldn't affect just a peaceful rally shouldn't affect, but in some cases it can get complicated.
Right. Thank you so much for bringing that up as well. And folks, thank you. I hope you're enjoying this discussion. I do have maybe another couple more questions before we leave.
Mhm.
So, this next one is what should someone do if they receive a call or a message from ICE asking them to report in person without clear instructions?
To report a person.
Yes.
Well, report in person. Okay. So at first I thought to report a person, that someone wants
In
to
person.
say, hey,
Sorry.
do you have illegal alien neighbors? Can you report them to us? No, a call or message from ICE. So I would say if someone receives a call like that, that person knows where to go and what to do, because every asylum seeker who is like in this like ICE supervision type of program, they know their officer, and then that officers make calls them once in a while. I think randomly, it's unlikely that someone would receive a call just out of the blue. They would probably receive some clear instructions, and they would know where their ICE office is. But generally, it's done with a written confirmation. So generally, it's in writing, and you want to wait for a written request, a written ICE appointment notice. But it can be in call as a call as well. So I would just ask when to go and where.
Yeah.
Again, I would not recommend messing with ICE.
Yes, for sure. Well, thank you so much. Now, I have another question, and if you could tell us, are there any lesser known forms of legal relief available for those facing
Oh,
deportation who don't qualify for
oh,
asylum?
yeah. So those who, I like one way that people don't know, and this is actually a religious worker. If we have clients who are, Sikh temples and some gurdwaras and Hindu
Mhm.
temples, uh, people who work for them as priests, or it doesn't have to be even a priest, and that's what most people don't know. If you work for some religious organization, and such as a Hindu temple and others, you might qualify for certain immigration benefits. The employment has to be full time, and it has to be religious in nature. You don't have to be an actual like priest, but you need to be someone who works with the priest, like an assistant, or like the choir director, or a teacher of kids or like a religious teacher, right? Maybe for the children. And then this is a category that most people don't know about it. I posted one video about it, and I got like, almost 1 million views because people just have no idea. And I got so many requests on that, like, hey, I actually work for a church or for a temple all my life, but I never knew that I could do something. Like, yes, if you have if you are a formal member, if you have some teaching, it doesn't have to be a 5-year theology program, but it can be some teaching that is acceptable in your denomination, in your religion. Then and then you actually work it a certain established temple. Then this can be utilized as well. It's a very rare way to obtain a green card, but a lot of people do that, and we have many clients who are for whom we successfully filed visas and green cards.
All right, very interesting. Thank you for sharing that as well, Mikhail. And I think this brings me to my last question before we leave. And if you could tell us, what documents or legal steps should someone prepare ahead of time, just in case they face sudden immigration enforcement because of the situation, especially right now here in the United States?
Well, so putting all the documentation in one drive or one folder online, and sharing that link with us and with your family members, so they know what to send an attorney is best. Because when we quickly need to assemble an asylum claim or something else, it's really difficult when you are in a detention center, and it's hard for us to gather evidence. But if you do it in advance, put it all in one folder, all your employment authorization documents, just the pictures, right? I-94 forms, the I-20 forms, the H-1B approval notices, all I-797 approval notices and receipt notices, maybe some criminal history documents. Put it all in one file. It will be much easier to deal with, and we can faster help you. And downloading our Skylex app is very important because it's on your phone. You can at any moment, you don't have to use it right away, but if something happens, you can quickly send a message. Even if we can't respond right away, if it's 5 in the morning or something, we will respond faster. And if we have a link to all your documents, then we will have your A number, we'll have your location, and the rest we can quickly do because we can find you where you are, which detention center you're at, or where you placed. And then from there we can contact the ICE to work on your release.
This is very, very helpful. Thank you so much, Mikhail. Lovely conversation, and thank you so much for patiently and for, taking up each of our questions, explaining them so clearly to all of us. It was really lovely having you today on our show, on Immigration Talk Show.
Okay, of course. Yeah, thank you very much. Are we ending now?
Yes, I think I'm done with most of my questions. I wish we could go on and on, but we should meet soon.
Good.
That's all I can say.
Yeah, definitely. So in conclusion, I would just say that people get very anxious when they hear the immigration news, and I would say, don't pay attention to the immigration news. Most of them are very complex, and they're just speculative in nature. These are speculation. The CBS News reported that the Trump administration plans to deport 300 aliens. They plan to give ICE vacation to the farmer workers. Then 4 days later, it's no longer the truth. Then someone else sued, and stole the deportation of this and that. Then we hear that, ICE still put people on the airplane and they still deported them to Sudan or whatever. So it's just noise. It's so irrelevant. I recommend that we just comply with the laws, don't do stupid stuff, and just pay attention to our jobs, and don't pay attention to the immigration news. Download Skylex, and we have also a educational channel there where we put the most important information. And then definitely subscribe to the Immigration Talk Show. But then all these just random articles and videos, the media is just exaggerates that, and then they just take advantage of us and make money on the ads, so we don't want to pay attention to them as much.
Absolutely. Well, thank you so much. I think very, very rightly put, and was very relieving, listening from you as well. So I think very much those tips are to be followed, viewers out there. And thank you so much, each one of you, for joining us. Mikhail, I really hope to see you very, very soon here again on another episode. Maybe we will discuss soon, on another topic on Immigration Talk Show.
Yeah, definitely. Yeah. Thank you very much, Nipasa. I'll see you next
Thank
time.
you.
Bye-bye.
See you soon. Yes. Have a wonderful day. And folks out there, do not forget to, also check us out. We are Immigration Talk Show. Our handle is at Immigration Talk Show. Check us out on YouTube. Subscribe to us. Ring that bell so that whenever we have discussions like this, you are notified. And feel free to also contact me if you have questions or anything you want to ask or suggest. This is my number, 408-335-6444. This is also my WhatsApp number, and you can also email me. My email address is nipa@staffingme.com. And I hope you had a wonderful session today with us. Do not forget to share this with your friends and folks out there who would benefit most from our content. And check us out, not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram to stay connected with us. And don't go anywhere. Stay tuned on Immigration Talk Show because there's a lot more coming that you don't want to miss. It's Nepasa saying bye for now.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose Emmy support.
Hello, everyone, and once again, welcome back to this very important and very exciting webinar that is lined up just for you. I'm your host, Sam, and you're watching Immigration Talk Show. And before moving ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. All right, friends, once again, welcome back everyone to Immigration Talk Show, and it's me, your host, Sam. And we are also live on YouTube, LinkedIn, on X, and do follow us on LinkedIn, Facebook, X, and on Instagram as well. Also, don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And talking about today's topic is again very important and a very timely one. That is O1 visa for tech professionals. Is it worth exploring? So, whenever a tech professionals think about working in the US, the first thing that comes to their mind is H1B visa. And along with it, the stress of lotteries, long wait times, and limited chances. But what if there's another option? That means no lottery, no long wait, just a chance to shine. And that's where the O1 visa comes in. It's lesser known, but trust me, it's incredibly powerful. And if you don't know what it is, who can apply for it, and what is the whole process, then this is the platform that is right for you. So watch this session till the end and also participate here as much as possible because the guest who is going to join us has an expertise on O1 visa. None other than, let me introduce him, immigration attorney Ralph Antonioli, who has 20 years of experience in the US and Latin America. Also, he's a strong advocate, a great communicator, and a passionate supporter of disability inclusion in law. He's been named as a top lawyer, featured in Who's Who in America, and honored with the Worldwide Humanitarian Award. So, hi, Ralph, and thank you so much for being here. It's been a long time, and welcome back once again to Immigration Talk Show. How are you doing today?
Good. How are you, Sam? Thank you so much for inviting me over here. I'm glad we can talk about this important topic, especially during this time when there is a lot of misinformation. So hopefully we can, clear the air for a lot of your viewers and, also demystify the fact that O1s are not just for superstars like people think, and that, with proper preparation and a good lawyer, you can actually get an O1. So let's get going.
Wow, that's super exciting. And I'm sure our viewers are also really excited for this session. So, friends, go ahead. Don't forget to like, share, and subscribe to our channel. We have so many important information to unpack in this webinar. Hope you'll enjoy. And also, the best part is that you can also get in touch with attorney Ralph Antonioli. You just have to visit this link and you'll get the contact details of him. Okay, and with this, Ralph, if you can let us know, some brief about what O1 visa actually is, then that will be little helpful for our viewers.
Yes. So the O1 visa is a non-immigrant. First of all, it's a non-immigrant category, sort of like an H1B. The O1 visa is not a green card. The O1B is sort of a work visa that will allow you to work in the United States for an initial period of 3 years, and then you can extend indefinitely for 1 year increments. So what is it? It's a visa that it's reserved for people who can demonstrate extraordinary ability. Extraordinary ability is a word of art here. It doesn't mean that you have to be a superstar. That's why at the beginning of the show I said that when you see extraordinary ability, it can be a little intimidating, but it's that's not the case. In the case of tech professional, this being extraordinary ability simply means, not that you're just good at your job, but you are probably among the best in your field. That's really that's really what you're showing. To keep it short, current law requires that, there are two ways to get an O1 visa.
Mhm.
One is if you have secured a big award, for example, like a Nobel Prize or um, like an Oscar. I mean, we're talking about technology, but I'm just, like a huge award in the industry. If you don't have that, then you go to the second option of how to get the O1. So there, and we're going to focus on tech professionals. Um, what you're trying to show here is that you're just not good, but that you stand out in your field. That's sort of and how do you do that? The immigration law provides um, an avenue, which is the O1 visa, and for people to, and which is the most common way for people who do not have a, like a major award, or the U.S. law provide 8 categories that you may choose from to demonstrate that you are an extraordinary ability individual.
Mhm.
Uh, there are 8, like I said, there are 8 categories. The law only requires that you show 3. From a practice perspective, I usually recommend clients to at least meet 4 or 5 if they can. In the event that USCIS does not find that you meet one, then you have another one to fall back on. You know what I mean? So yes, the typical route for a technology professional will be to meet at least 3 of the 8 um, criteria that the U.S. law currently provides, so you can meet the extraordinary ability definition. So that's really the goal. You don't have to show that you're a superstar. You don't have to show that you are in Forbes magazine, or you're in you got all these awards, that you are like super famous. I mean, we're going to talk about that later, but being famous has nothing to do with the O1. With the O1, like I always like to tell my clients, it's sort of like a statutory dance. You just need to meet. You need to have a good lawyer, and you need to be creative. And I think that's where tech professionals will come in, because to be successful as a tech professional, you have to be creative. So that's basically what the O1 is. It's like you also sort of indicated, this is a way for people to find employment in the US, but not have to worry about like the H-1B cap. That's the major difference, because
Yeah.
the H-1B caps only comes once a year. um and but the O1, as long, again, the caveat here is you have to meet the definition of extraordinary ability, and I explained how you do that. You have to meet certain criteria. So that's basically how the O1 works. I'm going to be saying this a lot today. Uh, Today, as you can imagine, there is a lot of uncertainty in the immigration law, even in the U.S. economy and everything you can imagine. We're not here to talk about that. We're here to tell people how to navigate the current environment. So that's really our goal. Yeah, so that's really what I have for as an introductory. I see that there are questions coming in, but we're going to focus on those a little bit later.
Sure, absolutely. And I have so many questions for you, Ralph, but thank you so much for explaining what O1 visa is in a great way, and absolutely very well said. It's not only for superstars, it is basically for the people who are creative, right? So I think that's great. And I'm sure our viewers are understanding what O1 visa and having a great background about it too. So also talking about some educational qualifications, Ralph, because you have said that they have to be creative, they have to be best in what they do. So what about the educational qualifications? If we talk about H1B, they need to have certain background, right, in terms of education. What about O1
Well,
visa?
O1 visa, there's technically no educational requirement.
Wow.
I mean, of course, it helps because you can, like I said, you have to meet at least um, at least three of the eight categories that the U.S. law provides for to meet an O1 visa. Um, but education is not a priority. Sort of like as opposed to the H1B, where you have to show that you have a bachelor's degree that is
Yeah.
related to the to the field of you know to a particular field that you're in the field you're going to work on. So that's not an issue and as we're going to talk about also here is there is no prevailing wage like there is in the H1B. So the O1 sort of lends itself for employers to sort of maneuver around salary requirements. And again, like I said, education, I'm not saying it's not important, but it's not a um, make or break like in the H1B scenario. You can definitely use your education to meet one of the requirements, or
Mhm.
to sort of artfully. But again, education is not a threshold requirement. I mean, again, you can use it as a strategy, but that's not. I mean, the O1 is really not focused on education, rather on whether you can meet the definition of extraordinary ability. Okay.
Okay, I think that's another very challenging thing because when you are doing a course, like for example, if you're having bachelor's, but on the other hand, you need to have extraordinary ability. So that becomes more challenging and more difficult to prove that why you are such a good one, right? With education,
Mhm.
it's pretty easy. You can study, you can score, but in terms of extraordinary ability, I think that becomes more challenging. And that's how
Yeah, I
these.
mean, I mean, if I may add, I think
Sure.
the H1B is sort of aimed at newly grads. So, if you have a bachelor's and you just graduated, probably
Mhm.
the H1B is probably your best bet. You don't have a big portfolio yet, so you can qualify as an O1. So, you know, that. I mean, that's just how it works. And what it's typical in the U.S., right? Yes, you come here on an F1 or whatever it may be, you get your bachelor's, and then you do your OPT, and you do your depending on your if you do understand OPT or whatever it may be, and then but yeah, I just want to clarify that the O1 requires a little more work. It's not
Absolutely.
impossible, but it requires a lot of strategy.
Yeah, it does. And with that, I'll say, friends, it also requires expert advice and the right guidance. And it is very important to have the expert advice right now. So please go ahead and get in touch with attorney Ralph Antonioli. You just have to visit this link that will be visible on the screen and you'll get the contact details of him. Okay, and with that, I can see Ricky is also here. Okay, Jay is also here. So, Ralph, we are getting a lot of engagement in this session. I
Yes.
think people are really interested in O1 visa. So, it's really great. Jay, Rudra, Yuri, please stay with us and stay connected. And also, if you haven't subscribed to our channel yet, then please do it right now. Okay, let me go ahead with my questions, Ralph, that I have for you. That can
Yes.
awards or patents help you get an O1 visa? And also, how much do they matter?
Well, awards and patents, again, they're helpful, but they have to, again, you have to be strategic about it. Um, just because you have an award doesn't mean it's automatically going to qualify you for an O1 or to meet with the awards um, criteria for O1s. The awards need to be nationally or internationally recognized. So, for example, to keep it very simple, like a generic employee of the month is not gonna cut it. Um, you have to show that the award is distinguished and selective. So you need to sort of do a little bit of homework and kind of um, spell out how is this award given. So if the award is given to almost everybody, that's probably not going to be enough. But if you got the award because of publications or because of work you've done in AI or in machine learning or whatever, yeah, the award um, has to be given based on something you have done. So that's one of the criteria. And the same thing with patents. If you have a patent that has been granted, probably the best way to show is that that your patent's being commercialized, for example, or that it's been cited by other people in their work, or that it's been adopted in the industry. So, for example, if you develop certain language that is being used industry wide, that goes a really long way. So, at the end of the day, awards are one of the criteria. Again, you have to meet at least 3 out of 8. I'm happy to give you all 8, but I think if we go question by question, you will probably get a better understanding of how they work. One of these criteria, as I've said, is awards. As you may recall at the beginning, I said if you have an international, highly recognized award, that's probably all you need. But I mean, the chances of someone in the tech industry having a Nobel Prize, that's pretty slim, right? So, um, but again, if you do, I mean, that's all you need. Yeah, so that's basically how patents and awards. At the end of the day, you have to do a objective analysis rather than subjective analysis. You have to, and what I always tell clients too is a lot of the USCIS employees, when they look at your application, they don't know anything about you. They don't know anything about what you do. So it's your job to basically tell your story. Tell them why you are an extraordinary ability person, and you go through what the law says. You go step by step, and and I think we're going to talk about this a little bit later, but I do want to emphasize that in today's environment, you have to include, and this is not only for O1s, you can also, it's also good practice for H1Bs or any other, like, what are you bringing to the United States? Why is it that because, now everything is focused on America first. So that means, okay, I am really good at X. And then you have to make an extra effort then and say, okay, X is going to benefit the United States, national security, technology landscape, etc., because of this. So that's something that I probably going to emphasize a lot today. You have to be really like US benefit focused, if you will. So yeah, I mean, the awards and patents are one way to, but again, it's just one way. You need at least three criteria. So one of them will be awards or patents. Yeah, so we can keep going with the other elements if you want.
Sure, why not?
Yeah, so for instance, just to give you an idea, and I'm going to read it straight from the regulations so you know what they say. Again, you can either be a recipient of a major international award, such as the Nobel Prize or any other. Again, if the award is not probably well known, then you go into the second category where you have to show at least 3 out of 8 criteria as to why you are a person of extraordinary abilities. So, for example, like we just discussed, the first criteria is documentation of received or nationally or internationally recognized awards for excellence. That's the key word there in the field of endeavor. The second criteria is membership in organizations that require the member to have, excellent achievements, and to, not just any membership where you just pay a fee and you join. It's got to be a membership that, like an organization where they sort of selected you for being a member. So, for example, like a fellowship, or the other thing is published material in major trade publications. So again, this is just another. I mean, I see some of the questions here saying, "Well, I published a few articles, and is that enough?" And I say, "Well, it depends. Like, where was the article published, and was it cited by other people? Is it relied upon by people in the industry?" Those are the questions you have to ask. And again, remind that just publishing articles is one criteria. You have to meet at least 3. So, then the other one is the person having worked in a panel, like for judging the work of others. I'm not sure how relevant this will be in the tech industry, but sometimes you have competitions, and people have called you to be a judge because of what you do and because you're known in your industry and your sector, and you can use that to meet one of the criteria for extraordinary ability. The other, and I think this is very critical for tech professionals, it says evidence of the person's original scientific, scholarly, or business related contributions. This goes back to patents, right? So what did you do that has made you stand out in the industry? That's what that means. Like how do you watch? I mean, why are you different than all the other tech professionals? That's basically what you're trying to do. Stand out from the rest. Again, and I think we're going to talk about this later, but another criteria is you have to show that you have been employed in a critical or essential capacity with companies. So, for instance, in January there was an update to the O1 category where the person could start its own LLC, for example, and then that company will serve as your sponsor, and the person who started the LLC could potentially meet, depending on other factors, they could meet that he's employed in a critical or capacity because, let's say you start your own company, you're the president, right? So you're definitely that's again, it's all, and ultimately the eighth, and I'm not sure if this is relevant to the tech industry, but usually when high salary is another criteria. So, for example, what you do is you compare, okay, as a tech professional, let's say just for the sake of argument, I make $1 million a year, and your typical person in my position makes 200,000, right? Then you can argue that your remuneration is a lot more than the typical. So that's how you meet that criteria. So that's basically, like I said at the beginning, it's a statutory dance. You got to go criteria by criteria and see, okay, how can we meet this? Do we meet these? That's basically what you do. I mean, it's not, and that's one of the things that why we're doing this is, sometimes people believe that, okay, I wrote a couple articles, that's enough. Fortunately, no. I mean, that may work to meet one criteria, but you have to show more than that. You know what I mean?
That's right.
So yeah, I think that's pretty a good picture of what, how you meet the one criteria. So yeah, I'm ready for your next questions.
That's wonderfully explained, and I'll say, Ralph, that everything has been explained in a very detailed manner. So thank you so much for that, and it's really appreciating. And I'm saying that our friends have also joined us. So friends, stay tuned, stay connected with us. We'll be coming back just after a quick break. So don't go anywhere, and keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and welcome back to Immigration Talk Show. It's me, your host, Sam, and we are having a great discussion with immigration attorney none other than Ralph Antonioli on the topic O1 visa for tech professionals. Is it worth exploring? So, till now, we have covered so many questions, and now we are also left with many more. So, I think without any further ado, Ralph, let me go ahead with my next question for you. And okay, let me pick up this one that how does the O1 visa can beat the H1B when it comes to tech jobs? Because H1B is also highly popular among tech professionals. So how is
Yes,
it better?
yes,
Yeah.
yes. So yeah, we sort of touched upon this a little bit earlier. The O1, it's probably not the first choice for tech professionals. Most people, like you said, are more familiar with the H1B
Yeah.
category, which is typically how people come here to the United States to start there. I mean, I started as an H1B, so
Okay.
um, so there are a few things that make the O1 attractive. Um, I would say the most attractive the most attractive factor of a O1 is probably that there is no lottery and there is no
Yeah.
cap. So, as you know, for H1Bs, you have to, well, especially now, there's a lottery, you have to register, then you have to wait until you're registered, and then if you're registered, you can apply. So it's kind of, there's a lot of uncertainties with the H1B. The O1 is, in that sense, is very flexible. If you meet with your lawyer, you go through the details, and if you can meet the O1 criteria, you can do it at any time. There is no cap. There is no. I mean, you can do it any time of the year. The other thing is there is like I explained earlier, there is no prevailing wage requirement. So this allows for a lot of flexibility for employers and employees to sort of structure a compensation package that could, potentially even meet the high salary criteria. But again, the important note here is that there is no prevailing wage. So for those familiar with the H-1B process, before you can file your H-1B, you need to get a labor condition application with the Department of Labor, where they basically certify that you can only pay this much. That doesn't exist in the O1 world. So the other caveat that I do want to provide is that the O1, as you've probably noticed by now, the O1 requires a higher standard. So it's
Yeah.
not. I mean, it can be flexible, but I mean, the reality is that not everybody will qualify. Um,
True.
but this is why you have to work with competent counsel, because people who have done this know how to navigate, especially nowadays where there's a lot more scrutiny on all
Yeah.
kinds of cases, not just O1s, all cases. Um, and another great advantage of the O1 is that if you have been granted an O1, you're probably 50% there for an EB1 visa, which is sort of I will probably call it the immigrant brother of the O1, because the O1 is for non-immigrant to work, whereas the EB1, it's for you to get an immigrant visa. So it's so the EB1, you do it through what's called the I-140 form. Um, and the excuse me, the the requirements for the EB1 are very similar to the O1s. So that like if you met the O1, that's why I said you're probably 50% there. So those are probably I would probably say the fact that there is no cap. Um, it's probably a game changer, because that allows for you to plan anytime. I mean, if you can meet the documents and the requirements, you can do your O1 anytime. You don't have to worry about a H1B cap or anything. And again, like I said, if you're interested in staying in the United States, if you've been granted an O1, getting your EB1 is probably halfway there. So I would probably say those are the major advantages over the H1B category.
That's right. And that's wonderfully explained, Ralph. And I'm sure our friends are keeping a note of all these pointers. And guys, if you have any other question or any other doubt regarding the topic, then please go ahead, put them on the comment section. And we would love to take all those questions. So, with that, Ralph, I think let me go ahead and take up some of our viewers' question too. So, hi, Ricky, and Ricky is here. So, Ricky is posting a question that is, if I'm one of the core members of the startup helping technically as well as in raising funds and bringing in new projects, then can you suggest ways to use this to build profile for O1 petition? Also, okay, yeah.
Yeah, I could take that question. Yeah. So the O1 is one of the favorite categories for startups because usually when you're in a startup, you can afford to wait for the H1B season. Also, you need top talent fast. And like when I discussed the criteria, as one of the core members, you can argue that you are a founder, and that will put you in an essential role. So you will meet that criteria. So yes, I think the O1 is very popular among startups. And again, as long as you sit down with your lawyer, go over the criteria, and you can definitely build a successful O1. I'm going to emphasize this, that O1s is all about strategy. It's about it's not as much as being fast, but as being compelling, being presenting an application that sells itself. Like I said, you have to keep in mind who's looking at this. It's probably somebody who knows absolutely nothing about what you do. So your job is to basically educate them and give them a roadmap as to why you are a person of extraordinary ability, and again, why you're coming to the United States to benefit the US. That's critical in the current environment. So I hope that answers the question. Yeah, I mean, just because you're a startup doesn't mean that's actually it puts you in a better position, because you're an entrepreneur, right? So
That's right. Absolutely. And I hope, Ricky, you got your answer. And thank you so much, Ralph, for taking up this question. Okay, let me go ahead with Jay's question. So, hi, Jay, and thank you so much for your participation. Hope you have subscribed to our channel. If you haven't, then please do it right now. Okay, so Jay is saying that I am a senior data scientist with a few published papers, and I have given some internal tech talks at my company, but nothing in major media. So, do I realistically have a shot at qualifying for O1, or should I not bother?
yeah, that's a great question. And like I said before, it's all about how you present. If your papers have been published, if your papers have been cited, you may use those to meet one criteria. I mean, and again, I want to remind your viewers that one criteria is not enough. You have to meet at least 3 out of 8. So you can most definitely use your published papers and your tech talks and put it all together and make an objective argument that you are on top of your field and you meet that criteria. But again, that's just one criteria though. You may be able to sit down and discuss and see how those papers have been cited, where are they published. Again, I'm an eternal optimist, so I don't I will never tell a client don't even bother. I mean, I'm the type of guy who's like he's probably going to go for it, but again, the O1 it requires a lot of strategy. You can't go at it softly, and two, you can't go at it alone. Not especially now. You need to have a competent counsel to guide you because this is not a do-it-yourself type visa, especially now in the current environment. So Jay, I mean, I don't think I don't think you should you should think that it's not worth it. I will probably focus on how do I meet the other criteria. That should probably be your mindset. So I hope that helps.
All right. And Jay, you can also get in touch directly with attorney Ralph Antonioli. Just have to visit this link and you can share your status, you can share your case or any other documents, and he would love to help you out. Okay, let me move ahead with Yuri's question. So, hi Yuri, and thank you so much for your participation. Yuri is asking that I have been working on open source AI tools for years, and I have decent recognition on GitHub. Does that carry weight with USCIS for O1, or do they only
Yeah.
value traditional press and academic credentials? Yes, Ralph, please go ahead.
Yes. Yeah. The same. This is sort of related to is the same question as Jay asked. Yes, you can definitely make an argument that your contributions to the open source and your recognitions in GitHub have been will help you meet one of the criterias. But again, the mindset is okay. I meet one. How do I meet the rest, or at least most of the rest? That's really at the end of the day. If you prepare well, you put together a really good application. You show how easy that you're going to benefit the United States, and carefully go through these criteria. An O1 is absolutely doable. So, but it requires patience, it requires preparation, and it requires good counsel. So
That's right. Absolutely. And in 2025, I'll suggest that it is better, friends, to have a direct expert consultation, and that will be a pretty safe option for you. So we have shared the link of attorney Ralph Antonioli. You just have to visit and go ahead, get in touch with him. Okay, Kriti is also here. And hi, Kriti. Thank you so much. I think you have joined us for the very first time. So please make sure to subscribe to our channel. Our handle is at Immigration Talk Show. Okay, so Ralph, Kriti has a question for you. That is just getting IEEE senior membership enough for satisfying O1A membership criteria? I have strong other 3 criterias.
So it depends what are the requirements to be a senior member of. That's the first question. Like, how do you become a senior member? If there is some type of criteria for you to become a senior member, then you can definitely make the argument. If you have 3 other criteria, then that's perfect. You're going to have 4. And I usually recommend my clients to meet at least 4 in the event that USCIS in the event that USCIS does not believe that you meet. So I'm going to sort of graphically explain how this works, so you can understand how
Mhm.
USCIS looks at this. So let's say in the case of Kriti, we put together your O1 and we argue for four criteria. We send the application gets received, and let's say we get an RFE. So the RFE usually looks like, okay, based on what you provided, you said you meet 4 of the 8 criteria. And then the RFE will go through criteria by criteria and say, okay, based on what you submitted, we believe you met these criteria. Or based on what you submitted, we believe you didn't. Then you have 3 left.
Mhm.
So that's how they look at it. It's a pretty mechanical process, but that's why strategy and having experienced lawyer is critical. So
That's right.
yeah, I
That's
just see that Chris said that. So that's your gold ticket right there. So yeah, that's exactly that's the argument you're making. So
Mhm.
yeah,
All right. Thank you so much, Ralph, for taking up this
yeah, of
question.
course.
And Kriti is also here, and she's saying that, okay, got it. Thanks. Thank you so much, Kriti, for your participation. And I hope you have subscribed to our channel. If you haven't, then please do it right now. And with that, friends, now it's time for a short and a quick break. So don't go anywhere. We are coming back in this platform only. So don't go anywhere. Join us after a short break and keep watching Immigration Talk Show.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and welcome back to Immigration Talk Show. I hope we have been talking about a lot of O1 visa, and the topics and the queries that we have covered in this session is going to be helpful for you. And Ralph is also here, and he is doing a great job. So once again, Ralph, thank you so much for your,
My pleasure.
answering all the questions and yeah, taking it in a very detailed way. So we have few more questions from our viewers. So I think let me continue with those. And here's another question, Ralph, from Ricky's side. So Ricky is asking, what is the timeline you are seeing for O1 petition processing?
Yes, that's a great question. So as some of your viewers may know, there is 2 types of filings in the US with USCIS. The first type of filing is your regular filing.
Mhm.
As you can imagine, the regular filing takes longer. Um, so and again, these are just estimates. When you file your regular processing, it takes about 2 to 4 months to be processed. It could take more, it could take less. It all depends. If you've ever interacted with USCIS or the Department of State or any other immigration agency, it's a very subjective process. So your case may take 2 months or may take 4 months. That's sort of outside of our hands. Now what the O1 as well as other categories and some of your viewers may be familiar with is the premium processing option. This is and I'm only referring to the O1 context. So the way premium processing works is you have to submit an additional fee, which right now is $2,805, which guarantees and quote unquote guarantees that USCIS will make a decision within 15 days, 15 calendar days. So that means in 15 days, either they're going to approve the case or they're going to issue an RFE. And straight denial is really rare unless you present a case that it's that it's bare bones. So, usually that's premium processing again. And the other thing about premium processing is, let's say there's an RFE. Um, the, the 15 days start again once the USCIS receive the RFE response. So the first 15 years sort of disappear. And they start over when if there is an RFE. Ideally, you will present a really strong case. I mean, I've had cases approved in less than a week. I've had cases approved in a couple of months. Again, it's a very subjective, but it usually, I like I said, I've done more than 100 O1s in my career, and knock on wood, each case has been approved. But again, it's a lot of preparation. It's a lot of legwork. You have to be on top of it. You have to be really involved. And then also you got to take into consideration how long it takes to get all the documents that you need. So, sometimes you can take a week if you're ready to go, or you can take, a couple of months, depending on, for example, what tech professional will probably rely on. It's recommendation letters, right? So those are probably, at least in all of the fields that I worked in, and I worked from retail to tech to even professional sports, securing recommendation letters, it requires some legwork. So yes, those, I mean, yeah, I don't want to deviate from the question. So yeah, you have a standard timeline and you have the premium processing. So those are your two options.
All right, that's great. Thank you so much, Ralph. And Ricky, as usual, you have come up with so many questions, and it feels so good that you are such an active participant and viewer. So let me go ahead with another question, Ralph, that Ricky has for you. And he's asking that can one combine salary from two jobs to claim the high salary criteria if the individual salaries themselves don't satisfy the high salary criteria? Mhm.
Let me see if I understand the question. So does he mean two salaries at the same time, or I mean, is that what he means? I mean, you could make the argument that I mean, it's all a matter of how you frame it. So let's say you're doing the same job at two different companies. You can make the argument that yes, I mean, you based on what you do and if they're related, then you can make that argument. Again, I want to remind Ricky that that's going to be only one criteria, though. So you're going to need others. And again, I always recommend clients to have at least 4 or 5, just to be on the safe side. So that, yes, I mean, it depends how. Again, it all comes down to a strategy. Like, how do you present the salary? Like, I mean, let's say if you do one job that is almost identical to another one, if you have two salaries, you can probably make an argument. But if they're completely unrelated, then that's probably more difficult to make. You know what I mean?
Yeah, absolutely. Okay, then thank you so much, Ralph and Ricky, also for participation. Now, Kriti also has a lot of follow-up questions. So, Ralph, I think let me go ahead with Kriti's question. So, Kriti is asking that, hi, Ralph, do you help candidates also patch the missing pieces in their profile? For example, if I have some media, but it doesn't mention my name, then how can we go about seeking contacts and media to help with the editorial? I'm a machine learning engineer in big tech.
Yes, that's a good question, Christy. The best way to do that is when, and I want to tell you what has worked for me in the past. I've had the first case that comes to mind is I've done I have done a O1 for a photographer
Oh.
who one of his jobs was to take photos for Apple. So he was taking pictures of everything that you see in the Apple commercials. He was the guy taking the pictures. So when you see those pictures, you don't see his name there. So um the way we did that is we included the picture, or in her case, we would include the article and then we would include a letter from either the editor or someone from from the magazine or the publication saying, yes, I can certify that, and then you can use that letter not only to certify that you were the one in the article, but you can also use that letter to meet the criteria that you have provided contributions to the field. You know what I mean? See how it's all strategic. You have to like, yeah, you have to think, try to meet as many criteria as you can. And I mean, that's the workaround that has been helpful to me um, and that's also where the recommendations letter come in. Just because your name,
Yeah.
um, just because your name is not in the article, that's not the end of the line. You can also, you can have someone from the publication write a letter and say, yes, she's the one we're referring to, or depending on what the case is. So
That's right. Okay. So let me go ahead, Ralph, with another question as you have answered Kriti's comment. So thank you, Kriti, and I hope you got your answer. In case if you have any other follow-up question regarding O1 visa, then please go ahead, put them on the comment section, and we will try to answer that. Okay, Durga Prasad, he's also here. So, hi, Durga. And if you are here for the very first time, please make sure to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. So, Ralph, he has a question that in your personal experience, what is the preference in big tech firms for hiring immigrants? Do they prefer hiring H1B because the SOP already exists, or they prefer O1 because O1 is easier to file? Also,
yeah,
he's.
yep, yeah. I saw his other question, so I can
Okay.
address those.
Mm-hmm.
Yeah, I mean, honestly, most big tech firms go with H1B just because that applies to the majority of recent grads. On the other hand, if you have a particular specialty that is attractive to big tech, you may persuade them to do an O1. Again, um, what your viewers said. I mean, he's saying it's easier to file. I mean, I think that's kind of a risky way to put it. I mean, I don't think an O1 is necessarily easy to file
Mm-hmm.
because it requires a lot of legwork. But if you, like I said at the beginning, if you are a founder, probably the O1 is going to be your best shot. Because you don't have to worry about the cap and you need talent right away.
Yeah.
Whether if your startup once down the line, I mean, unfortunately, that's not a prediction anyone can do. Hopefully it won't. But once you get your O1, you usually get a 3-year period, and then you extend it by 1-year increments. I mean, if you're a founder, I will probably say go for the O1, but or if you have contacts in big tech, you may be able to persuade them that you have such a specialty that an O1 um,
Mm-hmm.
may. And I mean, having an offer from, and I'm going to go back to what I said throughout our
Yeah.
time here together. It's
Mm-hmm.
having an offer from a big tech firm also goes a long way. So that may even help you to meet one of the other criteria. So again, it all falls back as how much you can show. So
Yeah.
I mean, yeah, I would say, explore the O1. Um, Unfortunately, H1B has limitations, but if you're a founder, probably the O1 is your way to go.
All right, that's great. And that's also very interesting, Ralph. And I think, friends, we are about to end our session. But before that, we're just going to go for a short break. So don't go anywhere, keep watching. And I think Durga Gap, okay, Rajkumar is also here. So, Rajkumar, stay tuned. And friends, don't go anywhere. We are coming just right after a break. So keep watching Immigration Talk Show, and we'll be right back.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello, everyone, and once again, welcome back to this very important and great conversation that we are having right now. None other than with attorney Ralph Antonioli, and he is explaining things greatly, beautifully, and in a very simple terms. I hope you guys are understanding and also able to understand all the criterias and all the questions in a very great way. Okay, Ralph. So I hope you're enjoying this session too, and by interacting with our viewers, you're also finding it interactive and, a good one. So I think let me go ahead with our some of the questions that we have for our viewers.
Yeah,
And
I want to emphasize to our viewers that the goal of having this
mhm,
conversation is to, you know, um, clear the air, because there's a lot of noise, there's a lot of misinformation, and I appreciate this type of programs that you put together because it helps people to, really learn what's going on in the on the ground, as they say here in the United States. Um, there's a lot of misinformation. There is a lot of, and unfortunately, I always caution people that, because there's a lot of uncertainty. There's a lot of people who give you false information just so you can,
yeah,
you can, I mean, for lack of a better word, so they can take advantage of you. So this is one of the, and I would, and that this is why I appreciate the type of shows that you guys do, because this is a way to, you know, set the record straight and say, okay, this is really what's going on. I mean, don't. I always recommend my clients, before you believe anything you see in the news, give me a call, because 9 out of 10 is not true. So, um,
mhm. I think that's
yeah,
that's so sweet of you, Ralph, and I really appreciate your kind words. Thank you so much. And I'll say because of experts like you, this show becomes a wonderful one. It's not only from my side, but the insights that you're putting and bringing up so much onto the table. Hats off, and the energy you are putting in this webinar. It's visible that we are getting a lot of engagement. So, with your request, if you're okay, can we extend 5 more minutes, and after that we can end up the session if you're okay with it.
absolutely. I'm here. Yeah, I'm here whenever you need me. So,
Okay, that's great.
and to
So.
your viewers, feel free to email me if you have specific questions. I mean, happy to help in any way I can.
That's right. That's right. And friends, I think that's a great idea. And we have been sharing, Ralph's this link where you'll get the contact details of him. So go ahead. And I think due to some time restriction, we have to leave the session just after 5 minutes. So maybe we won't be able to take all the questions, but you are free to go ahead and drop your status, your case, or questions on Ralph's email ID. And let me go ahead with some of the questions, and let's try as much as we can cover. So I think let's take up Rudra's question here. So Rudra has a pretty long question. He's saying that, hi, I'm a VAWA approved applicant. I had second interview after my waivers approved. Interview went pretty well, but officer put my case under administrative processing. But yesterday I got a letter from embassy saying I suppose submit my waivers notice. And on
Yeah,
CV,
I'm going to. I'm going to answer that real quick. I mean,
sure.
this the question is, I am a business immigration lawyer, and VAWAS is kind of outside of my hat of capabilities. What I would recommend is if you file your VAWA with an attorney, please reach out to your attorney and make sure that he is, he's proactive about all these requirements. Unfortunately, I just can't. I mean, I'm not in a position to tell you whether that's a good sign or not, because that's just not the type of cases I do. The case, so I highly recommend that you get in touch with your lawyer, and that's probably what I can suggest.
Okay, that's not a problem, Ralph, and I think that's okay. You can go ahead. I think yeah, Rudra. I'm so sorry, I forgot your name. Rudra, you can go ahead and look for some other immigration attorney, and of course they're going to help you. In case if you have any other question regarding O1 visa, then please go ahead and put them on the comment section. We are going to take that. Okay, so Raj Kumar is also here and he's asking, my perm date is on May 2025. I was on L1B from July 2023 to April 2025. Now I'm on H1B and enters USA on 14 June. So can I work outside USA for a couple of months?
I mean, if you work outside the United States, then so what? I mean, I think I need a little more information. Do you want to come back to the United States in H-1B or an L-1A, or so what's your plan? Like, why
Yeah.
are you going to be outside the United States for 2 years? Are I kind of need a little more information.
Mhm. That's right. And Rajkumar, I hope if you're watching our session, please go ahead and do let us know, what you are looking for or what your future plans are going to be. Then that will be a little easier for us to understand, and Ralph is going to answer
Yeah,
it properly. Yes, Ralph.
because if I know, like, what I mean, there may be some implications on your H-1B status if you may be, again, I don't know all the facts, but you may, if you leave for a certain period of time, you may have to be subject to the cap again. I mean, there's a lot of moving parts there, so we kind of need a little more information on what your plans are, so that.
Okay. He's saying something on same company.
So okay. Yeah, I mean, so is the plan for you to come back, or?
I
I mean,
think
if it's the same company, then
I think will affect. Okay, he's asking, will it affect my perm process?
nope. No, it will not.
Okay, that's all right. And with that, Ralph, I think we have covered, but this is just the last question that I would like to take up. And after this, we can let you go because it's already so much we have covered. So Nirav is here, and Nirav is asking that how much evidence is enough for an O1 petition? I mean, is 5 letters of recommendation enough or 10? Should I be aiming for quantity or quality? Yes, Ralph.
I think this question answer itself. It's all about quality. So, I mean, you can have 10 letters that say nothing, or you can have 5 letters that says a lot.
Yeah.
at the end. I mean, just to put it as simple as I can, I mean, if you have a letter that says, I really like to work with this guy and he's really great and this and that, that's probably not going to cut it. You need a letter that goes in detail as to why you are on top of your field. That's the goal. I mean, and I'm going to speak from a particular cases. For example, I did a lot of cases for people in the C-suites who are executives, and those letters were, they go into so many details. Some of the letters are like 4 or 5 pages. Um, and the answer is you have to be objective. If the letter explains why you are, if you have 3 letters that are great and go into a lot of detail, they're much better than 10 letters that say nothing. You know what I mean? So
Yeah. That's
I
that's
hope I
beautifully
hope that.
explained. Yeah, that's right. Yeah, yeah, Ralph, please go ahead if you want to add up anything.
No, I just want to remind your viewers here, and this goes back to what I said earlier about we we have, or why you guys also have these shows. It's, I'm an immigrant myself, so I know. And my job is to sort of, I always tell people, I'm an immigration lawyer because I want to be the lawyer I never had when I came here. So, I'm happy to provide a hand to anyone. And but again, you have to be willing to put in the work. It's not just like the last question said. I mean, it's not about quantity. It's,
Yeah,
some people say, well, I'm sending a package that is 300 pages, but like, what's in the 300 pages? You can send a package that is 50, but it has a lot more value than something that is 300. It's just paper.
yeah,
So yeah, I just want to add that it's, it's very subjective, but at the same time, it requires, um, it's not easy, but it's not impossible.
that's true.
It's, and it requires, I mean, you need to be mentally prepared for to put in a lot of work, be as detailed as you can,
Yeah,
be, and be proactive, be focus on why you're good, focus, and you have to sell yourself. That's, that's the key. So I mean, if you can sell your story to me, then there's probably a high chance you're going to sell it to the USCIS too. So
all right, that's wonderful. And Ralph, I think your answers are marvelous, and you have been explaining things in a very detailed manner, in a very simple terms. Everybody's understanding everything, and I think it's not only Ralph, on YouTube or on X we have got a lot of viewers, but the great news is that on Facebook also we have so many viewers. So I think it's already 1 hour 10 minutes. So if you are okay, with your permission, can we extend like for 5 more minutes, or would you like to take a leave? It's
yes,
completely on you.
no, that's fine. We can chat.
Okay, that's great. So yeah, we can take few questions from Facebook side, and Control, if you can please share
Okay.
the screen. And yeah, let's take some Facebook as well. Okay, so we have a question, and it is that, hi all, has anyone applied for an O1 visa renewal or extension with the same employer? If so, could you please share details about the process and also required documents for the O1 visa extension?
Yes, that's a great question. I'm not sure if he heard my comments at the beginning, but typically when you apply for the visa for the first time, you get a 3-year period. Then um, when you can spend indefinitely in 1-year increments. So after the 3 years, you go 1 year. You have to extend your O1 every year. The key here is to continue to show that you remain a person of extraordinary ability. So your O1 extension is not going to be identical to your initial, but it will
Yeah.
be updated materials. You know what I mean?
Mhm.
Um, if you in your original O1 you said I published 10 articles, in your extension you should probably say I I publish 10 more or I publish 5 more. You need to continue to show that you still remain a person of strong liability. I mean, it will be very similar, not identical, similar to
Yeah.
your initial filing. So your initial filing is your foundation, and then whenever it comes to time for you to extend every year, then you make sure you're updating your credentials. So that's how extensions work.
All right. Okay. And let's move ahead with our next question. So this we have from anonymous member who's asking that, hi, my O1 case has been pending for 8 months now in Vermont office. I'm considering upgrading to premium as I already lost 3 months on my visa and I'm anxious. Is it a good idea to upgrading now or is it better to wait? How much more could I be waiting for? I'll be grateful for some insights from someone with experience. Yes, Ralph.
Yes, like I said at the beginning, the immigration process is very subjective. Someone can look at your application tomorrow, or they can, someone can look at it in 2 or 3 months. At the end of the day, this is how comfortable are you with the strength of your petition? I mean, how many, for example, I would look at how many criteria do you argue? If you argue 5 or 6, then I would think premium processing, it's a good idea. I do want to caution you, though, however, like I said at the beginning, not at the beginning or during this show, when we spoke about premium processing, is that once you pay the premium processing fee, they have 15 calendar days to either issue an RFE or approve your case. If they issue an RFE, then the 15-day clock resets, okay?
Yeah.
The 15 days won't start until you respond to the RFP. So, I mean, this is really a judgment call. I mean,
Yeah.
how comfortable are you with what you already submitted? So I think if you have argued for at least 5 or 6, or even 4 or 5 criteria, I would say go for premium processing. If you're willing to pay the fee, I mean, go for it.
Okay, that's great. And thank you so much, Ralph, for taking up this question too. And let's move ahead with our last question of today's webinar. This is hello, everyone. I'm trying to complete Form I-129 for my O1A visa application. I'm filing through an agent and I'm not sure which information to use for Part 5, information about the proposed employment and employer. I have a job offer from some company and I don't know whether to use the company information or the agent information.
Yeah, that's a great question. So, I mean, usually people use an agent when the person will work in more than one location. So the way an agent O1 works is the agent is the petitioner, and then you send what's called an itinerary, right? So you say, okay, this person is going to work for company A from this date to this date, company B from this date to this date. This is a strategic filing so that someone can work for more than one employer. If you're only going to work for one employer, I would recommend that company actually be the petitioner. That's probably the best strategy, because if you do an agent, and again, I'm not guaranteeing, or I'm not, please don't take this for, if you're filing through an agent and you are only working in one company, this may raise some flags. Again, I don't want to scare you, but I'm just, we're here to be honest. And if you only have if you have one employer, I will probably, have the employee be the petitioner. That's more straightforward than, you don't want them asking, okay, why are you using an agent? Is there really a job? You don't want to, you don't want to open yourself to more questions. So I hope that helps.
All right. And I think that's all for today's episode, Ralph. So we have covered, I think, so many questions, multiple questions from viewers from Facebook, X, and also from YouTube as well. So I'll say that it was really a great session and a great conversation to have with you. You have explained everything, with great insights, great point of views, and of course, the knowledge is commendable. So thank you so much, Ralph, for being here. I really appreciate your time, your support, and got a great engagement from our viewers. So once again, thank you so much, and we are really honored to have a show with you.
Well, thank you so much for having me here. And like I said, feel free to shoot me an email. I'm happy to help you. We can brainstorm together, whatever you need, just let me know. Thank you, guys.
Thank you so much, Ralph. Have a great day.
You too.
Thank you. All right, friends. So that's all for today's webinar. It was pretty long, but very informative. Don't forget to share the link of this session with your friends or the one who are looking for the O1 visa. It's a great chance to shine. No lottery, no long wait times. A great opportunity for you to go ahead and work in the USA. And with that, the best part is you can also email me in case if you want to cover any other topic, any other visa category for our next session with attorney Ralph Antonioli. Then please go ahead and share me on my email address, that is sam@staffingly.com. And with that, friends, thank you so much for joining us. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. It's me, Sam, signing off for now. Till then, goodbye, everyone, and take care.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI Support, virtual immigration paralegals trained in real case prep, DocketWise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI Support.
Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are back again with a very exciting webinar that is lined up just for you. Stay tuned and make sure to watch this session till the end. And before going ahead, let me read out this very important disclaimer. That is, by watching our videos, you agree and understand that the information shared by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. All right, friends, with that, once again, welcome back to Immigration Talk Show. I'm your host, Sam. And today we are live here again at 2 p.m. EDT on your platform, that is YouTube. We are also live on LinkedIn and on X. And do follow us on different social media platforms like LinkedIn, Facebook, X, and on Instagram as well. And lastly, don't forget to like, share, and subscribe to Immigration Talk Show. Okay, and with that, talking about today's session is a very important one, and that is about NIW Guide, National Interest Waiver. Yes, friends, and in this webinar, we are going to cover everything about National Interest Waiver. What exactly does it mean, and also what's needed, what are some common missteps that most of the applicants do without even realizing it, and also how to get approved. And it is really going to be a very insightful session. And to make this webinar a more interesting one, I have a very honorable and a very, energetic guest over here with me. So without any further ado, let me welcome none other than Attorney Poonam Gupta, who has over 25 years of experience in immigration law and also has a solid background in intellectual property and litigation. So, hi Poonam, and firstly, thank you so much for being here again and really looking forward to a great session.
Hey, Sam, thank you for having me. And I'm excited about today's session as well. This should be cover a lot of topics that anyone who's starting out on the NIW journey may have. So really excited to get people's questions and what they want to delve into. So let's get started.
Absolutely. I'm too really excited for this session. And friends, the best part of this webinar is you can also participate. We are here live for an hour. So make best use of it. Ask as many questions as possible regarding NIW. And I'm sure Poonam is going to help you out. She's going to simplify every doubt of yours in a very easy and in a very understandable way. And you can also get in touch with Attorney Poonam Gupta, where you just have to click on the link that will be visible on the screen. Yeah, this is the one. You just have to visit this link and you'll get the contact details of Attorney Poonam Gupta. Okay, with that, before delving into the topic, Poonam, if you can just give a sneak peek, what our viewers can expect from today's webinar.
Sure. What we are hoping to discuss today is delve into the basics. What is NIW? What it entails, what the requirements are, what are some of the common missteps or misinterpretations, if you will, why it's a good idea to work with an attorney when filing this petition, and what are some of the things that you should be looking out for when working with your recommenders. Letters of recommendation are an integral part of any application that claims you are special. It may be any talent visa category, and adding the proper context to each letter of recommendation is critical, and we will go into some of those aspects as well.
All right, that's great. Sounds to be really interesting and insightful as usual, Poonam, because your webinars are very, eye-opening and lots of information. Okay, and with that, let me go ahead with my very first question. So I think, Poonam, let's begin with the basics, because NIW, people do understand what it is, but we really want to make it so easy, for our beginners also, so that they can also understand what exactly is NIW and also how is it different from a regular EB2 green card. Please go ahead.
Sure. As our viewers may be aware, there are different employment-based sponsorship categories for a green card. The first preference is the one that obviously gets the first preference. And then there are second and the third preference employment-based categories. The criteria for the employment-based second and third category, one of the key components of that is that an employer is required to conduct a labor market test and prove to the to the U.S. government that there are or no ready, willing, and able U.S. workers available for the job. That is the traditional EB2, EB3 green card categories. The distinction between EB2 and EB3 is primarily in the requirements for the position. Now, NIW, which is an acronym for National Interest Waiver, is a category that is permissible under the EB2 category. It is not an EB1 category, so it is not first preference, it is second preference, but it offers a lot of benefits. And what exactly is it? It is a category that permits anyone with or without a job offer to apply for the green card as long as their work will help the US national interest. If their work is so critical to the United States and its priorities, then there is a possibility that the person may be eligible for a national interest waiver. Whether that is possible or not depends on each individual profile and how their work relates to national interest. So, broad brushstroke, this is about whether or not your work is in the US national interest. You may be phenomenal on your own, but if you cannot show that your work is in the US national interest, then you may have a hard time filing for this category. There may be other categories that you may be better suited for, but national interest, the critical piece is the US national interest.
Yeah, it does. Okay, so Poonam, as you are, mentioning the term national interest, and I think it is the key word in NIW. So, can you clarify more about, what does this national interest means, and what are some other professions that people can get a better example? If you can share what national interest they have to prove in terms of getting NIW approved.
Sure. So prior to um, a decision, which is called the matter of Dhanasar, it may be something that anyone who starts on their national interest waiver journey will hear about. And if you've not heard about it, that is the first case to look for. It's matter of Dhanasar, and it lays out the roadmap for the US government on how to assess national interest and how to evaluate a national interest waiver petition. It has three different criteria. First is that a person, and again, because a green card application is a futuristic application, it is all about what is the person hoping to do or wanting to do. So, the person's proposed endeavor, what they want to do, number one, has to have substantial merit and national importance. So, it cannot be local, but it has to be national. Then, second, is that the person is well positioned to advance that endeavor, the proposed endeavor, as in they have the skills, the expertise, their past experience, achievements, and whatever they plan to do in detail is it all aligns and it's all synced together. And last but not least is the critical piece of the national interest waiver, which is that it is in the US interest to waive the requirements for a labor market test or a labor certification process. And because the work is so critical and so important to the US national interest, that is why. So, if those three prongs are met, the chances are pretty high. But there are other components to that aspect to determining whether or not a case qualifies for national interest. But those are the threshold criteria. And then how you present the case, how you present the national interest argument determines whether or not the case will be approved.
All right, that's great. Thank you so much, Poonam, for clarifying those three pointers. And I'm sure our viewers are understanding and keeping a note of all the pointers that till now we got to learn from Attorney Poonam Gupta. And friends, you can also go ahead and ask questions. I can see Ricky has so many questions. So thank you, Ricky, and I can see your hello just before our session got started. So thank you so much for waiting, and we will definitely take up your question. But before that, I do have some questions from my end. So stay tuned, and also meanwhile, don't forget to subscribe to Immigration Talk Show. Okay, let me go ahead with next very important question, Poonam. That how does USCIS determine what counts as national interest? So, is there a standard or is it case by case?
So, as I mentioned before, the standard for national interest is the matter of Dhanasar,
Mhm.
and it is a case by case assessment using that standard. Excuse me.
Sure. I think that's okay, Poonam. If you want to take a short break, we can take for your comfort. And we can continue after 5 minutes. I think till then you will be okay. So, friends, don't go anywhere, and we will be just right back. And Ricky, we will be taking back your questions again. So, stay tuned, friends, and we are here. And definitely, it's a very interactive session, and lots of viewers have also joined us. Just give us 2 to 3 minutes, and we'll be right back here. After that time, Poonam will be here with another very energetic voice. So keep watching Immigration Talk Show, and we will be right back. Hello, everyone, and welcome back to Immigration Talk Show. This was just a short and a quick break. And I think now Attorney Poonam Gupta is fine. So, hi, Poonam, and I hope you're fine right now. I'm so sorry you were mute. Yeah, please go ahead again.
I said, thank you. I'm good. Let's continue with where we were. So, we were talking about how does USCIS determine what counts as national interest, if there is a standard or it's case by case. So, I would say it's both. There is a standard. The standard is matter of Dhanasar, and it is case by case in the sense that each case has to meet the three-pronged test set in that case, and whether or not how the individual meets those prongs, meets those criteria, will determine whether or not the petition can be approved.
Mhm.
As I mentioned before, the three prongs are the proposed endeavor or the proposed work that the person wants to do in the US has substantial merit and national importance. The person is well positioned to advance that proposed endeavor, as in they have the skills, the education, expertise, and achievements, if any, and a detailed plan for future work. And last but not least, that the work is beneficial to the US in that it is worthwhile for the US to waive the labor condition requirement.
Mhm. Okay. And what about, Poonam? Because most of the time we have been hearing that advanced degree, if somebody has, then it's a very obvious reason that they can strengthen the NIW. But
Mhm.
what about apart from advanced degrees? I mean, what are some other less obvious factors that can also strengthen the NIW case?
There are lots of things that someone, besides an advanced degree, can strengthen the case. Um, some of the factors include what is the impact of their work. So, if their work has influenced additional research, for instance, or has led to new policies or new technologies, all of that is, that it, as long as they can show the nexus between their work and the subsequent changes that have been adopted,
Mhm.
that is powerful.
Yeah.
Then, if their work aligns with critical technologies or the work that is in national interest, then that is a critical piece of showing that their work is in the US national interest. Having commercial success is always beneficial because if your work was adopted commercially and was successful, that creates a different level of credibility, that builds credibility. Then, if you are, sorry, if others in your field uh, seek your expertise and consider you as an expert in your field, then that also adds value that establishes your credibility and goes to the prong of that you're well suited to pursue the proposed endeavor.
Mm-hmm.
Then, if you have publications, again, none of these per se are official requirements. And you do not need all of them. You can have one or none of them. There's no requirement that all of these are required, right?
Mm-hmm.
You could present at conferences, you could have published media about you. There could be any number of things that can help you build your case. But these are just some of the things that we've seen that help. Again, how the case is presented makes it.
Of course, it does. Okay. And I think, Poonam, we do have a lot of questions from our viewers. So, okay, let's start with Ricky because Ricky was the first one who commented. So,
Sure.
Ricky, I think you're not, new to Immigration Talk Show. You have attended some of our webinars. But in case if you are watching Attorney Poonam Gupta for the very first time, then the best part of this webinar is you can also get in touch with her. You just have to click on the link. I'm sorry, you just have to visit on the link that will be visible on the screen, and there you'll get the contact details of Attorney Poonam Gupta. Yes, this one. Okay, and with that, Ricky, let me take up your question. And you are saying the NIW processing time for the Nebraska Center is 65 months as per USCIS website. So, can you give some idea on the typical processing time that you are seeing to receive the I-140 petition results?
Um, Again, these are typical processing times for the government. If you apply under premium processing, then it is 45 business days to get a response. Again, depending on each person's situation, Sometimes it is advisable to file under premium processing, other times it's not. The biggest determining factor in most cases is whether or not that person has a priority date. If they do not have a priority date, then in my view, it is always beneficial to file under premium processing so that once it's approved, you can be assured of your place in the green card queue.
Okay, and I think this is the continuation of Ricky's question. He's saying that my NIW I-140 petition was filed by my employer. If approved, can the NIW be carried over when changing employers in a similar but not exactly identical domain? And also, in continuation to the previous query, if the employer lays off, then what happens to the pending new NIW I-140 petition? Yeah.
Ricky, thank you for those questions. First off, I want to say NIW is one of the few categories that permits you to self petition, as in, you do not need an employer to sponsor you. And I apologize, my voice is breaking. I don't know, somebody, but I hope you can hear me clearly.
Yeah, yeah.
So, if your employer is sponsoring you, then like any other employer sponsored petition, you are subject to the employer. And if you're laid off, unfortunately, while your petition's pending, you lose that petition. There is no way to save that petition. If you want your employer to sponsor you or cover the costs, then my recommendation is to request your employer to cover the cost of it as a self petition, not as an employer sponsored petition. This way, even if you are laid off, the petition will survive. And then I think the first part of Ricky's question was switching employers. Switching employers, the the time when this becomes relevant is at the time when you're filing, if you have an approved I-140 petition, then the time this becomes relevant is when you file for adjustment of status in the United States. And at that time, you have to be able to show that the work that you're doing is aligned with what the petition was approved for. Is it same or substantially similar? Does not have to be identical, but it has to be substantially similar. And it's a legal test that requires an analysis and analysis of what the two jobs are. It's hard to explain what that is here.
Okay. That's okay. And I think we do have lots of questions here. And let's take up Seema's comment here. So hi Seema, and thank you so much for your comment. She's saying that I'm a biomedical researcher working on rare diseases. My work isn't widely published yet, but it's gaining traction. So do I realistically stand a chance with NIW, or is it too early to apply?
Thanks, Seema, for that question. And it's great that you brought it up. Your work does not need to be widely published. What you need to be able to show is that whatever rare disease you're working on is something that the US cares about. Have they, is it in the on the national priority list? Is it a set of diseases that the US government has allocated significant funding for, and things like that.
Mhm.
And what are your credentials? How well, how well are you able to execute on what you say you plan to do? So it is possible you may be ready to apply for NIW, but you need more. I need more information than is possible to gather here.
All right, that's okay. So, Seema, I hope if you're watching us right now, then please share us more information regarding your status, and that will be easier for Poonam to simplify with your query. And also, don't forget to like, share, and subscribe to Immigration Talk Show because we do come up with lots of immigration updates and also great live webinars here. Okay, let me go ahead with one of our viewer who has joined us on LinkedIn, Chaitali Rajput. So she is saying that have you noticed any shifts in adjudication trends in 2025? Yes.
The adjudication, thanks, Chaitali, for joining. The adjudication trends have shifted because it's a different government and the government's priorities are changing. But the basic tenets and the basic requirements remain the same. Everything has to be aligned with the US national interest. If you're able to show that your work is aligned with the US national interest, then it doesn't matter whether you applied in 24 or will apply in 25. Your petition will get approved. But if you are filing a petition that is just throwing anything at the wall to see if it sticks, the chances are it will get denied.
Mhm. Okay. And I think Chetali has got your answer. So, Chetali, if you still have any follow-up question, right, then please go ahead and put up your question on the comment section. Until then, friends, we have completed first hour of our session, and we will be continuing back again after just a short break. So I think let's take a short break. Until then, go ahead, put as many questions as possible, and we will take all of them in the next half hour of our session. So it's a very interesting session and a very insightful one. So don't go anywhere, friends. We'll be here just after a short break. So do join us again on Immigration Talk Show. It's me, Sam, with my guest, a very special guest here, Tony Poonam Gupta. So go ahead and post questions and don't go anywhere. Keep watching Immigration Talk Show. Hello, everyone, and welcome back to Immigration Talk Show. It's me, Sam, and today I have joined by none other than attorney Poonam Gupta. And the topic of our discussion is NIW Guide, what's needed, common missteps, and also how to get approved. And with that, don't forget to like, share, and subscribe to Immigration Talk Show. We are also live on YouTube, LinkedIn, and on X. So do join us from these many platforms. And also, you can follow us on different social media platforms like LinkedIn, Facebook, X, and on Instagram as well. Okay, and with that, let us continue with the questions that I have prepared for you, Poonam, and I hope you're doing great now. So
Yes, thank
let's
you.
begin. Okay, all right. All right. So we do have covered, few questions from our viewers, and let me go ahead with my another question, and this is regarding what are some of the most common mistakes, Poonam, that applicants make when filing for NIW?
I think the biggest mistake people make when filing for NIW is not focusing on the national interest. As I mentioned, that the three prongs
Mm-hmm.
for an NIW petition are that the person's work has, or proposed work, has substantial merit and it's of national importance. Two, that they're qualified to do what they said they will be doing. And three, that their work is in the national interest.
Mm-hmm.
Most people talk about how great they are. And they have this many publications, they have a PhD, they have this many papers, and they talk endlessly about how good they are, how great they are. And what they forget that the NIW is not the process or the forum for that. And I see Jadav has a question similar to what we're talking about. And the critical reason for in applicants is just harping on about themselves. The NIW is about themselves, but only one third of the way. Of the three criteria, only one third of the petition should be about them. The other two thirds should be about why what they're wanting to do is meritorious. And then the third piece should be why is it so important to the US and the US national interest that they should bypass the labor certification or the labor market test process.
Okay, and as you said that Jadhav is also having similar questions, so let's take his question. Jadhav is saying that I have seen people say they got denied even though they had PhD and publications. Yes, and what's usually the real reason behind such denials? Is it the way the petition was framed? That's
Thanks,
right.
Jadav, for that question. And absolutely, it is how the petition was framed. As I said, if individuals are only talking about themselves, that they have a PhD and they have this many publications and so on, but not enough or at all sometimes about the national interest, then you're not meeting the criteria that are required for national interest. So it is critical to focus on the criteria. And the USCIS website is a great website which gives you outlines literally everything you need to know on what is required for that. So I highly encourage anyone who's looking to start learning about this topic to start with the USCIS website.
Absolutely, and that's a great advice. And I hope, friends, you can go ahead with that advice and Jadhav too. Okay, CR is here. So, hi, CR, and let us know, from where you are watching us. Okay, CR is saying, how much weight does USCIS place on letters of recommendation and what weakens their value? Yeah.
Um, Thank you for joining and asking this great question. USCIS places a tremendous amount of weight on the letters of recommendation, while USCIS sees evidence and documentation from pretty much every field there is. They are not experts in the field. Most USCIS officers barely have a bachelor's degree. Do they understand every aspect of the corporate world, of the various fields? No. And the role of the letters of recommendation is to educate them and tell them about one, what is the field? Two, how good of um, of a person that the applicant is in their field, what value do they bring to the field, how their work is in the national interest. What weakens their value is when they don't address any of the specific criteria. If the letter says, "Dear officer, I am such and such. I know this person because he's my cousin. He's great. You should absolutely, I strongly support this person's candidacy." Or, "I am this person's best friend. I've known them since childhood. They are very diligent, they're hardworking, they know everything, and they are phenomenal. You should approve their NIW." That letter of recommendation is garbage. I'm sorry.
Yeah.
What that letter of recommendation needs is substance. It needs credible information on what is it that this person will do, credible information on how their work is of great importance, and how their work is of great importance to the United States. So that those are absolutely critical pieces of a letter of recommendation.
Absolutely. And that's wonderful, Poonam, the way you have explained, because letter of recommendation is also a very major role in terms of NIW. And, people they misunderstood these terms and they just think that letter of recommendation means so many good pointers about the applicant. But it's actually not
Correct.
about that. It's about the credible thing, how you can make them trust that, yes, you are the right candidate and you can really do something great in terms of national interest. Okay, so that's great. And let me go ahead with Neerav's question here. So, hi, Neerav, and thank you so much for your comment. Neerav is asking, what are the implications of the matter of the NSR and decision on NIW petitions, particularly with regards to the national interest standard? Okay.
Neerav, thank you for that question. The national interest standard is the most critical aspect of an NIW petition. Matter of Thanasar simply codified and simply clarified what the three criteria are. As the title of the category suggests, it is a national interest waiver, which means the petition has to, there is no question about it, absolutely has to establish that that person's work is in the national interest. If it is not in the national interest, then it doesn't qualify for NIW. It does not. If it's not in the national interest, let me just spell it. If it is not in the national interest, then by definition, it does not qualify for a national interest waiver. The title of the category itself is explanatory. And if anyone who is looking to file an NIW petition, the first thing they have to articulate is how is their work in the national interest. If they cannot articulate that, then they should not think about national interest waiver, but they could think of some of the other categories. And this is where working with an attorney comes in handy because they can look at your complete profile and help you strategize on the best path forward.
Absolutely. And I would say that, also Poonam, not taking help of any attorney is also one of the common mistakes that applicants do. So, friends, I think without any further ado, you should directly go ahead and get in touch with attorney Poonam Gupta. She's here. She has over 25 years of experience and great in what she do. So go ahead and visit the link that is on this screen, and you can get the contact details of her and reach out to her, ask any query, ask any doubt that is bothering you, in your immigration journey. Okay, and let's move ahead with Karthik's question. Okay, Neera, we have taken. Karthik is also here. Yeah. Karthik is asking that how can petitioners in fields such as arts, humanities, or social sciences demonstrate national interest in their work, given that these fields may not have the same level of quantifiable impact as STEM fields? Yeah.
Sure. Karthik, great question. It is permissible for individuals to show that their work is in the national interest. And it's not just STEM fields, even though it may seem like those are the best suited for it. That is actually not true. It is anyone who can show the national interest. It just depends on what area of work you're in. So I'll give you an example. I got an NIW approved for a construction manager. No one would think a construction manager who helps build and maintain buildings, their work is in the national interest. But their national interest was because their work, or they were a construction manager for affordable housing. Affordable housing is a critical aspect of US society, and it's weaved into the fabric of the US society. There's a critical need, and establishing that person worked in that area, there was substantial merit to that. He had the skills and the experience and the certifications and the letters to support that he could do what he was saying he was going to do, and that his work was in the national interest. So I have been successful in filing for NIWs outside of STEM fields. Obviously, it depends on what the field is and what the national interest is, but it's possible. It's not just STEM fields that qualify.
All right. Okay. Thank you so much, Poonam, for your answer. And I hope, Karthik, you got your answer. In case if you still have any follow-up question or query, then please go ahead and let us know in the comment section. Let me go. Okay, Ricky has another question, and he's asking from you, Poonam, that Attorney Poonam, do you provide G28 representation? If yes, then what is the procedure for the same?
Ricky, as part of my representation of my clients, yes, I do include a G28 where I am a G28. For those that do not know, it's a form by the US government where the person or the attorney indicates that they are representing the individual in their application. So whenever I take on a case, I do include the form G28 to indicate that I'm representing as an attorney that person or that company.
Okay, that's great. Let's go ahead with Kritika's comment here. So Kritika is saying that my NIW application is denied due to a lack of evidence demonstrating national interest. However, subsequent to the denial, I received a prestigious award. So can I submit this new evidence as a part of a motion to reopen NIW case? What are the chances of success?
So, Kritika, thank you for sharing your journey. And what my question to you is twofold. When did you receive the denial? And there is no motion to reopen, if you will. There's a motion for reconsideration after the denial. And that window is only open for a 30-day period. And the basis for that reconsideration has to be the evidence that was already submitted, that the government did not look at everything, and that is why. In your case, you say that you received a prestigious award. Was that award going to help establish that your work is in the national interest? If not, then you're still at the same place. But if that award shows and can establish that your work is in the national interest, then I think a better position may be for you to resubmit that application with the new evidence and presenting a much more robust argument for the national interest rather
Yeah.
than trying to reopen with new evidence, because new evidence is not permitted at that stage.
Okay. All right. So thank you so much, Poonam, for taking up, Kritika's question again. And thank you, Kritika, for your question. And, in case, I hope this is a bit clear now, you can't reopen. And any follow-up question, if you still have in your mind, then please go ahead and put them on the comment section. And we will definitely try our best to
Mhm.
solve that out. Okay, Sonia is here. And Sonia is saying, if I'm missing peer reviewed publications but have solid recommendation letters and media coverage, is that enough or is that considered a weak case? Yes, Poonam.
Sonia, thank you for that question, and I appreciate everyone jumping in and asking such fantastic questions. So thank you. Sonia, the critical piece is whether or not your case has substantial proof of national interest. And a quick plug-in, if I may, if you go to my website, there is a tool on my website which is a free AI-based visa assessment tool that allows people to upload their resumes or whatever position documents you may have and get an assessment for free, no obligation from any person. No one will chase you to hire anyone, but you will get clarity on whether or not your case is eligible for an NIW, EB1, O1, or the like. So I would encourage anyone who's going down this journey to at least consider that. As I said, it's a free tool, it doesn't cost you anything. You're not, your information will be visible to me and me only. But I will not contact you to chase you that you should do this. That is entirely your choice on what you want to do. I have heard from many, many clients
Mhm.
that, and in fact, as part of my consultation, I request that everyone take this assessment because it helps my clients or prospective clients get clarity on how well they're prepared and how well they've presented their information and what are some of the weak points. That assessment provides them with the breakdown of what criteria they meet, what is acceptable, and what is a weak and where they can bolster it. So highly encourage. Sonia, back to your question. You have peer reviewed publications, great. You have solid recommendations and media coverage, that is phenomenal. But I don't know whether your case, one, what is your area of work? What's your background? And whether your work is in the national interest, the three critical pieces for national interest. So you may have a solid case for an NIW, or you may have a solid case for an EB1A. I don't know. So that is for you. We would need a lot more information than just that to tell you whether or not you have a good case or a weak case.
That's right. Okay, so Sonia, thank you so much. And Poonam, to you also. I mean, that was really a great advice, a big help that you are saying that that's a free assessment and viewers can go ahead and check it. So that's really sweet of you. And I'm sure, our viewers will be feeling so glad that they can have at least a platform where they can have a real assessment without any pressure, without any doubt. So that's really great. And I'm sure our viewers will go ahead and, try to utilize this platform as much as they can. Okay, Ansa is also here. So, hi Ansa, and thank you so much for your participation. Ansa is saying, would a clinical mental health counselor with an independent license have enough strong evidence to support their argument for NIW?
And so thank you for that question. And I think this is an example of people not in the STEM field who may be eligible for an NIW. Mental health is there is a huge need for mental health. So I think there is substantial merit. The first criteria for NIW is substantial merit in the endeavor. I think it definitely meets that criteria. Whether or not you can substantiate that you have the skills, I mean, you have a license, so you have the threshold for that, but how far can you go above that it will depend on your particular facts. And whether this is in the national interest, I have not done my research on this particular area. I've not yet had a client in this area. So I cannot tell you whether or not, at least not off the top of my head, but if you contact me separately, and if you can show me some evidence where it is aligned with the US government priorities, I think there is a strong case to be made potentially for this NIW.
That's right. Okay, Ansa. So I think you can go ahead and get in touch with Attorney Poonam Gupta, and she will definitely help you personally. This is the link. You just have to visit this link, and you'll get the contact details of her. And reach out to her right now, not later, but just right now. Okay, Ricky is here with another question. So let's take his question back. Ricky is asking for an employer submitted NIW I-140 petition, which is pending. Can I submit the same petition as is by myself under premium processing, as employer isn't willing to do premium? Can you help with it? Yes, Poonam.
Sure, Ricky, by all means, reach out to me through my website, schedule a consultation, and we can take it from there. But just taking a step back and helping our viewers understand, your employer may file a petition under regular processing, but if you want to file premium processing, you can offer to pay for premium processing fees. There is no prohibition that prevents the employee to pay for premium processing. Sometimes it's a function of the employer being sensitive to costs, but it is your life and you have the right to make the decision on whether or not you want to file for premium processing. So by all means, you can offer to pay, or if you want to self-petition and want my assistance, absolutely happy to help.
Okay, that's great. And thank you so much, Ricky. Today you have been one of the, most asking question viewer and active viewer. Okay, thank you so much, Ricky, for your question. And let's move ahead with Jay's question. So, hi Jay, and he is asking on behalf of my friend. He has been working on a project that has significant national interest implications, but the project is still confidential and has not been publicly disclosed. So, he's asking how can he demonstrate the national interest implications of their work without revealing confidential information? That's a
So,
yeah.
Jay, thank you for that question. I have to take a step back and ask you, how do you know the project has significant national interest? There are lots of projects that are never made public. The companies do what they need to do, they do their work, but they do not necessarily publicly disclose or take out a banner saying this is the project we're working on. It is possible to make the argument that by explaining what the work is, what the national interest is, obviously the company or that individual would have to disclose the confidential information to the government, but it is possible to ask the government to not reveal it under a Freedom of Information Act action, for instance, by any party. I've made those requests on a regular basis for my clients, especially corporate clients, where they may be revealing some trade secrets and the like to establish their case. And we have been successful in requesting that the government keep that information confidential. So it is possible, but obviously there is a nuance to it and there is a process for it, but very much possible.
Okay, all right. And thank you so much, Poonam, for your questions. I mean, for your answers, and taking all these viewers' questions and my questions very patiently. But before letting you go, as it's almost 1 hour, I would just like to go ahead with one last question. And after this, I think we can wrap up our session. So this is very important and a very demanding question that our viewers ask from us. That is self-petitioning for NIW riskier than going through an employer? What do you have to say on this?
It depends, Sam, on what the area is. In
Okay.
some areas, using the employer establishes a basic level of credibility that you may not be able to establish yourselves.
Mhm.
But in most cases, in my view, self petitioning is preferable than going through an employer for two reasons. One,
Okay.
as Ricky mentioned in some of his questions earlier, if the employer is filing that NIW, they control your petition. They control whether or not it can be premium processed. They control when they want to withdraw it. You have no control over it. But
Yeah.
if you self petition, then sometimes the employers are willing to cover the cost because you're such a valuable employee, even as a self petition. Other
Mhm.
times, employees will go out and cover the cost themselves because the value and the freedom that an NIW self petition gives is worth way more than a few $1,000s.
Wow.
I mean, in the grand scheme of things, if you look at it,
Mm-hmm.
you may spend a few $1,000s on filing your NIW self petition, but you will not ever be dependent on any employer for your green card.
Yeah.
To me, that freedom has no value. You could be laid off and not have to worry about your green card. You could switch jobs and not have to worry about your green card. Your spouse can work as soon as your NIW is petitioned if you're an H-1B, right? You could start your own company and self-sponsor your H-1B.
Wow.
But can you go down that path and get that freedom through an employer-based petition? I don't think so. So
Mhm.
my advice to my clients is always, where possible, file as a self-petition because you want to be in charge and you want to take charge of your immigration journey. You don't want to be dependent on anyone else. So that's all.
All right. That was really great and sounds so fascinating and like great, Poonam, when you speak about all these facts and put up all these insights in front of us, it's really great. So I would say again, thank you so much. And it feels so great as always to have these great sessions with you. I would love to have, these sessions every week. It just depends upon your availability. And you have seen how much great engagement we got again, in today's webinar. So it's really great. And once again, a huge thank you to you, Poonam, for being here, supporting us and sharing these great insights, expert advice with us, and being really sweet and extremely helpful to all our audience. So, thank you so much, and it was really our honor to have a show with you. Looking again to have a next show and soon, just after the next week.
Sure. Thank you, Sam. And my goal is to help people. That is the whole purpose of why I'm here, to help educate people. My LinkedIn posts are again in that vein. If I have been able to give even one person the clarity that they needed in this process, then it's been successful for me. So I'm glad I was able to answer so many questions and help so many people. I hope I was helpful. So thank you for that opportunity. And thank you all for joining and chiming in and asking your questions. Good luck with your journeys.
All right. Thank you so much, Poonam. And this is also our goal, friends, to make you guys educate more and more about the topic and to help each one of you regarding your immigration journey. So, with that, Poonam, it was really our honor to have a show with you. And I'm sure, that we will try to educate more and make, I would say, spread awareness regarding immigration journeys and, whatever the complexities that they are facing right now. So, I hope to see you soon. Until then, good day and thank you for joining us again.
Thank you.
All right. Thank you. Okay, friends, so this was the end of our session, and we have covered a lot of questions over here. And our friends have also joined us. So before leaving, I would just say that, Ricky, Seema, Kritika, Karthik, Sonia, Jay, and so many others, if I haven't taken their name, please go ahead and don't forget to like, share, and subscribe to Immigration Talk Show. It's me, Sam, and I love to have these webinars. And again, we are having a lot of webinars lined up on upcoming weeks. So don't forget to hit the bell icon again because you'll be getting notification. And yeah, go ahead and like, share, and subscribe to Immigration Talk Show. And do join us here on this platform. Also, do follow us on different social media like LinkedIn, Facebook, X, and on Instagram as well. So, with that, this was the end of our session. Thank you so much for joining us. See you next time. Till then, take care and good luck, everyone. Hello, everyone, and welcome back to Immigration Talk Show. I'm your host, Sam. And today we are back again with a very exciting and important session that is lined up just for you. And before diving into the topic, let me go ahead with this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. Use of information at your own risk. All right, friends, with that, once again, welcome back everyone to Immigration Talk Show, and I'm your host, Sam. And today the topic is green card process, myths versus reality. What's the truth? So, getting a US green card is like dream for many, but it's also surrounded by confusion, rumors, and half truth. Some say it takes decades. Others think that it's just a matter of luck, and many believe that you just need to marry to a US citizen and you'll get a green card. But you know what is actually the reality behind the green card process? If not, then this video is for you. So make sure to watch this session till the end and also participate in this webinar by asking more and more questions. Because in this session, we are going to break down some biggest myths, also going to reveal the real facts, and also help you understand what actually works and what doesn't. And to help me out, make this session a wonderful one, I have a very special guest here. Joining me in a bit, none other than very energetic and a great speaker, Nandini Nair. So, hi Nandini, and thank you so much for joining here. So good to have you here.
Thank you, Sam. I really appreciate it. I'm happy to be here.
All right. And friends, let me tell you about something about attorney Nandini Nair, that she is a partner at AY Strauss and leads the immigration practice with over 25 years of unmatched expertise. And her insights have been featured in the New York Times, CNN, Bloomberg, and more. She's also been recognized as a trailblazer in the legal field. So many great things about you, Nandini. And once again, welcome back to Immigration Talk Show. I'm so happy to have you here. How are you doing?
I'm good. I'm good. I'm happy to dive into this topic. I think it's really important. So,
Absolutely. It does. And the session is really going to be interesting because we are going to burst some amazing myths and facts. So let me go ahead with my very first question. And, this is very important that, according to you, Nandini, that you have a lot of experience regarding immigration and everything. So, till now, what is the biggest myth that you hear about getting a green card?
I think it depends on the background of the individual. You know, some people it's an easier route. Okay, it's that's the truth, right? If you're from Europe, you get sponsored by an employer, wait time is a lot less. If you're Indian, obviously it's a lot more. So the
Yeah.
myth I would say for your audience that I hear from business side especially is the way they think they qualify for a certain type of green card is actually not correct. They are, my friend got their this way, and so I should be able to get it this way. And in my practice and in my years of experience, my biggest thing is having to disappoint some people to tell them no, you don't qualify. I understand where you think this is how it works, but it actually isn't. So the biggest myth I always find is that they assume that the road that somebody else followed is the same road that they get to follow based on whatever criteria. And that is something that I face every day with the people having to walk them through this journey.
Wow. It's not just about Nandini, the green card process, but generally, and mostly in terms of immigration, people should understand that everything depends upon case to case. Each case is different.
Mhm.
So that's amazing, and thank you so much for making us understand. Instead of assuming, it's better to be on the facts and get to know what the actually things are. And I think let me go ahead with my next question, that can you burst the myth that a green card is actually the final step in the immigration journey, or is there more?
Yeah, there's more. Obviously, it's getting citizenship, right? The green card is a very important step, and you can live in the United States forever without getting to that next step. But is that the final step? No, it's the citizenship is your final step. And I always recommend most people, again, based on their own circumstances, to go and get that citizenship. Why do I say that? Because even if you have a green card, you can still get deported. You can still be forced to leave this country. It is not the safety net you think it is, as we are seeing today with this administration. So,
Yeah.
do you want to create a safety net for you and your family? The best option is whenever you're eligible, file that US citizenship and become a US citizen. That's going to protect you in the future.
Absolutely. And I think that was really a great point, Nandini, that, my next question was about to be that if somebody has a green card, then what are the chances of deportation? Because people think, they assume that they have a green card, so it's impossible for deportation. But I
No,
think that's
that's that's not true at all. Actually, you can get deported. You are not a citizen of the country. You are a citizen of another country, and you are just getting permission to live here legally and to be able to work without having to have a visa of some kind. That's what the green card gives you. You're not allowed to vote, right? So the government, has the ability to say, if they don't like you because, let's say, you committed a certain felony or certain crimes or certain situations like that, they can then have the legal authority to deport you. If you're
yeah.
watching the news today, you're going to see people who have valid green cards. They've been here for years and years, but maybe they were an activist, and maybe they were, got arrested for something like that, and you are seeing these individuals getting deported or being put into detention. So
Mhm.
no, green card does not give you full protection to not be deported. You have to always still mind the laws of this country. You have to still follow, the conditions of the green card.
Yeah.
There are people who think, oh, well, I got the green card. Now I'm going to go live in India, you
Mhm.
know, because I have this safety thing. No, it doesn't work like that. There's conditions to that. You can only leave for a certain amount of time. If you want to come back, you have to have a certain type of permit to come back in. And if you don't have those, your green card is gone.
True.
So again, it's important to know that the green card is not the final step here. Go for that citizenship. And if you become a US citizen and you want to go back to India, you want to go back to China, you want to go back to Europe, wherever, you will still be able to come back into the United States, unlike a green card holder. You could be gone for 20 years, you could still come
Mhm.
back. So, yes, green card holders can be deported from the United States. It does not give you the protection you think it does.
All right. Thank you so much, Nandini, for explaining us about that. And friends, till now we have covered few questions. And in case if you still have any queries or anything regarding the topic, then please go ahead. You still have time. Put them on the comment section, and we will definitely take them up. Till then, also if you haven't subscribed to Immigration Talk Show, make sure you do it right now. Okay, Nandini, now this next question is again a very interesting one. And this is, most of our friends also says that best and the easy way to get a green card is to marry a US citizen. So
Mm.
what is actually the reality behind it? Like, is it true that marrying a US citizen truly makes sure that he has green card, they'll get without any delay or without any denial? What's the reality behind it?
Okay, first of all, there's no guarantees in any application, right? So that's a myth. That's a myth right there. There's no guarantees. Every application stands on its own merits and its own facts.
Mhm.
Is marrying a US citizen one of the safer and fastest methods of getting that green card? Yes. That is an absolute truth. That is. But when I say it's not a guarantee, it also depends on the facts of this case. For example, I have practiced enough where I have seen people get married for just getting the green card. They were not really relationships. It was, individuals who are making a deal with each other for payment and getting the green card. I have seen also issues when people, especially in our culture, they have arranged marriages, right? Because then those, even though that's a cultural norm in our culture, it is
Yeah.
not the cultural norm here. So those type of applications will have a difficult, not impossible burden to overcome, to show that this is not about just getting the green card. This is a valid relationship. They are involved, they want to live their life together. So again, everything runs on facts, and
Mhm.
everybody's case is a little different. But if somebody asks me, hey, what's my fastest way to get a green card? And this is not a, again, uh, saying it to tell everybody go jump and marry a US citizen. I'm just going to tell you on the processing and on the facts. Yeah, that's your fastest way to get the green card. Absolutely.
All right, absolutely. That's very well put up. That is the fastest and the easiest way. Not easiest, but at least better than the other ways. But it's also not the reason, that anyone who doesn't have a real relationship can go ahead and get married. And
Mhm.
also, Nandini, one news I'm remembering that right now, these marriage based green card interviews are also being stricter. I mean, the questions will be asked a little specific with the couples, right? Earlier, it used to be some documents and, I mean, little lenient way, but now it's going to be a very tough way. So if you can also let us know something about, interviews, like what questions
Yeah.
officials can ask, then that will be very good.
Yeah. So let me first of all say that when I look at these type of cases, the first couple of things I look at is the ethnicity of the two individuals. And it sounds silly, but what I look at is an Indian person marrying another Indian person, okay? Or is it a American person, let's say white, marrying an Indian person? The
Mhm.
reason those things are looked at by me is because the officer looks at that, because generally they understand that Indians generally, again, it's not all the case, it's, and it's less and less, marry other Indians. So when they marry outside of their ethnicity, that opens up a red flag in their mind. Like, oh, okay, right? So how did you guys meet? So now the officer is going to say these type of questions. So how long did you date? And remember, it may be against our cultural norms to be dating, like, here, but that's what they're looking at, right? Oh,
Yeah.
so you're different. Okay. All right. Did all your family members were at the wedding? That's one of the questions that people don't realize. You are not just going to City Hall and getting married, and that's the end of that. They're going to question that, because also culturally, Indians have big celebrations and family members come and things like that. So they look at that. They look at the pictures,
True.
and stuff. So they'll ask about those type of questions. They will like look at your Facebook. People ask, oh, do they actually look at social media? 100%. I always ask for social media snapshots, because generally most people tag their husbands or spouses or girlfriends and things, like they post pictures. So these are definitely things that people need to be very aware of, that the officer will look at and ask these type of questions to you. But the history of the relationship is the main thing that they'll ask you, is how did you meet, when did you meet, why did you decide to get married, who was at the wedding, how, various questions like that will be asked at every single interview that I've ever been to. So they should be ready for that.
All right. Okay. I am sure our viewers are keeping a note of all the pointers that Attorney Nandini Nair is explaining. And let me go ahead with my next question, Nandini. And this is about, do green cards expire? And does expiry means that someone has lost their permanent residency?
Right. And this is a myth. This is definitely a myth. And let me break down the reality. Yes, green cards, the actual physical card generally has a 10-year expiration unless you got a 2-year green card. Okay. Yes. And there is an expiration date on that.
Okay.
But it does not void your permanent residency. It does not void your green card status just because the card expired. That is actually a big myth that people seem to have. Like, oh, my card expired. How am I going to, work, or how am I going to do this? No, you got that green card status is attached to your body. That card is just a evidence to show that, hey, I have this status. It doesn't, so if that expires, it does not take that away from you. Now, of course, I always tell people never let it expire. Try to renew it if it happens and stuff like that. But I have clients that, it expired 10 years ago and I have to get a new card for them. Don't have to refile the application for them. I just have to get them a new card. So people should be very much aware, if the card expires, don't freak out. It does not mean that your green card status has expired. It just means the card expired.
Okay. And also, Nandini, talking about, is there any limitation regarding renewing the green card?
No, there's no limitation, as long as you can do it before, like 90 days before. You can do it a couple of years after if it expires. Again, you're going to do fingerprints, obviously. So every time somebody does renew something or put in an application, I always make sure that clients understand this, and I check their backgrounds every time I'm doing an application. If from the time you got the green card to the time you're going to file a renewal application, something has happened in your background, that's going to be a flag, even on the basic renewal. You're like, hey, is this person doing something wrong? Right? And remember, you're going to get fingerprinted, right? So if you had a criminal issues and things like that, you are going to might have some problems here. So that should be asked. And even when you naturalize, okay, when you go and apply for citizenship, they're going to go back through that history and stuff because you're going to do fingerprints.
Yeah.
So all of these things can, cause the pullback of that status. But just because the card expired and you have not, that's all that happened. No, you could just go and get it renewed and stuff.
True. All right. Okay. And let me also say hi to our viewers because Ricky is here, Ranjit is here, Jadav is here. So, hi, guys, and thank you so much for your questions. Okay, let me go ahead and take up Ricky's comment here. So, Ricky is saying that if I'm not the founder but a core member of the startup helping technically as well as in raising funds and bringing in new projects, can that be used in EB1A application?
He's not the founder, but he has helped to develop, and I assume what he's saying is grow the company. Can he apply for an EB1A? Under extraordinary ability, is he talking about, I assume? Again, every application, listen, works on its own merit. This is another myth that I deal with so much in this green card application, where we have individuals who believe that based on certain things that they have in their background is sufficient enough for them to get that green card, whether it is a multinational manager, whether it's the EB1, extraordinary ability. They don't understand that each application is a case, like a trial, right? Like you got to put up your evidence as to show that, hey, I am this, this, and this. And just because you have evidence one doesn't mean you got it. If the requirements are 8, let's say, you not having 5 is a problem. And even that 3 that you seem to have, if they're weak in their quality, in their content, okay, so you have some publications. You published in like some little paper, with the team. Oh, but I was publicized, no, that doesn't work. If you're a doctor and you were published in the New England Journal of Medicine, that one thing might be enough to help in that criteria. So everybody has to understand that having a few little dots here does not make the whole application, and it does not make a successful application. That's why you really have to talk to a lawyer, have that lawyer walk through your background and say, okay, I think we have a shot here. And I'm very honest and to a fault in that, because I'm not here to waste anybody's money. And I always tell them, listen, this is a weak application. We can take a shot, but I'm going to tell you right now, this is weak. I have 25 years of experience doing this. I can read it immediately when I see it, like, this is not going to work and stuff. Or, hey, this is not a bad place. Let's go. Let's take that shot. I can pull it together for you and stuff. So when people who are founders or people who are not founders, it doesn't mean about that. It's, again, where's the rest of the criteria? What else you got to show the officer, So again, to Ricky, if it is, Ricky, talk to a lawyer, on the background, see if that can work for you. Do a consultation with somebody, don't sit in your own mind thinking this will work or not work. Get some expert advice here.
That's right. And Ricky, why don't you go ahead and get in touch with attorney Nandini Nair, because she has lots of experience, and with 2 expert advice, she is going to give it to you. So please go ahead, visit the link that is on the screen, and you'll get the contact details of her. Reach out to her and share your query or your doubt regarding whatever problem you're facing, and she would love to help you out. Okay, and with that, Ricky, if you haven't subscribed to Immigration Talk Show yet, then please do it right now. And let me go ahead with Supriya's question. So Supriya is saying that I have heard so many things online about how long the green card process takes. Like some say it's just a few months, others say it can take years. What's the actual timeline I should expect? Yes, Nandini.
That is a $1 million question. Okay, so Supriya, it's all of that. That's the funny part. It can take a few months, and can take a few years. years, it can take a few decades and stuff. It actually really depends on a lot of different things. One is your country of birth, not country of citizenship. And as you're probably hearing, yeah, it'll take years and years. Unfortunately, for nationals from India, China, Mexico, Philippines, okay, the backlog is tremendous.
Yeah.
Even though they have the same exact qualifications from somebody from Australia, and they're following the same exact path, whether it's an employer-based filing or something like that, their route and their timeline is going to be different than yours, simply because of your country of birth. So, that's one important factor. Second important factor is, how is the green card being filed? Like we talked about marriage to a US citizen, right? Obviously, that's the faster route. But employment based, there's different kind of categories. Some categories are faster, some categories are less. But again, you have to look at where the person is from, the category that they're going to file, and it can move back and forth. An Australian person who's an EB1 can get their green card, I'd say like a year, less than a year, maybe even, But in EB1 India, same exact qualifications, we're backlogged like 4 years now.
Oh my God.
So EB2, Australian person,
Yeah.
can get it probably in 2-3 years, just because the situation is difficult right now with the perm process. An Indian individual starting in 2025, they're looking at 30 years.
Oh my God.
Exact same person, right? So again, that's why it's there's not a right or wrong answer, and that's why you're confused, Supriya, because it can go from months for some individuals to decades for others.
That's right. That's a bit of truth, I'll say. And there's a follow up. Okay, she's saying, Supriya, that does it really depend on where I'm from or the type of application? Exactly. That's what Nandini you have shared. And Supriya, I hope that you got your answer. It was really a very interesting question, $1 million question. And in case if you still have any follow up, then please go ahead and put them on the comment section. We will let you know more about the topic. Okay, Ranjit is here. So, hi, Ranjit, and let's see what he is asking. He's saying that I'm a bit confused about the whole priority dates thing I keep hearing about. Can you explain how priority dates work and why sometimes they move so slowly or even seem stuck? Okay, another interesting question.
Yeah, wow, Ranjit, you're asking a good question. Okay, so very simply, okay, the US government has said we will allow a certain bucket or certain amount, quota of green cards into the country every single year. Okay, there was laws passed, the Congress agreed, they said, okay, ABC. So to think of it like they said 100 green cards can be issued every single year. But then they said, listen, we don't want one country to dominate those 100 open slots. So we are going to put in a second hurdle and say only 7% of that 100 can go to one country at a time. Okay. And within that 7%, you have to break it down between the different categories you have. EB1, EB2, EB3, EB5. No, EB5 has a separate category, but like those categories. So think 100, 7% of 100, and then breaking it down between those categories. Okay. So that's important to understand how there is a tiny amount of green cards that are actually being issued for an Indian national, a Chinese national, a Mexican national, a Filipino national, because you're capped at that 7%. So then the 7% also includes spouses and kids. So you got a family of 4, they just took 4 green cards right there and then. Okay. What's the priority date? The priority date is the place in the queue, because right, we have a queue here now, right? So how do you get a priority date? Your priority date is based on certain type of applications. It may be the perm application that you filed. When that's filed, that sets your priority date. Okay. When you can skip that and you go to the I-140 because based on the certain category. When you file the I-140, that sets your priority date. And that's the date you're looking in that visa bulletin, say, India, I'm an EB2. Oh, here we are. That's where I am. And why does it move slowly and even stuck? Because of that 7% issue. India has an oversubscribed population, meaning that there are thousands more applications than the available spots every single year. That creates the queue and that creates the backlog. And the reason it gets stuck is because the families are taking these green cards. It's not based just on the principal person filing. It is also they count how many family members there are. And we don't know how many family members there are, or CIS, until the 485 application is filed and approved. That's why the data is never accurate.
Wow. So much to process. And that was beautifully explained, Nandini, explaining everything from scratch. Really great. And I'm sure, Ranjit, you have got a proper understanding of the topic. And in case, if you still have any follow up or want to know more, then please let us know and we will take that up. Okay, Ricky is here with another question. And Ricky is asking that can you give some tips on expediting EB1A application based upon senior role in advancing a startup?
Again, I think every case stands on its own merits, and it's impossible for me to just give you a like 1, 2, 3, do this and stuff like that. Everything has to look, I have to look at the case. I would have to look at the background. I would have to look to see what are the criteria. And like I explained before, individuals sometimes have this idea that, hey, I met 1 or 2 of the criterias, so I should be qualified, and sometimes I get people saying to me as the lawyer, like, well, can you help me with 3, 4, and 5? No, I can't. Like, I can help you organize it. I can help you frame it correctly. I can help you present it well and stuff, but I can't do 3, 4, and 5 for you. So I would say, Ricky, if you're looking for tips on this, again, I don't think any lawyer, really a good lawyer, would be able to kind of on this kind of format be able to give you that advice. I think it's an individual conversation that you must have with a lawyer where they review your background, and then they possibly can give you a better understanding of where things can work or not work for you. So I really just recommend that to you.
All right. And I think, Ricky, you can directly go ahead and, get in touch with the Tony Nandini Nair. You just have to visit this link and you'll get the contact details of her. So go ahead, reach out to her and give her a proper detail about your status so that she can, advise you in a better way. Okay. And with that, let me take up Jadav's question. So, hi, Jadav, and thank you so much for your comment. He's asking that I'm a graduate with 20 years of experience, married, and have 1 year kid. If I want to apply for a green card, then what strategies should I follow? And what are the chances that we will get the green card and when?
Okay, Jadav, I'm assuming you're here in the US on a visa. Otherwise, you wouldn't be asking this question. Again, what's okay? So there's two, you're already married. So a family based, the fastest route is not going to work for you, right? You're already married. So, generally people will say marriage to a US citizen is the fastest way. But since you're already married, that's not going to work. So family based option is not going to work for you here unless again you have parents who are US citizens and they're able to sponsor you as an immediate relative. That's going to speed up the process and stuff in certain ways. Not as fast as you being a minor child, but some option is there. Other than that, it's employment based, right? Which is where you have to have an employer sponsor you for a green card. And if you are Indian and if you're going through the traditional route, unfortunately, I don't have great news for you. It is going to take years and years to get to that final step of the green card. But if you start, the sooner you start and have that conversation with the employer, the better for you. Unless you are like, I'm just going to keep it working for 6 years here. Or if you're on an H, for example, 7 or 5, if you're on an L, and I'm going to go back home and that's all it is, that's fine. But most people, especially when they have kids, they're desperate to have that green card, right? Because they want the kids to be able to have an education in the U.S. and go through. They don't want to pull them out from here. So, but I would say, Jada, you have to talk to your employer if you are working here in the U.S. on a visa, and that's probably your only real option. Obviously, there's the EB-5 option, also investing money and stuff like that. But even for Indian nationals, that's a backlog of like what 4 or 5 years now. But obviously, much better than doing the traditional perm process and stuff. But there's a lot of money and capital you have to put up, and just different things like that. And people sometimes don't just have that option. So, but talk to your employer if you're wanting to go the traditional way.
All right. So, Jadav, I hope you got your advice and you will make a note of it. And here's a follow up question from Jadav Nandini, that is it true that hiring an attorney can speed up the green card process, or does USCIS treat your case the same whether you have a lawyer or not? Okay, what do you have to say on this?
Listen, you don't need a lawyer to file anything. Really, you don't. Okay, I'm not going to say you do. However, what is the purpose of having a lawyer? The purpose of having a lawyer, and obviously an experienced lawyer, is that they understand the system. They understand the agency. They understand what you need to present to get a successful outcome. That's the reason you go to a lawyer. It's the same way you go to a doctor, right? Like, or a nutritionist. Is it that, or to a trainer in a gym, right? I think we all know how to go to a gym and do something, but why do we use a trainer? Because they give you the expertise and knowledge to get you the result that you're seeking. Same concept with a lawyer, right? I'm going to put that application in a way that I know CIS wants to see it. You don't know it because you don't file those things. I know it, right? And that's what you're getting from me. My knowledge, my experience, my strategy, my know-how, my inside information that I might have, things like that. That's the purpose of hiring an attorney. Otherwise, yeah, go for it. If you think you can do it yourself, go for it. Not a problem.
Absolutely, and that's very well put up. I love the example, Nandini, that you have put. But I think keeping in mind the terms and conditions. Right now, the immigration policies are changing day by day. It's better advisable to have an attorney and get an expert advice, because everything is changing and so many new rules and policies are coming day by day. So, Jadav, I think it will be a little safe option for you to get in touch with attorney Nandini Nair, because that is the way that will be easier and fastest way for you also to get your green card. Okay, okay, Ranjit is here and he's saying thanks Nandini for explaining it in simple words. That's so sweet. Let me go ahead with Gigi, and Gigi is saying that my son just turned 21 in May. Should I wait a while for him to petition for me, or is it okay to file now? I came in with a visitor visa and has been here for 25 years.
There's no waiting period once he becomes 21. But here's the issue. How's he going to support you? So when a petitioner files for a green card for a family member, they have to financially support that person, or you have to get a co-sponsorer. So when someone is 21, are they working? Are they still in school? How will they be able to prove that they can financially support you until you become a US citizen, which we're looking at, years from now?
Yeah.
So it's not just your son turning 21. Look at the other requirements for that green card application. It's not just the relationship, it's the financial ability to support that applicant that also is important. But you can also get a co-sponsor and things like that. Some people are very resistant to that because now, especially with the Trump administration, they are definitely looking at some of those things and saying to people, the co-sponsors, are you still supporting this individual? Are you going to support this individual? So people might be a little nervous about doing that. So, but you have to kind of put that into perspective about the financial part of it.
Okay, all right. So, thank you so much, Nandini, for taking up these questions. And now we would also like to move ahead with Facebook questions, because we do have lots of viewer over there. So, Control, if you can please share your screen and you know, please make us aware about the Facebook questions. Okay, so this is pretty long, but let me go ahead. This is a question we got from our viewer, and who is saying that my post completion OPT ends on June 2, 2025, and I'm planning to apply for the STEM OPT extension with the requested dates of June 3, 2025 to June 2, 2027. But my college DSO sent I-20 with post completion and date as 1st April 2026 and STEM OPT start date 2nd April 2026 and end date is 1st April 2028. So I'm applying to USCIS for STEM EAD with this I-20, but dates are not matching. The DSO informed reason for this as the cap gap extension has been automatically added to your service record, which in your specific case results in an updated end date of April 1st, 2026. Therefore, the service system forces us to issue the STEM OPT recommendation dates based on that date, this resulting in your STEM extension showing on your I-20 as April 2nd, 2026 to April 1st, 2028.
Mm.
Your I-20 is correct. If your STEM OPT is authorized, USCIS should issue your EAD card based on your correct STEM OPT authorization period, which in your case will be June 3rd, 2025 to June 2nd, 2027. So, will USCIS accept my STEM EAD application with I-20 shared by DSO, which have different dates? Yes, Nandini.
Okay, so this is a little confusing to me because he's talking about the cap gap extension. So that's issued generally when somebody has been selected in the H-1B. So I'm not sure if this individual, if that's what's going on and that's why the dates are off here. But do I think they'll accept it? I think, yes, I do agree with the DSO, what they're saying. And so I think you should not have an issue applying with this I-20 with the different dates. And if anything, they might kick it back and you might get it, like an RFE and your DSO will provide a letter and you should be able to get that through pretty easily and stuff. So I'm not super concerned about that. Based on these things, like I said, the cap gap is throwing me off a little bit, but the other stuff, yeah, I'm not super concerned about it.
All right. Let's move ahead then with the next question. I think we can't see the next question. Control, can you please change the next question? Um, I think there are some internet issues that we can't see the next one. But that's okay. I think let me go ahead with another question that I have with me, Nandini. And till the time we can, continue with the Facebook questions.
Yep.
Okay, so this is another myth, Nandini, that most of the people say. Many people believe that having a US born child automatically gives them a green card. So I would like to know, like, how accurate is that?
No, that's not accurate. It's not an automatic process. Like we were just talking with Gigi, right? When your child turns, if they were, born in the United States, and a lot of people's kids are born in the US, right? They're here on visas. They have kids here, and the kid turns 21, then the kid can sponsor the parents. Yes, that is all true. But again, it's an application. As we talk about, nothing is a guarantee, right? Everything has to stand on its own merits. Everything has to be decided by USCIS. And just because your child is a US citizen does not translate into you. It does not transmit to you. They have to get to 21, then they have to put in an application, then that application has to get approved. That's the process of getting the green card through your child.
Absolutely. And many people think, just by having a child, they're going to get the green card. But no, that's not the thing. And Nandini, I think we have a Facebook question here. So this is, I have been sent my passport along with a 221G form, asked me to come. Along with passport and this blue 221G form, have not asked any documents, then what it means.
So if they've asked you to come for an interview, that means they have some questions. They don't need the documents because either they have documents from your application that's sufficient, but they have some extra questions they want to ask you. I see this all the time, that there's not additional documents that are being asked. My response to you to prepare for this is have your documents still with you. Whatever you are going to present, and even if they haven't asked for it, still bring it with you in the event that the officer asks for something or you some clarification. So don't walk in there without all of that information. But is it like common not to get any document requests? Yes. But they're there to interview you. Yeah.
Okay, that's great. And there's another question, Nandini, and it is that do I need to submit my new I-94 to USCIS after my return, since after travel I-94 gets updated?
I'm not sure what that means, but what I'm assuming is in the olden days, before I-94 was automated or electronic, we used to get a card, right? When we used to enter, and that card was attached to a page in our passports. And the law was that when you were leaving the United States, you are supposed to hand that back over to the airport officials who are looking at these things so that they can then manually go in and enter this information in the system. And if you didn't, then it could cause some problems and stuff like that. Your record isn't clean. You don't have to do any of those things right now. Your I-94 is linked to your passport. So when the passport is scanned upon your, departing the U.S. or returning back to the U.S., it automatically gets updated on the CBP website. So there's nothing you personally have to do at this point.
Okay, okay. And let's move ahead with our next question. Okay, this is from Gopal, and Gopal is asking that family based adjustment status filed on November 29, 2024. So biometric is done. When can we expect the green card? Yes, Nandini.
I mean, what do you mean by family based, right? There's very different processing times generally, right? Is it marriage to a U.S. citizen? Is it parent of U.S. citizen? There's just different things. But generally, let's say you're here, you filed an adjustment of status. That means that you filed a 485, you filed it about November 29th. So let's say December 1, generally, it's only been 7 months. You are looking probably at least, if it's an immediate relative position, I'd say at least towards the end of the year. I'm not seeing that any earlier than that at this point. And remember, there's interviews now. So local offices, processing times are different. If you're filing in Iowa, where there's not that many applications or something like that, the interview schedule is much better. If you're trying to file in New Jersey, when there's so many applications, there's hardly any spots at this point. So it all, like I said, everything depends on the facts of each individual situation. I know everybody wants like a B, C, and it fit to everybody's profile. It just kind of unfortunately doesn't work that way. You can get high level information, but keep in mind that everybody's case is different.
That's so true. That's so true. And thank you so much, Nandini, for explaining everything in a great way with amazing examples. I personally really enjoy having shows with you, and I hope you also do with me. But that was really amazing, and I'm really looking forward to another session. And friends, let me tell you that Nandini is a little busy today, so we have to take a leave 15 minutes before. But you can also get in touch with Attorney Nandini Nair in case if you are still having any questions. Go ahead, get in touch with her. You'll get the contact details, and she's going to help you out. Thank you, Nandini.
Thank you for having me, Sam. I appreciate it.
Thank you. All right, friends, with that, that's the end of this webinar. And thank you so much for joining us. Don't forget to like, share, and subscribe to our channel. Our handle is at Immigration Talk Show. And also follow us on LinkedIn, Facebook, X, and on Instagram as well. Until now, it was really great having Attorney Nandini Nair here, and we have understood so many things about green card process. So thank you so much, everyone, for joining us. I'm Sam, and keep watching Immigration Talk Show.
Hello, everyone, and welcome back to Immigration Talk Show. I'm Napasa, and I'm going to be your host for this session that's lined up. And before we head on with today's amazing webinar, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And friends, like I said, today we have another very amazing session lined up, and we are going to speak about, everything that's making a buzz right now, especially with regard to student visas here in the US. And to help us, dive deeper into this topic today, we are going to be joined by attorney Isadora Velasquez, and we're going to be speaking about what's changing here with the student visas and how could it affect the foreign students. And by the way, our guest is from ISA Law, yes, based out of Miami, United States. So yes, if you talk about ISA Law, they combine expertise in business and family immigration law. And we are going to be very, very excited today because we have Isadora Velasquez joining us all the way from Miami. Hi, Isa, how are you? Good to see you.
Good to see you again. Very happy to be here because this topic is hot and changing every day. So I'm glad to discuss it.
Yes, so true. Every day is so interesting, especially when you talk about US immigration law, right? So
Correct.
you have been busy, I'm sure. Tell us about it. What's going on with ISA law?
Well, we do a lot of detention work. So for better or worse, we have been very busy. We do a lot of court cases. So we are here in Miami and all over the United States. So yeah, it's been a very busy couple of days, but very fulfilling because we have been able to maneuver many changes. So I'm hoping I can explain all of them to you guys and your audience so that we can be ready for things that may be coming our way and we're not caught off guard when they show up because there will be new changes, not only from a local level, but also from the Supreme Court and especially for students. So it's good to be prepared for what may happen soon.
So true, so true. And thank you so much today for making time to be here. And I'm very excited because we have some very amazing questions from my end. And I'm sure that folks out there, who are also watching us from different corners of the world are going to be happy to join us with their questions as well. And let me tell you, folks, that you can comment wherever you're watching. We are live right now on YouTube, but you can also check us out on LinkedIn, Facebook, X, on Instagram as well. And please feel free to drop in your questions. We are going to take them a little later in this webinar that's happening today with none other than Isadora, attorney Isadora from ISA Law. So check us out. And another very exciting thing is that you can join us on call. And the number is displayed above on the screen. The number is 425-436-6335, and the access code is 988-888. So feel free to join us. And Isa, I'm excited. So I think without further ado, let's just go into the questions if that's all right with you.
Of course.
All right. So I've got this first question that's coming up, and that is, was the US State Department's global pause on student visa interviews something that you anticipated, or does it feel like a sudden move?
Well, it felt a little bit sudden, I think, for all of us. And the reason was because we were actually caught off guard when we started seeing the detention of residents for voicing their opinions. We know that anyone who is not a citizen could have been detained, and the privilege of being in the U.S. can always be taken away. But doing so for specifically having a different opinion than the government is something that we had not seen at such a high level before. So the pausing of specifically the student visas for the particular reasons that the government was advocating definitely caught us off guard. At the same time, we was something that we thought was going to be redirected only to a specific organization, in this particular case to Harvard University. And we found it interesting when the government decided to pause it for all institutions altogether. Interestingly, though, the fact that it was originally directed solely to Harvard has been the green light, because the deep lawsuits that originally started with Harvard have now opened the door for us to assume that these visas will soon resume, meaning Harvard has been very successful, and as soon as yesterday, the Department of State has announced that they will be resuming the visas for Harvard in particular. So that leads us to believe that visas for all students will soon be resuming very soon. So I'm hoping that this is only temporary. So the same way we were caught off guard, thinking this is only going to be for one institution, and it ended up being for everyone. Now this one institution will hopefully open the doors for all of us to start seeing the student visas up again. So don't despair. I really am hopeful that the Department of State will soon give new directives on student visas to start interviewing again.
Absolutely. Even I feel so also, because even recently, we had a couple of hundred, people, students who had their visas revocated, but then, they were all active again. So I'm so excited. I mean, so happy that that happened for them. And I really hope that it works the same way even for the others as well. So,
Yeah, it just emphasized how we must be on the constant lookout for the news. I know that, especially as students, we are busy studying, of course, that's why we came here. But now, with immigration in particular, when we have this temporary status, we have to constantly pay attention to the news, because what we've seen is, of course, the student visa for new visas in particular were affected, they were put on pause. But now we have the added layer of a travel ban. So although we expect that we will see new student visas come up and that we will see the interviews come up thanks to the lawsuits from Harvard and the Department of State, please remain cautious for the 12 countries that are now part of the travel ban, because that has now come to effect. And unless there's new litigation in particular from those 12 countries, we have to remain on the lookout for the news to see if those particular countries will have the student visas. For so far, the answer is no for those 12 countries in particular.
right. Thank you so much, Isadora, for that, helpful explanation, I would say. And I would like to also greet our folks who have joined us. Ricky, hi, Ricky. Thank you so much for joining us here on YouTube. He says hello, by the way. And stay with us. We are going to take up your comments and questions in a little while. So be with us, Ricky. And also, Isa, the pause, which is being linked to the national security and enhanced social media screening. I mean, nobody thought that social media would be screened at this level. I mean, we've been in social media for, more than a decade or 2 decades, and it's been very, very involving, I would say, and didn't know that it's going to turn up against us someday like this. But how should we understand this shift from an immigration law perspective?
Well, if you didn't think it was going to be this screened this heavily, obviously it goes back to my point before on how we need to pay attention to the news, because this is not a surprise for anyone who's been looking at the news. And so, it's not just for the immigrant community. U.S. citizens are now seeing the very intense scrutiny of social media, particularly at the airport, to the point that when we come in as U.S. citizens, we have to relinquish our electronics. We are now being advised that when we travel to do so with our electronics in airplane mode, because technically even us as US citizens have to, when we're questioned by agents, unless we have specific entries such as global entry, we could be questioned by agents, and we don't even have the luxury of letting them or simply rejecting the answering of questions when it comes to social media, or not giving them our appliances or electronic devices or phones or cell phones or even our computers. So having them in airplane mode is the only way to avoid answering these questions when it comes to social media. I give the advice of putting them in airplane mode, but that won't help the immigrant who's seeking a visa, because of course they will scrutinize very heavily your social media handles, what you have posted, and what you may have deleted. And that's only going to continue, because imagine if you're doing so very heavily for US citizens when you're coming in through the airport, they're going to do so even more to anyone seeking a visa, not just student visas, any visa at all, including tourist visas that we've seen maybe in some countries in particular may be easier to get. Now social media is highly scrutinized. Also remember what's going on inside the US, the whole internal turmoil, the division, so and even division inside our own government and sadly politics that has seeped into how visas are being processed. Sadly, the advice that we immigration attorneys are now giving our clients is that although freedom of speech is basically how the U.S. has been built when it comes to acquire immigration benefits, it has to be limited. If you wish to seek any visa, from tourist visa to student visa, even work visas, freedom of speech is something that sadly will be used against you. And that is something that is in the discretion of the Department of State when processing any visas. So you must be very careful with what you may have posted, even if it's your own country's internal turmoil. Understand that the government, in their own discretion, I mean here the US government, may review it and even hold it against you. So we have been at least I have been instructing my clients to be very cautious with what they post, even if their web pages are private. Because understand that your page might be private and you may have a friend whose page is not, and they decide to share something, the government may have access to it. We have lately seen some interviews, although attorneys don't accompany their clients to interviews at the consulate level, they do accompany their clients here inside the US at their interview. And we have seen the government show pictures of what they may have posted in their social media, even when their pages are private. So you may think, oh, my page is private, they won't have access to it, and you will be surprised what the federal government can find. So although I encourage people to be vocal and protest if they want to, be careful if you're looking for a visa and try to balance out what's more important, what's your need. If your need is to come and work in the US or come and study in the US, or to voice your opinion, understanding that sadly, under this political climate, it will be used against you. That's just the way things are being processed right now. There is very active litigation, both in the deportation level, that is very notorious. You may see it in the news. There are people who are right now undergoing deportation removal proceedings who are residents right now facing possible deportation consequences solely for voicing their opinions, not just in social media, but also in protest. And that's being used against people seeking visas. So it's only going to continue until litigation has some impact on how we regulate social media. Because it's in the beginning stages, as Nifasa just mentioned, we have to be very careful. So if you're seeking a visa, my advice, like I said to all my clients, is balance it out. And if you can be quiet, that is sadly the best way to go at this moment. Because if you want the visa, anything you post can and will be used against you.
Well, that leads me to my next question. I mean, what about, free speech and fair immigration policy, stuff like that? I mean, if you look at Secretary Rubio, who hinted, there's that potential visa denials, tied to activism and public criticism. So, how does that sit with US principles of free speech and even fair immigration policy?
So that's the balancing act. So what we've done is I admit I have some clients who understand that because of their jobs, their studies, they have chosen to delete their pages and they have simply chosen to take, we may say, the easier route and simply keep their visas and not risk it. Others, I admit I have some very brave clients who have chosen to fight their deportation and they understand that they may be facing originally in the introduction, Ipasa briefly mentioned some visa revocations that we saw, student visas in particular. Some of them were revoked for very trivial reasons, arrests that were dismissed. Some of them were revoked for very serious reasons, maybe posts that didn't disagree with our government's current values. And we went to court and we sued. Interestingly, the government reinstated these visas, so the lawsuit later became moot. But those people were doing it to state, basically for the same reasons, to send a message, the importance and the value of the free speech or the U.S. First Amendment that is so strong. And in a way, some people will argue that made this country what it is today. So it's more of a balancing act. I admit I have some clients who are a bit hungry to express their opinions and they want to go to court and they're not afraid to fight it. Others are a bit more hesitant because they understand they have a job and schooling and they don't want to risk the visa. That's why it's more of a balancing act of each person's values. Also, I'm not going to minimize that it's not cheap to go to court here. The United States is a very litigious country, but at the same time, it's not a country in which going to court is cost effective. It can be very expensive to have attorneys, and the government is aware of this. That's why they know that going to court, face deportations, they don't give you an attorney. It's not like criminal court where you have an attorney assigned to you to represent you. Because they know that, they also understand that people who may be detained can afford an attorney. So I mean, immigration attorneys have been trying to pair up with nonprofits, but we're also a bit overwhelmed at this point. There's many detentions going on. So it's once again, balancing act of each person's values, what they can contribute, and what they're willing to endure. Is your boss willing to put up with you missing some time of work because you may be having issues with your visa? Is your school right now? Most schools are in summer break, so it is maybe a good time to be facing litigation. So it is the balancing act of what we can face and what we can afford, and where can we find people to represent us. But there are some organizations, depending on the state, who are fighting back. Right now, if anyone's following the news, LA is very notorious for being very active and vocal, and that is one of the issues they're fighting, the lack of freedom of speech for people who may be seeking visas to come to the US and don't have access anymore to that social media aspect that has been so essential in a way to communicate. So hopefully people will keep fighting, but as a balancing act, if you want to come to the US, my advice still remains, be careful what you post because it will be used against you.
Exactly. And that brings me this funny thought that, we used to have notebooks. So I'd say maybe start writing them on your notebooks rather than just posting them on social media, or maybe tell it to your best friend, but not on social media. Right, Isa?
Yes, and don't send it on a text message because remember, they may take your phone and read that message. And if you have that notebook with you, maybe put it in your suitcase or don't carry it in your carry-on because they may go through your bag.
There you go. Thank you so much, Isadora, for that. And yes, I do have more questions, but I think we should take a couple of them from our audience as well, not keep them waiting too much. So, folks out there, I hope you are, enjoying this session and you're resonating with this discussion. So please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show, and check us out. We are on YouTube, LinkedIn, Facebook, X, and also on Instagram. And of course, if you have or you want to contact attorney Isadora Velasquez, for a one-on-one consultation, please visit this link, which is displayed on the screen. Now let's take up Ricky's question. My NIW I-140 petition was filed by employer. NIW I-140 petition processing time for the Nebraska Center is 16.5 months as per USCIS website. Can you give some idea on the typical processing time that you are seeing for the I-140 petition? Also,
Ricky,
can premium processing increase chances of RFE for NIW I-140 approval?
Ricky, if you look on the website, and first of all, thank you. I saw that you were here very early, so I highly appreciate it. But if you look on the website in the top corner, it will say that this is the processing time for 80% of cases. And what we've noticed is they're fairly accurate. So on average, it's around 15 months. 16 tends to be on the high end, but yeah, around 15 months. As to the premium processing, personally, I am a fan of premium processing. Not all my colleagues agree. I have actually seen the opposite. If you do a really good job and you pay for premium processing, not only do you get a quick answer, so you have that weight off your shoulder because in less than a month, 15 days, if you have the need for an RFE, the reality is that I always warn my clients, most of the time you may get an RFE because they want to buy the time to get additional 87 days to give you a response. But in reality, who cares? If your case is good enough and you know you have the information, you know you have the evidence, you're still going to shorten your time significantly from 15 months to 87 months, because once you send the evidence in response to the RFE, they have to respond again in 15 days. So I encourage premium processing. I know it's pricey, but I think it's a good idea. I think it's worth it. I also personally think it increases your chances of an approval. I think immigration has seen, they take you seriously when you're willing to invest in premium processing. So it may increase the chances of an RFE because the government wants to buy time to process your case, but I still think it's worth it. So that would be my advice if you're willing to do it. Then again, if you're in that category in which you're not going to get it right away and you're not in a hurry, you may want to save that money. So it's balancing on getting the response right away and getting the weight off your shoulder, or how costly it could be.
Right, right. Thank you so much, Isadora, for that, helpful explanation, and I'm sure that it will be very, very, very helpful for Ricky. So all the best, Ricky. And now let's go on to Minakshi Sood's question. As a foreign student, I'm concerned about my visa status. Could these changes affect my ability to stay in the US if I already have a student visa, or will they only apply to new applicants?
Great question. So there's two changes to keep in mind. One has to do with people who are applying for a new student visa. Those are the people who are seeing that they're not getting appointments. So if you already have your student visa, congratulations. You don't have to worry about having to get that appointment, which is so difficult, almost impossible to find at this point. The other big change is the travel ban. If you already have your student visa and you're out of the country, come back quickly. Understand that there's a list of 12 countries that are part of the travel ban. They gave us a very small cushion to come back. And the reason is because if you are part of this list and you're not back, you're not going to be allowed in, even if you have a visa. So to answer your question, the travel ban does affect people who already have visas available. Even if you have a student visa, if you leave your country, you will not be allowed in. So keep that in mind, that changes affect individuals who have visas. Travel bans affect individuals who have visas, basically making these visas void if you decide to leave. So the visas remain valid if you're in the US, but they will not allow you back in if you choose to leave. That's the big distinction. Now, if you already have a visa, you don't have to worry about an interview. That's where you don't, the student visa becomes a great asset. You don't have to worry about that interview that no one can find out, and hopefully you will be able to get them soon again.
For sure, for sure. Thank you so much, Isadora, for taking up this question for Minakshi. Now let's take up Imran's question as well. And hi, Robinson, thank you for joining us. Imran, thank you as well for joining us, and let us take your question. I've been considering going for a part time job during my studies, but with the visa changes, I'm worried that it might cause problems with my status. So, are there specific rules I need to follow for an on campus and off campus employment now?
So far, there haven't been any changes as to on or off campus jobs that will affect your visa, but the main rules are that you need to ask your school for permission. For example, Venezuela is a particular country that, based on a memorandum, they are allowed to work. But to do so, to get that particular work permit, they are encouraged to go to their school, the school that issued their student visas, and let them know that they need employment. The memorandum, and for Venezuela in particular, points out that the country is in dire need, and because of the need, the U.S. government assumes that everyone who has a student visa from Venezuela also has a need to work. So if you are somebody who needs to work, it is advised, and this is for anyone who has a student visa, to go to your school, to the admissions department, let them know that you need to work. They'll evaluate your circumstances. This is called work study. It is allowed under the student visa. Once again, it has not been announced that this will change, if there are any circumstances. Just let them know you need to work, and they will work with you. Most of the cases, they allow for work study inside on campus. I encourage it. If you need it, go get it. Once again, no announcements that it will affect in the future. But as I mentioned before at the beginning of the show, right now, although we might be busy working and studying, it is important to follow immigration news, because no announcements that this will change, but we never know. So it's important to follow if this may change in the future. But if you need to work, go to your admissions department, let them know, and they'll work with you to see if they can offer most likely employment inside on campus and on the campus. And if not available, they'll look for something, at least help you or assist in trying to see if you have something off campus that may even be related to the field that you're studying. So it's good to ask your school first. That's the first step, and it's essential.
Absolutely. Thank you so much. I'm sure that that'll be very helpful for Imran. Thank you, Isadora, once again. And friends out there, to keep yourself updated, since it's very important, especially that, every day there is a new update with regard to US immigration policies. So do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. We do come up with, the latest updates as soon as we have them. And of course, if you want to have a one-on-one consultation, or maybe get some help with your visa process, do contact attorney Isadora Valquez and visit this link which is displayed on the screen. So thank you again. Now let's go on to Robinson's question. He's saying, I'm a foreign student currently pursuing a master's degree in the US and F1 visa. The new rule proposes to limit the duration of stay for F1 visas to a fixed period of 2 or 4 years, depending on the country of origin. How would this change, affect my ability to complete my degree, and what steps can I take to ensure I can remain in the US to finish my studies?
So I'll tell you how we've been addressing this. The U.S. Is notorious for having students who are actually full-time students and are whose career, whose job is to be a student, meaning that they're master students who take much longer than 2 years to graduate. We have applied for these students to extend their visas locally. It will be an extension of your status. So that would be how I would answer your question. How would you change your ability? Instead of having the typical maybe leave and to go through consular process or having to renew your visa the same way you have maybe applied to extend your visa before inside the US, that's how you would apply to extend your visa inside. I know it may sound contradictory, they're limiting your F1, but if you're able to show that your master's degree is not done, there's they have been allowing your extension, just showing how many credits you have left. Interestingly, I don't know if many of you recall, I assume you're all rather young, the student visa typically used to be a visa that had an I attached to it. An I to mean indefinite, meaning you would renew it until you were done with studies. These new regulations that limit the time, we attorneys have been able to fight against them using their own American techniques, meaning how long Americans may take to finish degrees. Most Americans don't take 2 years to finish master's degrees. So that would be your reasoning to either extend your visa if you are not done with your master's degree. So you can apply, like I said, to the form is the I-539. You can file it inside the US through your school, obviously, to get a new form I-20 to show how many credits you have pending to extend. You could do consular process, but personally, I would encourage you to do an extension of your status. We've noticed that has been easier because through consular process, because of the rule, in consular process, they tend to be a bit more, we will call it stickler for the rules. So it's easier to do the extension of your status. USCIS, the administrative department here in the United States, is more understanding of the American way of taking a little bit longer than 2 years to finish your master's degree.
That is very interesting. So, I mean, plus different countries have different timelines, right? I mean,
Correct. Americans like to study for a long time, I guess.
well, well, I mean, if I may ask, with visa law, how many student visas you're dealing with right now, visa?
Well, I'm going to tell you a little secret with visa law. When it comes to student visas, we especially encourage our students to go directly to the school and to process the visa with the school. We only process the visas with the students if the schools are having issues for whatever reason. For example, when a few months ago they were having issues with their revocations, that's when we got really hands-on and fought for our students. But otherwise, because the schools have to work so closely with the students, we tell our students, go with the school, save that money, and use us when you really need us.
Okay. That's interesting to know. And thank you again. Ricky, thank you for your questions. Please stay with us. We will take them up very, very soon. But now let's move on with some of my questions as well. And I wanted to ask you, what's the immediate impact of this policy on Indian students who are aiming for fall 2025 intake? The denials or the free speech and fair immigration policy we spoke about some time back.
I'm sorry, I got this. I was reading Ricky's question and I got distracted. You mean the with the impact that we've seen? Oh, well, the impact that we've seen in the schools, and I know because the same way I encouraged my students to apply to the schools is because I work closely with the schools to make sure that they apply correctly. And what we've seen is schools very concerned about not only the lack of diversity, which was already a problem at the beginning of the administration because they were pushing against getting rid of some diversity policies that the prior administration had implemented. But now it's even worse because the schools are actually actively not receiving the visas that they expected from other countries. So they're seeing a lack of diversity in the schools. As Nifasa mentioned in the beginning, introducing me, I am located in Miami, which, as you can imagine, is a very diverse area. But my law school is located in Pennsylvania, not a very diverse area, particularly Carlisle, Pennsylvania. My law school has severely complained that they relied on student visas to meet their quota of what they understand as a diverse school, and they haven't been able to meet it. So that has been the impact, at least in the schools, of not having the visas processed. In addition, right now we're in the summer break. Schools rely on income from international students, and they don't know if they're going to have that income starting August when the schools start. So they are worried about, for example, a notorious school, well, not notorious in a negative way, but a fairly large and famous school here in Miami, Florida International University, the name says it. They are concerned about not having those international students that make their school so famous beginning August, because many of the visas for the freshman year have not been processed, and they don't know if they will be processed in time. The Harvard list for Harvard in particular was announced yesterday, June 9th. June 9th, and yesterday was June 10th. We don't know if the visas that are processed just for Harvard, if it's going to be enough time for schools like Florida International University to meet their quota, just to fill their freshman class. So University of Miami, Florida International University are worried, yet we attorneys worry that the only school that has been fairly vocal about not meeting the quota or just enough students has been Harvard. We know the schools don't have enough international students lined up because there are simply no visas being issued, but no one is speaking up in terms of lawsuits besides Harvard. Possibly because they're afraid of losing funding from the government. The government has taken away $2.6 billion from Harvard just because of this issue. So maybe that's why schools haven't spoken up, but at the same time, they are losing a lot of money by not having the students lined up. So I think once they do the final numbers and they see how much money they're losing by not having international students and how much money would they lose if they make the government angry, we may see more lawsuits. And that's when we'll really know the answer to your question as to how are students being affected and how are the schools truly being affected. But right now, we're a bit in the dark.
Oh, goodness me, those are huge numbers. And even if we look at, the students' perspective, they are afraid that they'll be having gap years or gap months. And, fall 2025 is very, very soon. And they're even worried about spring 2026. So, what about that?
Well, the schools are worried about lawsuits to them because many students have already paid for the semester ahead. So they're worried that if the students can't get the visas that they were promised, because like I said, when you had asked me how many visas are firm process, I warn you that we send our students directly to the schools to process their visas. So these students already paid the school the tuition, they paid the room and board, and now they're being warned they might not get their visas. They're definitely going to be suing some schools. Schools like the University of Miami cost $40,000. So these are going to be many lawsuits that the schools may be facing, and we wonder who are they going to sue back, if it's going to be the federal government or are they going to be rush jobs to get the visas going once the appointment starts. Because attorneys like myself, tourist visas are taking a year to process. So attorneys like myself were encouraging people to get student visas if they wanted to come to the US quicker. And now that plan may backfire. So it's going to be interesting couple of months.
Yes, every day is interesting, especially with US immigration. So, friends, do not forget to subscribe because we come up with the latest updates that you don't want to miss out on. So, ring that bell and subscribe to our channel at Immigration Talk Show. And also, friends, I'm sure that if you are navigating a US visa, you may need some help and you may need consultation. So, why not go visit attorney Isadora Velasquez and check her information in the link which is displayed on the screen. So thank you again, Isadora. I'm having a great time. I hope you are as well. Are you ready for more questions?
I enjoy it always. Of course.
Okay,
of
so
course.
are there any proactive steps that universities or students can take, to minimize this disruption caused by these delays?
Yes. So the proactive step, one of them we hinted to before, when we were talking about people who already had the student visa and if it would affect them. One of them is people who have tourist visas, and they said, okay, I was waiting for my student visa. Now this appointment is gone. What should I do? If you have any other visa to come to the US, we've been encouraging our clients to come here using that visa. If you have a tourist visa, which is the most common one, use it to enter the US. I must distinguish a tourist visa from ESTA, or what we also call visa waiver. Those visas are typically tied to European countries, and that's because a tourist visa, I can apply for a change of status. I can change your status from a tourist visa to a student visa while you're already in the US. So if there's no appointments in the consular process, you can still come to the US with your tourist visa, and I can change your status to a student and you can go to school. Or if you come under your H4 category for your parents' visa or whatever, another visa, I can change your category. But if you come under ESTA, or what, as I mentioned, the visa waiver, that is the one of the few visa categories that cannot be changed. You cannot change your status from that to a student visa. So before you enter, make sure you speak with an attorney and find out if your visa status can be changed. But explore that. If you have a visa, try to come to the US and we'll change your status to a student visa so you can study. So if you can't find an appointment abroad, we can change your status here in the US while you're already here.
There you go. Thank you so much, Isadora, for taking that up as well. And now I have another question, and that is, for students who have already paid tuition or, secured their housing, what is the option that, they have if their visa plans are now very uncertain?
So when NEPA sent me this question, I actually reached out to the schools that I work with and I asked them, what are you guys doing? And that's how I found out that many of them are worried about lawsuits that may come up. They have mentioned that some students have actually started in the process of suing them if they're not offering refunds. Some of these schools have already started giving them contingency plans, such as potential refunds if they're not able to make it. But in time when the school starts, they do hope that during the summer break, they will resume with these interviews and people will be able to make it in time for when the school resumes. The third option that the schools have mentioned they will be offering is putting your position on hold so that if you're not able to start for this semester, which will begin in August, September, maybe you can start by the next for spring. So it's advisable that if you've already put your deposit, contact the school. And of course, if the school is unreasonable, I emphasized before, the U.S. is very litigious. This is the type of lawsuit that because private schools in particular, which are the ones that tend to issue these visas, are pricey, attorneys are working on what they call a contingency fee, meaning that they are not charging hourly, and hourly fees can be very pricey. So if your school is being unreasonable and not working with you, not trying to give your money back or hold your spot, be aware that there are attorneys that are definitely willing to work with you to take action with the school. But most schools, I've noticed from my research and preparing for this today, are definitely willing to work with you because they understand it's the Department of State not cooperating with this. And that's why I think this is going to be very short-lived, the same way the revocation of the student visas at the moment was short-lived, because the schools did speak up. They were not suing as much as we would have liked, but they were privately putting some pressure in the government, letting them know we're losing money and affecting our economy. So hold tight. I think this is going to be brief, but I'll keep you guys posted as to what may happen. But contact your school right now to make sure you're protected.
It's very important to stay in touch with your school, the DSO, and especially because you're an immigrant here, and to be informed is your power. So friends, do not miss out on any information, and make sure that you have subscribed to the news that bring you the latest updates, and of course to our channel as well, because we bring the latest updates on US immigration as well. Our handle is at Immigration Talk Show. Do not forget to subscribe and ring that bell. So, Isa, we should take up some more questions, and we do have from Ricky now. Ricky, let's take up. He says thanks already, by the way. And our WhatsApp calls also subject to social media scrutiny during visa appointments and USCIS petitions reviews. And our WhatsApp conversations or calls also subject to social media scrutiny for visas and petition. Well, I am one of the core members of the startup helping technically was as well as in raising funds and bringing in new projects. Can you suggest ways to use this to build profile for EB1 petition? Well, Ricky has a lot to say first off, but yeah, never go ahead.
I like your project, Ricky. So first, WhatsApp. Yes, definitely they can be used. Now, calls are difficult because you're calling and that's supposed to be encrypted, so they're not supposed to know. But if you're calling somebody who they can see is somebody they might not like, yeah, they will know. WhatsApp is a tool they can use against you. So my advice is when it comes to going to the interview, delete WhatsApp. Don't have it. Same thing coming to the airport. Don't have it available. Have it on airplane. The truth is, the government knows that you may have WhatsApp. I am one that I am not a fan of WhatsApp, but that's because I am Hispanic, as you may be able to tell. And in the Hispanic community, we love WhatsApp and we abuse it. So my friends use it so much that I just delete it because it's used way too much. So maybe you can get away with that excuse that I just don't use it because it's too annoying and I like to be unplugged. But if not, be aware that they might find it a bit suspicious if you don't have it. But they can go through it. They can use it against you. So just be careful. I'm not saying delete every message. WhatsApp is a little bit easier to control than other media like Facebook or Instagram, in which we think we delete things and they show up in the future. WhatsApp is, when they say it's encrypted, it's encrypted. That's why we see a lot of criticism on the government not being able to access it. So you do have a little bit more privacy when it comes to WhatsApp, but just make sure whatever you don't want them to see is not there to be seen. But yes, it could be technically used against you. As to my tips for EB1, my biggest tip when it comes to how to build it up to be successful is if you're gonna go the EB1 route, EB1 is for the big boss. So be the big boss. You can't be hands-on as much as you would like to be to really go the EB1 route. If you're gonna be one hands-on, you may want to consider EB2, which is more of artists. Or I mean, if you're EB1, maybe work on your talent or emphasize how many awards you have won. EB2 is more national interest or more of a petition. So, but EB1 is either be back off and let the firm run itself, the startup run itself. But if you're a core member and you're very hands-on, they might say you're more of an employee. If you're a core member and you're hands-on, focus more on how many awards have you won? How many awards has the company won? How many of them are tied to you? How much money do you make? Either become a very special, above and beyond individual, or become very hands-off, big boss, so that they say he is the CEO. CEOs don't answer the phone. They don't meet with clients. They delegate. Or if you're extraordinary talent, you are extraordinary talent. You're the GOAT. You're messy. You win everything. So that balancing is very important for the EB1 category. Otherwise, you may want to consider other categories. But for raising funds, it's very important to see how big the project is and how much you can bring to it without being too hands-on, depending on what you're doing. I know it's a very complicated explanation, but it's really the best I'm trying to help you here. If you want, it's complicated. Make sure you have an attorney guiding your
Yes,
hand,
I think yes. I
please.
would always suggest that, no matter what visa you are dealing with or are, the process that you are going through, it's always best, to get some important advice from the experts out there who are immigration attorneys like you. And friends, if you need a consultation or some advice, do not forget to also visit this link which is displayed on the screen and scrolling below, and go visit yes, this link to get to know more about ESA law and attorney Isadora Velasquez. So we do have more questions, Isa, and I think we should just take them up. So control, let's go. Yes, with this first one is from John Wick. Can anyone help me with a situation? I have submitted my DS 160 in 16th of April and paid for my MVR fee and booked appointment on 2nd May. Today I noticed that I submitted the DS in different country. US Embassy portal. What should I do now? Can anyone help me with this? It's very urgent.
Email them. There should be an email, and if not, you need to contact an attorney because we do have an email. And that's how you let them know, I submitted this in the wrong portal, and they'll fix it for you. As an attorney, we have access to an email that we use to fix mistakes. Of course, we're all human. If you don't have an attorney, now is the time in which you hire an attorney. But email is the way to fix mistakes like this. You basically email them and let them know this mistake happened, and they will fix it for you. But that is at least the way we handle these things, which happen to us all the time in our office. You must email them, contact them right away, let them know. Because you're right, it is very urgent. Email them.
Thank you. Thank you, Isa, for taking that up. This is John. I hope that you are resonating with all these answers and discussion we are having today. And folks out there, do not forget to subscribe to our channel. Our handle is at Immigration Talk Show, and also ring that bell so that whenever we have discussions like these, you're notified and you can join us with your questions. And Ricky, since you have been commenting, I would just say, folks out there, we also have a number for you to dial in. So why not just call us on this number? The number is 425-436-6335, and the access code is 988888. Join us. So this next question now is from an anonymous member, and saying, hi, did anyone change their visa from F2 to F1 without leaving USA? And how much time is it taking nowadays?
Yes, you can change from F2 to F1. As to how much time, go to your school, because it will really depend on when your school starts. For example, here in Miami, we have language schools that work by trimester instead of by the semester, and they may be starting in a couple of weeks because they may be summer schools. So when they are working with you, they may be able to change your status from F2 to F1 within a couple of weeks, because they need you to start fairly soon in July instead of waiting until August. So find a school that is suitable for you, and that way you can apply for your change of status. That's the form. That's exactly what you're applying for. So yes, you can change your visa from F2 to F1 without leaving the U.S. I highly encourage it. Right now, it is being done right now. It's not being done at the moment are the actual consular processing, the appointments at the consulate level. Do so and find the school to understand how much time it may take, because that will vary depending on the school that you choose. Because like I said, the school is the backbone. They need the I-20. They need all those CVIS forms that they have to process for you. Without the school, you can't get it done. The school will determine how much time it will take.
That's interesting. And thank you so much for the detailed explanation, Attorney Isadora. So now let's go on to this next one. This is from another anonymous member asking, on submitting my DS-160, I got following message. An unexpected error has occurred while processing your previous request. The error has been reported to the site administrator. No further action is required. To retrieve your DS-160 application, please enter your application ID. Has anyone encountered something like this? If so, how did it get resolved? Do you know anything about this?
It's normal. It happens. The system falls regularly. Of course, we attorneys know, because we like to submit applications late at night, at midnight, when systems crash. It's normal. As long as you can access the DS-160 application, which I encourage you to, because it's always good to always have applications that you submit to make sure all applications you always submit to the government remain the same with the same consistent information. Make sure you have it. So as long as you can access, it was properly submitted, you should be okay. There's nothing to resolve, as the system said, because it was properly submitted. They're just simply letting you know that maybe it was not sent immediately because they were doing some maintenance or whatever it may be. That's why it was an error message. But the application was properly sent as long as you can access it. That's how you resolve it. If you can access it, you did it correctly. If you can't access it, that's where before I said email it, you would try to troubleshoot it. Either email them and let them know I can't access it, or try to file it again. But if you are able to access it, you did it correctly, and it was just an internal error due to maintenance, because like I mentioned, we've been through it. It has happened before. But if you can access it, you're fine.
I'm sure. And thank you so much, Isa, for taking that up. Let's go on to our next question. And this is saying, hi, has anyone on STEM OPT tried to renew their F1 in the last few months or recently? Please share.
So STEM OPT is having some issues, and it's not just STEM OPT, it's OPT in general. Technically, you should be able to renew your F1 because it's still available, but the government, you know, how before we were discussing work study and whether there has been any announcement or any issues with work study. And the truth is there have not been any issues with work study, and I encourage people who need to work study to go to their schools and request it. OPT, though, which is different, is when we're done with our school and we want to take some time to actually practice what we studied. OPT has been under the administration's watchful eye, and it might be on the shopping block. We don't know yet, but it has been discussed as something that might be eliminated. And because of that, we have seen some, not issues, but delays with the transferring of OPT back to F1 status. I still encourage my clients to apply the same way I encourage the person who formerly asked before about F2 to F1. So if you're an OPT, definitely go to your school and mention that you want to go back to school and you would like to apply for your F1. The school will work with you because you should be allowed to apply and change your status from OPT or to extend your status from OPT, which is an F1, to another F1 visa. But be aware that it may take a little bit longer simply because of the conversations that the Department of State and Homeland Security have been having here in the U.S. about possibly eliminating OPT. But it has not been done yet. It just may take a little bit longer to change from OPT back to F1.
Yes, there is a lot of changes going on. And friends, I think it's always best to consult with an expert, an immigration attorney. Whichever visa process you are dealing with right now, whatever your status may be. So why not visit this link, which is displayed on the screen, and you can get the details for attorney Isadora Velasquez and also the contact details for her as well. So also do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out, and let's go on with our next question now. This is from another anonymous participant asking, "Hi everyone, I'm applying for an F1 visa to pursue my master's degree at a public university. All my documents are ready, but honestly, I'm feeling a bit nervous about the interview. I was previously refused a B1, B2 tourist visa, and I'm worried that it might affect my F1 application. If anyone has tips or advice on how to prepare or what to expect during the interview, I would really appreciate it. Thanks so much in advance."
It would be best if you know why your tourist visa was rejected. But the reality is that when our tourist visa is rejected, we don't know. They don't always tell us. But if you know, you may be able to prepare accordingly. If you know that maybe it was an overstay, or maybe because you have family here, or maybe you didn't have enough money in your bank account. Typically, the reasons a visa may be rejected are those. So if you know you don't have enough money in your bank account, you can go ready now to your interview for a student visa, knowing that you need to show you have enough assets, or you need to show that you have enough ties to your original home country, showing that you're not going to stay illegally in the U.S. Understand that those are the main things they're looking for. They want to know that you won't stay in the U.S. illegally, that you will not be working without permission, that you have enough money to support yourself, because the student visa is very limited and that it may not allow you to work. So if you go with those factors in mind, knowing I have enough money to support myself, I have enough ties to my country, my parents are still here, I'm leaving my car, I'm leaving my fully furnished apartment, I'm leaving all my friends and family, and emphasize that during your interview, you maybe have a successful interview, and distinguish that maybe when you had your tourist visa, you were younger, you didn't have that much money, you didn't have a stable job back then. How are you different now than you were back when you had your tourist visa? If you distinguish those two individuals, you may have a better shot during this new interview.
Thank you so much. Thank you so much, Isadora, for taking that up. And, I see more questions, so I don't want to leave them as well. So let's take this one. I would like to know if other people on F1 visa have traveled outside the US and re entered without any issues. I'm planning to travel to my home country for a month, and I'm unsure if I might face any problems when returning. My country is not in the list of banned or restricted countries.
So it depends. What we've noticed is some countries have complained on treatment. For example, Colombia has complained that they are treated differently coming back to the US. I recently had to travel for work to London, and I didn't see any specific treatment, but it depends. What I have noticed is sudden news, like Nipasa was saying. The travel ban happened rather suddenly. Although we heard some rumors, We were surprised by some of the countries that were included. We were surprised by some of the countries that were not included. We were expecting countries like China to be included, and it was not mentioned. So my point is, you always have to be on the lookout. To answer your question is, if your country is not included in the travel ban, sadly, you still have to be very cautious on what is announced and follow U.S. news. If you have a visa and you're going to have to come back. Now we see that at least we'll have a cushion of a couple of days if there is an announcement of a potential travel ban, so to come back quickly if you have to come back for work. I do worry that things like tourism may be affected when you return, but I haven't seen, besides that, specific countries being targeted or treated differently upon their return. There are some countries that I would encourage people not to visit, even if they have a visa and they're not part of the travel ban. For example, any other countries in the travel ban, even if we have family or we want to visit, I would advise my clients and you guys not to go, at least not for now, until things settle down or we get better guidance as to what the courts may do. And when you're coming in, just follow the news. Sadly, we have to follow the news to make sure that the government's not taking any action on any place we may be returning. Besides that, so far, the U.S. is good, but that's for the moment.
Thank you so much, Isadora, for taking that up as well. And I don't want to leave Girish or RK without answers, so let's quickly take them up. Girish, hi, thank you so much for joining us here on YouTube. And he's saying prior 5 months of H4 visa overstays and unauthorized work on H4 EAD. Departed US, if employer apply for new H1 or I1 or L1 visa, will be approved. Any waiver are there?
So the 5 month overstay is not really that big of a problem because it's typically when you hit the 6 months that the 3-year ban kicks in. The problem is the unauthorized work. The unauthorized work, there's not really that much of a waiver because the waiver typically requires what we call a qualifying relative, which would be somebody in the U.S. that needs you. So the unauthorized work is the biggest deal here, particularly for the H1 visa, because the H1 visa is more of an employee visa, so that may be difficult. The L1 visa might be a little bit easier to get because the L1 is more for the boss of the company, the leader of the company, or the employee who's very specialized. So there's more of a specific need. So if your employer can choose between the H visa and the L visa, I would encourage your employer to pick the L visa. As to the waiver itself, it's like when you break a vase, you don't go to your mom right away and you tell them, oh, I broke this. You wait for your mom to find out, and then you're like, oh, and then you say you're sorry. So I would apply for the L visa, and then when the government tells you, no, you're not going to get it because of whatever reason, then you seek a waiver. That's how I encourage my clients to apply, because applying with a waiver ahead of time is like admitting, oh, I made this mistake. Be aware that the 5 months, like I said, typically wouldn't be an issue, although overstaying is never encouraged. Don't do it. But it wouldn't be an issue. It's more the unauthorized work. You have to be honest in the application, so please don't lie. But wait until they ask for the waiver. And once again, if you can choose, pick the L visa instead of the H visa, because the L visa is more likely to be better suited for you, that you can justify that you need this waiver, because typically waivers require that qualifying relative, which is very difficult to justify under an H visa if you don't have one. So go for the L and good luck. It's going to be tough, honestly.
Thank you so much for taking that up for Girish. Girish, I hope that you've got your answer, and if you have any more, keep commenting. Well, now we have RK. He's saying there's a talk of removing OPT. What is the chance of that happening, Isa?
It depends. I honestly think that it will be up to the schools to be very vocal and emphasize how OPT is needed. I feel that talk about removing OPT has to do a little bit with the falling out between Trump and Elon Musk, because Elon Musk was very helpful in emphasizing how OPT was needed for students to practice what they have learned, and how we could keep in the U.S. great talent by having OPT. So now I believe it's up to the schools to emphasize how OPT is great for the United States to keep that talent. So I'm hoping that schools, the same way Harvard was very vocal in letting the country know how international students are essential for the U.S. to remain as great as it wants to be, if we follow the narrative saying, by the way, it's not just when they're studying, it's also when they're practicing their trade. If we can follow the narrative, we can keep OPT. I would ask you selfishly if you can help us promote, spread the word. I don't think we realize, we see students and we don't realize that there is a time in which they're working and how essential they become for the economy, for what we do, and then we lose them and we only see when we lose them. So if we can help spread the word of how great they are when we have the students here so that we can keep them, maybe we can keep it. But right now, I am very worried that it could happen because the Secretary Rubio in the Department of State has been pushing for it. And I believe it's partly based on this falling out in relationships that has not been the best at spreading the word. So that's why I'm asking you to help me spread the word that we need international students, not just as students, but also as employees.
For sure. For sure. And, we've always known America to be a land of immigrants where we are all living together, and working together. So
Yeah.
let's see what happens. But a lot is happening, friends. And to keep yourself updated is the key. So do not forget to, subscribe to our channel. And, before we leave, Isadora, I would really ask, what's your guidance to students and families, currently who are stuck in limbo? So should they wait out, or defer, or look at alternative countries?
Well, for students, it depends where you are. For my clients who are stuck in limbo in the U.S. right now physically is not the best place to be stuck in limbo because of the high level of detentions that are happening. For example, when the visas were being revoked and we didn't know what was going to happen, I admit that I was encouraging my clients to go to Canada, to return home. And it's something that I never thought I would be fighting, but I was generally worried about the high level of detentions we were seeing. Also because the detentions were tied with transferring people and they were not humane conditions. So that's where, if you people are in limbo in the US, I encourage them to leave. But if you're in limbo in other countries, I do encourage them to continue considering the US because I do think litigation is the only way we can stop this ongoing changes that are not really fair. For example, the OPT elimination is something that for students who already have their student visas, they were expecting to have that hands-on experience. It's part of the packet of going to school, paying for the tuition, and now the possibility that you may graduate and not be able to work at where you may have been applying, that should be frustrating. So I have encouraged those students to not give up and to consider litigating, and maybe consider fighting it, to not just be complacent, because I know that may be a limbo, but it's a limbo that I think we can fight legally without the fear of persecution or detention, which I think is the biggest concern right now. So it really does depend on the limbo. For my individuals who were part of the travel ban, I basically called everyone in the 12 countries, asked them to come back to the US, depending on the visa. If it was a tourist visa, I basically we're now litigating. We filed lawsuits against the government. I keep emphasizing how expensive the government is because the litigation and attorneys are. Because like Ricky asked when to get an attorney involved, when to have a G28 representation. Honestly, from the beginning, because what we've seen now is a perfect storm of people who maybe before, during the prior administration, filed using notarios, paralegals, maybe with the best intention, but now that things are a little bit more complicated, it's difficult to fight, or maybe because you didn't keep your DS-160. That's why I previously mentioned make sure everything is the same. The government's finding little loopholes to attack you more. So on complicated cases like EB-1, like we were discussing before, it's good to have an attorney from the beginning. On simple matters, like personally, I find student visas to be best done by the school directly. Those are cases in which it's best to just simply have your documentation in order and choose to pick your battles and litigate them. That's why I give the example of OPT, in which being in limbo, depending on where you're located, if the limbo is simply not knowing whether you're going to continue or not, or if they're going to give you the visa or not, give you the program or not, it's good to litigate it. So it's good to look where you are, what options you have available and see if you have that trusty attorney next to you that's willing to take the case to court. Because you could be the example that everyone looks up to if you keep the visa alive for everyone to enjoy. So think about it. I'm here to help.
For sure, Isa. I mean, that was wonderful. What a good thought, and thank you for sharing that with us as well, folks out there. I'm sure you really resonated with this conversation we had, and you must be taking away good information with you and have learned quite something from this session we had today with attorney Isadora Velasquez. So do not forget to check her out as well. This link is displayed on the screen. You can check out contact details if you need a one-on-one consultation as well with her. And also, thank you so much, each one of you, for joining us with your questions, for viewing. And if you have shared, thank you so much. And also, please feel free to keep sharing our content with your friends and folks who would benefit most. So, yes, our handle is at Immigration Talk Show. Subscribe now and ring that bell. So, thank you, Isa. It was really wonderful to have you here. I know if we especially talk about student visa, we can go on, but sometimes sticking to what we have thought we'll discuss. And I'm sure, if there'll be more updates, we would love to have you back to discuss further on this as well.
Whenever you want.
Thank
Happy
you.
to be
Thank
here.
you once again. Have a wonderful day.
You too.
Thank you, everyone, for joining us. And yes, if you do have more questions or want to reach out to me as well, I have a phone number. My number is 408-335-6444. That is also my WhatsApp number. So you can just send us your questions, and maybe that way I could also send it to Attorney Isadora. And you can also email me. My email is nipa@staffingme.com. And once again, please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. And stay tuned on Immigration Talk Show, because we do have a lot more coming in that you don't want to miss out on. It's Nepasa saying bye for now.